before the Court of Appeal. Before the Court of Appeal, IBC filed 12 grounds of appeal challenging the High Court's findings, contending that the court had, by finding there was no quorum to undertake the constitutional and statutory mandates. It is also challenged the decision that the court misapprehended the provisions of Article 257(4), which did not require the IBC to verify whether there was public participation before the verification exercise. In the High Court, this appeal was challenged. The Court of Appeal had the appeal and also the cross appeal by the Kenya Union of Nurses and also by OP 254 and the cross appeal by Mr. Morara Omoke. In determining those appeals, the court framed 21 issues which were determined by the conclusions and findings that were pronounced in the Reed judgment by Musinga J. Those findings are there. I need not read them. And before us now, the Attorney General, the IBC, and the third appellant were dissatisfied, and therefore they found these appeals, which were consolidated before us, and we were able to frame 7 issues for our determinations. We also directed parties to file written submissions, which were done, and we have summarized all those submissions in our own judgment. I do not wish to read what each party said in the argument to support the appeal. The appeals were also opposed by the respondents, and we have captured all the submissions in opposition in the judgment. There were parties also who supported the Attorney General and the IBC's appeal. That is the 13th and the 15th respondents. We have captured what they said. The National Secretariat and the Honorable Raila Amolo Odinga. The appeal was also supported by the President, and we have captured what was submitted before us by Council in our long judgment. The 19th respondent, Isaac Arwoche, appeared in person, relying on his submissions, which we have also highlighted in our own judgment. The 72nd respondent, Pirista Wakesho, we have also captured what was said in the submissions. We have highlighted the specific parties who opposed the appeals. Mr. Morara Omoke opposed the appeal, supporting the decision of the High Court. The first, second, third, fourth, and fifth respondents represented by Mr. Nelson Harvey and Ms. Esther Angawa also opposed the appeal and relied on their written submissions and made oral submissions, which we have captured in our own judgment. The 7th, 8th, and 9th respondents are represented by Mr. Elias Mutuma, appearing with Ms. Gerono for the 7th to the 8th respondents, also relied on their joint submissions and made oral highlights, which we have captured in great detail in this judgment. The 11th and 12th respondents, represented by Learned Counsel Mr. Elisha Ongoya and Evans Oganda, made submissions in opposition to the appeal. So was Mohori, represented by Ms. Caroline Kituku, made extensive submissions on the issue of the verification of signatures by IEBC and also the quorum of IEBC. We have captured that. The 79th respondent, Kituo Sasheria, represented by Learned Counsel Dr. Kaminwa, also made extensive submissions, and we also have considered the briefs by the Hamisi, Professor Rosalind Dixon, and Professor David E. Randau, the first and second Hamisi. We have also considered Gautam Bhatia, the third Hamisi, and what he told us in his written submissions on the application of the basic structure. Professor Migai Akich, the fourth amicus, also submitted his Hamisi brief, which we have summarized on the issues that they raised. Professor Richard Albert, the fifth Hamisi, we have captured his submissions regarding the issue of the basic structure doctrine. And Professor Yaniv Rosnai, the sixth amicus curiae. Professor Charles Manga Forband, Professor Dr. Adem Abebe, Dr. Duncan Ojuang, John Osogo, and Dr. Rinda Musumba also filed a very extensive Hamisi brief with Dr. Jack Mwimari. The Kenya Human Rights Commission also made some extensive submissions on the basic structure doctrine. I have considered all those submissions for and against the appeal, and as observed, the appeals are predicated on Article 163, 4A of the Constitution, which clothes this court with jurisdiction to determine appeals from the Court of Appeal on question of interpretation and application of the Constitution. Although the length and breadth of the pleadings and arguments are summarized, I've touched on several chapters of the Constitution. The common denominator is that they are focused on the interpretation and application of Chapter 16 of the Constitution and how that is to be done. The two superior courts below have traversed and touched all the key provisions of the Constitution. In my view, therefore, this court's jurisdiction is properly seized under that provision of the Constitution. And having set out the issues framed by the court for determination, the 7 issues, I will now proceed to deal with them sequentially. On the basic structure, it is pertinent in the circumstances to point out that the basic structure doctrine, as articulated in the High Court and endorsed by the majority judgment of the Court of Appeal, the sum total of the two decisions being that beyond the three stipulated pathways for amending the Constitution provided in Chapter 16, there are certain fundamental features in the 18 chapters of the Constitution that are not amendable without first determining on a case-by-case basis whether a proposed amendment forms part of the basic structure. Further, that any amendment to these particular articles identified as fundamental features of the Constitution would follow a four-sequential process, being civic education, public participation, and collection of views, constituent assembly debates, and a referendum. In effect, the two superior courts below concluded that certain provisions of the Constitution are beyond the reach of enumerated amendment powers stipulated in Chapter 16 of the Constitution. The history of the emergence and evolution of the basic structure doctrine was comprehensively covered in the very detailed judgments of the two courts below. Therefore, I will merely mention some of the key features to place my findings in perspective. The basic structure doctrine first received judicial recognition in 1973 in the Kesavananda case, a decision of the Supreme Court of India. The case concerned a challenge to the state government of Kerala's attempt under two land reform acts to allow state government to acquire privately held land to fulfill its socio-economic obligations. Subsequently, the Indian Parliament passed the 24th, 25th, and 29th amendments to the Indian Constitution, which in one way or the other shielded Kerala State's land reform acts from being challenged in court. It is in this context that the Supreme Court of India addressed the question of whether there were limits to Parliament's power to amend the Constitution. In a majority judgment of 7 judges with the 6 judges dissenting, the Supreme Court of India held that the 24th, 25th, and 29th Constitutional Amendment Acts passed by Parliament, exercising its powers under Article 368 of the Constitution of India, were unconstitutional to the extent that they damaged the basic structure of the Constitution. The doctrine places substantive limits on the amendment power by placing the basic features of the Constitution beyond the legislative's power to amend the Constitution. In effect, the Supreme Court of India endorsed the idea that a constitutional amendment can be unconstitutional on substantive grounds. I have recited or restated the provisions of Article 368 of the Indian Constitution, and from that provision, it is clear from its reading that the amendment process under the Constitution of India is exclusively vested in the legislature. This therefore means the amendment process of India's Constitution can be described as falling under the flexible model of amendment powers in the flexible regime dichotomy used to categorize the nature of amendment powers in a given constitution. And for this preposition, I have also read the books by Zachary Ekins and Richard Albert on making, breaking, and changing the constitutions. Subsequently, the basic structure doctrine and the idea of limits of power to amend a constitution have been considered by courts in several jurisdictions across the world and received mixed reception. For example, the basic structure doctrine and its various variants have been accepted in Bangladesh, Belize, Colombia, Taiwan, Malaysia, Slovakia, and Peru. While courts in France, Georgia, South Africa, Singapore, Zambia, Uganda, and Tanzania have rejected the doctrine. What this state of play demonstrates, which has been recognized by some of the distinguished scholars as reflected in the various materials cited before us, is that the basic structure doctrine has not yet matured into a universal norm of constitutionalism. And for that, I have referred to the writings by Richard Albert, Maukas, Makize, and Therese O'Kay. Given that the basic structure doctrine has not matured into universal norm of constitutionalism or a doctrine of general application, courts have adopted the approach of evaluating its fit within their constitutional systems before accepting its applicability in the various jurisdictions where it has been considered. In Kenyan context, this court has already developed an approach which courts are obligated to follow in ascertaining whether to transplant any juridical idea to the Kenyan Constitution in the post-2010 constitutional order. In the vetting board case, this court grappled with the question of the scope and effect of the ouster of the judicial review power of the High Court by a constitutional ouster clause. Whereas the court considered similar jurisprudence on ouster clauses from other Commonwealth countries that had been inspired by the landmark decision of the House of Lords in the animistic case versus Foreign Compensation Commissions and other. This court developed the interpretive model to be followed, in that case, the vetting board. I have considered the dictum in that case and the imposed obligation by this court under Section 3C of the Supreme Court Act, which provides that we must develop rich jurisprudence that respects Kenya's history and traditions and facilitates its socio, economic, and political growth. Accordingly, before declaring the applicability or otherwise of the basic structure doctrine in Kenya's constitutional context, a court is obligated to take into account our constitutional history, especially bearing in mind that the doctrine, which found root in 1973 in India, was available when the framers of the Constitution of Kenya conceptualized the provisions of Chapter 16 on amendments. Another way of looking at the matter is to ask a pertinent question as to whether there are gaps identified in particular in regard to the provisions of Chapter 16 of the Constitution requiring to be sealed by the basic structure doctrine. In addition, in evaluating whether the basic structure doctrine is applicable in our constitutional system, a court must take into account the purposive and value-based interpretation decreed by Articles 10, 20, 4, 159, and 259(1) of the Constitution. Such an approach to constitutional interpretation begins from and remains rooted in the text of the Constitution, whilst interpreting it holistically, giving effect to its values and principles, and never losing sight of the historical context and the backdrop of the provisions being interpreted. Therefore, to comprehend and contextualize whether the Constitution contemplates the basic structure doctrine, the starting point should be the rationale behind the provisions of Chapter 16 as documented in the preparatory documents from the constitution-making process. It is an statement to say that Kenyan independent constitution endured a legacy of hyper amendments during the post-independent period. The former constitution was flexible, giving the legislative wide power and discretion in amending it. As a result, Parliament undertook so many amendments to the constitution that it lost its original character. The most significant amendments being the merger of the Senate and the House of Representatives to establish a unicameral legislature, abolition of the quasi-federal regional governments that led to the establishment of a unitary state, and alteration of the entrenched majorities required for constitutional amendment, making it easier to amend the Constitution. Yet another repulsive amendment was the abolition of the security of tenure for judges and other constitutional office holders. Ultimately, the amendment that finally broke the proverbial camel's back, giving rise to the clamor for a new constitutional order, was the one that converted the country from a multi-party democracy to a de jure one-party state in 1982. Informed by this history, Kenyans yearned for a stable constitutional system where the power to amend the Constitution would not be abused for short-term interests by political elite. The CKERC report records at page 74 that Kenyans expressed what they wanted, and I quote, "There is a need to protect the Constitution against indiscriminate amendments." What emerges from the historical account is that there was a strong concern that the country should adopt provisions on amendment power that are able to protect the constitutional order from abusive amendments. But this was not all. There was also a recognition that the Constitution must remain flexible in order to adjust to political, social, economic, technological, and other changes that take place in the polity. In effect, the overarching imperative that informed the drafting of Chapter 16 was the need to find a proper balance between rigidity and flexibility. The quest for a balance between rigidity and flexibility is evident in the tiered amendment provisions in Chapter 16, which stipulates 3 pathways for amending the Constitution. The first pathway, under Article 256, provides for amendment by parliamentary initiative. This process involves public participation and approval by the Houses of Parliament through a vote of endorsement by 2/3 of all members of each House during the second and third reading of the amendment bill. The second pathway, under Article 257, provides for amendment by popular initiative. This process involves collection of at least 1 million signatures from registered voters in support of the popular initiative by the promoters of the initiative. Approval of the initiative by the majority of the county assemblies, and passage of the bill by the majority of the members of each House of Parliament. In this second process, if either House of Parliament fails to pass the bill, the proposed amendment is submitted to the people in a referendum. The third pathway, under Article 255, relates to what has come to be known as the entrenched provisions of the Constitution. Some of the Court of Appeal judges referred to these entrenched provisions as forming the basic structure of the Constitution. Article 255(1) of the Constitution stipulates that in addition to adopting either the parliamentary initiative or popular initiative pathway, where an amendment relates to the following articles, a bill to amend those provisions shall be subjected to a referendum. These are the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the national values and principles of governance in Article 10(2), the Bill of Rights, the term of office of the President, the independence of the judiciary and commissions, and independent offices, to which Chapter 15 applies, the functions of Parliament, the objects, principles, and structure of devolved government, or the provisions of Chapter 16 on amendment of the Constitution. Approval through the envisaged referendum under Article 255(2) must satisfy two conditions. At least 25% of the registered voters in each of at least a half of the counties should vote in the referendum, and such an amendment should be supported by a simple majority of the citizens. A reading of the three pathways for amending the Constitution in Chapter 16 clearly shows that Kenyans were alive to the historical legacy of the culture of hyper amendment in the pre-2010 era and sought to tame any abuse of the amendment power. In particular, Article 255(1) and 2 of the Constitution demonstrates that, alive to the culture of hyper amendments, the Kenyan people sought to ring-fence the core fundamental commitments of the Constitution by entrenching them and subjecting the process of amendment to deepened public participation, as well as imposing a downstream constrained veto by stipulating that the entrenched provisions enumerated in Article 255(1) of the Constitution can only be amended through a referendum process. The rationale of entrenching the provisions mentioned in Article 255(1) of the Constitution is, in my view, informed by the very democratic idea that constitutional amendments of a fundamental nature should take place through a deeply participatory process and be ratified by the people, being the ultimate sovereign of the polity, through a referendum. The approach in balancing flexibility and rigidity in constitutional amendment adopted in Chapter 16 reflects and compares favorably with modern constitutional architecture and design. Drafters of contemporary constitutions pursue the goal of balancing rigidity and flexibility through what has been termed as tiered design amendment rules. This argument is augmented by the articles cited before us by Professor Rosalind Dixon and David Randau in their writing titled Tiered Constitutional Design. Under the tiered constitutional model, amendment rules vary with provisions that are core to fundamental to constitutional systems being placed on a higher tier and made more difficult to amend. The amendment rules under the Constitution adopt this modern tiered constitutional design, combining the virtues of rigidity and flexibility by having different amendment procedures apply to different parts of the Constitution. The core foundational values, principles, and structures of the Constitution have been granted a higher level of entrenchment to ensure the stability of the constitutional system. It follows, therefore, that Kenyans were conscious of the core constitutional values, principles, and structures that they wanted protected from abusive amendments, and they protected them through entrenched provisions in Article 255 of the Constitution. In my view, therefore, the framers of the Constitution, well aware of the basic structure doctrine, chose to ring-fence some key features from flexible amendments, and if it was their intention to provide for eternity clauses or the basic structure doctrine, nothing would have stopped them from doing so. The next question that follows is whether it was necessary for the two superior courts to adopt the basic structure doctrine and thereby devise a fourth-way path for amending the Constitution outside the three pathways that are stipulated in Chapter 16. To answer this question requires one to appreciate how the High Court and the majority of the Court of Appeal judges proceeded to analyze Chapter 16. It was on the premise that, based on the history of hyper amendment, of the repealed Constitution during the pre-2010 dispensation, the Constitution demanded heightened procedures beyond the tiered design of the amendment procedures provided in Chapter 16 that would make the Constitution more difficult to amend. The two courts, therefore, did not go into a detailed analysis and to specifically point out the actual shortcomings of the provisions of Chapter 16, especially in light of all the 21 unsuccessful attempts that have been made over time, over the last 10 years, to amend the Constitution. The Court of Appeal, in my respectful view, and a duty to analyze the findings of the High Court and specifically point out whether there were apparent inadequacies as far as the provisions of Chapter 16 were concerned. Looking at the history, as stated above, as well as the provisions of Chapter 16, it is clear to me that Kenyans sought to achieve a balance between rigidity and flexibility in the amendment process. Kenyans did not want to shift from one extreme of hyper amendment to another extreme where no amendment can take place. That is, from hyper amendment to ultra rigidity in the amendment process. Rather, what Kenyans desired is a balance between rigidity and flexibility, as reflected in the tiered amendment process in Chapter 16 of the Constitution, with the core or essential features of the Constitution being accorded heightened protection, but still open to amendment through an enhanced, inclusive, and participatory process that culminates in our people exercising their sovereign power through ratification in a democratic process in the form of a referendum. The High Court and the majority of the Court of Appeal, with tremendous respect, failed to appreciate that the tiered amendment process is one of the options available in the menu of constitutional designs options for dealing with the practice of abusive amendments, just like other designs options limit amendability. For example, eternity clauses and basic structure doctrine. Therefore, where Kenyans have selected the tiered amendment procedure as their response to the culture of hyper-amendability, I find it difficult to justify this judicially created fourth pathway of amending the Constitution founded on the basic structure doctrine. Unfortunately, there was no justification provided to demonstrate the lacuna in the Constitution, and hence the need to call in hand the basic structure doctrine to enhance the existing tools of interpretation. The 2010 history of Kenya is replete with precedents of application of foreign laws and doctrines from Commonwealth and other jurisdictions, which was done due to absence of local statutes. Today, I dare say that courtesy of our Constitution, we have sufficient arsenals that include our own canons of interpretation, which we must exhaust before borrowing from other jurisdictions. Further, I see a potential conflict within the constitutional system with the judicially created fourth pathway for amending the Constitution. This is for the simple reason that in our constitutional dispensation that is people-centered, our nascent democracy that respects the doctrine of separation of powers by vesting legislative power in the legislature, to create a fourth pathway within the scheme of amendments would bring into question the place of the participation of the people and the place of the legislature in that scheme. Taking into account where we are at in our constitutional democracy, Kenyans needed to be consulted on whether it is their wish to introduce the fourth pathway for amending the Constitution. In other words, we judges should be vigilant, lest we are accused of usurping the sovereign power vested in the people by introducing a constitutional amendment through judicial fiat. Put differently, the tiered amendment process provided in Chapter 16 of the Constitution is a design option for dealing with the problem of abusive amendments and obviates the need for judicially created limits to amendments' power, like the basic structure doctrine. This is in line with the view expressed by Professor Rosaline Dixon and David Randau. My take home from this scholarly perspective is that tiered design of constitutional amendment process is one of the design options used to curb the problem of hyper amendments. Professor Rosanai rightly points out in his well-balanced amicus brief that the applicability of the basic structure doctrine depends very much on the context. The most important contextual consideration is the balance between flexibility and rigidity of the amendment process. The more difficult the amendment process, the less there is need for a doctrine of implied limits to amendment power. The jurisprudential underpinning of this view is that in a case where the amendment process is multi-stage, involves multiple institutions, is time-consuming, engenders inclusivity and participation by the people in deliberations over the merits of the proposed amendments, and as downstream veto by the people in the form of referendum, there is no need for judicially created implied limitations to amendments power through importation of the basic structure doctrine into a constitutional system before exhausting homegrown mechanisms. Moreover, I fully agree with a portion of the judgment by Sishare J, where she questioned the viability of relying on judges to interpret on case-by-case basis on whether a particular provision of the Constitution is amendable. To put this into perspective with respect to our constitutional architecture, amendment of entrenched provisions of the Constitution relating to the matters listed in Article 255(1) through popular initiative route requires, first, there must be public participation throughout the amendment process by dint of Article 10(2) of the Constitution. Second, collection of 1 million signatures from registered voters in support of the initiatives as provided in Article 257. Third, support of the initiative through approval of the bill by a majority of the county assemblies as stipulated in Article 257(7). Fourth, consideration of the bill by the bicameral House of Parliament, Article 257(10). Fifth, subjection of the bill to a referendum in terms of Article 255, in which at least 25% of the registered voters in each of at least half of the counties vote in the referendum, and the amendment is supported by a simple majority of the citizens voting in the referendum. Six, it should also be appreciated that the processing of the bill in the county assemblies and the bicameral Houses of Parliament is also subject to a further public participation requirement in terms of Article 196 and 118 respectively. Seventh, Article 88(4)(g) imposes an obligation on voter education on IEBC. Amendment of the entrenched provisions under parliamentary initiative routes by dint of Article 10(2) of the Constitution requires public participation, which must inform the entire amendment process. Second, the amendment bill has to go through the bicameral House. Looking at the two pathways for amending the entrenched provisions, it is inescapable to conclude that amending the core of fundamental provisions of the Constitution is a multi-staged, multi-institutional, time-consuming process that ensures that a constitutional amendment process that touches on the core of the fundamental aspects of the Constitution is transparent, inclusive, engenders the participation of the people, in a democratic society, where they designed their own governance. I therefore find that the tiered amendment process under the Constitution meets the set criteria as to when judiciary created basic structure doctrine is inappropriate and undesirable. Therefore, the two courts below and by finding a fourth judiciary created pathway for amending the Constitution, which is with respect tantamount to amending the Constitution through the judgment of the court. To buttress the point of tiered amendments, post-2010 Constitution, the amendment practice post-2010 Kenya illustrates that the tiered amendment design is an adequate work against abusive amendments. As pointed out by Sishare J in a dissenting opinion at the Court of Appeal, there have been 21 failed attempts to amend the 2010 Constitution during the first decade of its operation. 19 of these were through the parliamentary initiative and 2 were through the popular route. It is also notable that although the amendment bill had gone the farthest in amendment process, it was yet to be subjected to the ultimate downstream veto of the referendum process. Comparatively, the Independence Constitution had undergone 12 major amendments by its 10th birthday. In essence, it is right to conclude that the resilience of the 2010 Constitution in its first decade is proof that Kenyans attained the goal of balancing flexibility with rigidity in designing the amendment power as reflected in Chapter 16 of the Constitution. It ought also to be appreciated that judicial protection of implied limitation to the amendment power, such as through the basic structure doctrine, become increasingly required in context where the country has two flexible constitutions that can be amended fairly easily. Therefore, while it was inappropriate in the pre-2010 dispensation for the High Court, Lingera J, as it then was in the Joya case, to recognize the basic structure doctrine under the repealed Constitution, there is no such need under the 2010 Constitution. This view is founded on the premise that the risk of abusive amendments has been tamed by the tiered amendment process that entrenches the core of essential provisions through a heightened, elaborate amendment process. Considering the progressive nature of the Constitution, a three-judge bench, Korir, Goge, and Odunga in Priscilla Dururu case, expressed skepticism as to the continued relevance of owning the Joya case on the basic structure post-2010 Constitution in light of the provisions of Article 255 of the Constitution. In contrast, the unique context of India, with a too flexible constitution that grants the legislature the wide discretion in amending the Constitution, arguably justifies the judge-made basic structure as developed and practiced in India in order to stabilize the constitutional order and prevent the practice of abusive constitutional amendments, given the low threshold for amendments in the text of the Constitution, just as it was in our case prior to the 2010 Constitution. Although I think I've said enough to demonstrate why I disagree with the judgments of the majority of the Court of Appeal bench regarding the application of the basic structure post-2010 constitutional order, I will briefly highlight some of the critical aspects which were not considered by the two superior courts, and if the judges had done so, perhaps they would have come to a different opinion. Number one, the superior courts failed to appreciate that the concern with the culture of AIPA amendment had already been taken into account during the drafting of the Constitution of Kenya 2010. This led to the design of the tiered amendment process that balances flexibility and rigidity. In such a context, the correct judicial posture ought to have been fidelity to our Constitution. This is informed by the reality that the Constitution, to a large extent, is self-contained and self-regulating in dealing with the legacy of abusive amendments in the former constitutional amendments. Therefore, there is no justification for courts to go outside the four corners of the Constitution to create a fourth pathway for the amendment of the Constitution. Number two, the Court of Appeal failed to analyze the provisions of Chapter 16 and to arrive to its own independent conclusion on the shortcomings of the three-tiered process, and to state clearly whether it was necessary to call in aid a foreign doctrine. Also to take into account the amendment practice in the post-2010 dispensation in the analysis of the Kenya's constitutional history, which shows that Chapter 16 of the Constitution has brought stability in the constitutional system in contrast to the culture of hyper amendment under the former Constitution. There have been multiple attempts to amend the Constitution, which were all unsuccessful, meaning that the amendment process is not flexible, as in the Indian case. Three, the Court of Appeal failed to take into account the fact that Chapter 16 is one of the entrenched parts of the Constitution under Article 255(1) of the Constitution. Therefore, it could not be amended by the court through created fourth pathway of amending the Constitution without following the constitutionally ordained amendment process provided for under Article 255(1) of the Constitution. And fourth, the Court of Appeal failed to appreciate that Kenyans were aware of the idea around the basic structure doctrine during the Constitution making phase in light of the legacy of the case of Joya, and yet did not embrace the idea of a veto to the amendment power as represented in the basic structure doctrine, as well as related to doctrines like eternity clauses. The CKERC report on page 76 indicates that Kenyans yearned for power to have a say in amending the core fundamental features of the Constitution through a referendum and an inclusive and participatory process. This was done through the provisions of Article 255 of the Constitution. Another aspect of the majority judgment of the court that I need to address relates to how the two courts treated the historical background informing the drafting of Chapter 16. It is evident that the decision on the question of the application of the basic structure and doctrine within Kenya's constitutional system was largely turned on historical inquiry to clarify and provide interpretative guideline on the intent of the Kenyan people during the drafting of the Chapter 16. While this court has in the past celebrated the virtues and utility of the historical context, the background to the adoption of the Constitution in the Constitution interpretation is imperative. Given the subjective nature of the historical narratives, courts should endeavor to extract and have a view of the complete account of the historical background to the constitutional provision being interpreted. Where a court embraces an account of history that marginalizes, excludes, or suppresses or omits some portions of history accounts, such an incomplete history distorts or rather fails to illuminate the meaning of the constitutional provision being interpreted, hence misleading the court to reach an erroneous conclusion. Before leaving this part, I will also address the argument advanced by Dr. Kaminwa that the basic structure doctrine is applicable in Kenya pursuant to the provisions of Article 2.5 of the Constitution. The provision reads, and I quote, "The general rules of international law shall form part of the law of Kenya." This court has already provided juridical interpretation of Article 2.5 in the case of Mitubel, where it was held, and I quote, "In light of the foregoing, we hold that the once general rules of international law in Article 2.5 of the Constitution refer to customary international norms including jus cogens. There is a general acceptance that customary international law requires, in the words of Article 38(1)(b) of the Statute of International Court of Justice, a general practice accepted as law. That is both sufficiently widespread and consistent practice and what states have accepted as law, opinio juris, accompanying it. Examples of customary international law include the doctrine of non-refoulement of refugees and granting of immunity for visiting ends of states. Since the basic structure doctrine is a constitutional law principle acceptable in just a number of states and not an international law principle, it does not amount to a customary international law principle. Therefore, Article 2(5) of the Constitution cannot be the basis for founding the applicability of the basic structure doctrine. In the end, I find that the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the High Court and the majority of the Court of Appeal are not applicable in Kenya under the Constitution. Any amendment to the Constitution must be carried out in strict conformity with the normative standards and provisions of Chapter 16 of the Constitution. I will now move to the second issue, whether the President can initiate amendments to the Constitution through a popular initiative. The question raised was whether the President could initiate the amendment and popular initiative routes provided for under Article 257 of the Constitution. Like other norm-producing process, a constitution amendment process starts with an initial decision. That is the initiation or activation of the process. The initiative speaks to how the amendment process starts. The story starts with the 8th August 2017 presidential elections, in which the President was declared by IEBC as having been duly re-elected for a second term in office. The election results were challenged before the Supreme Court by Right Honorable Raila Odinga, who had been declared as the runner-up to the presidential elections. The Supreme Court annulled the results through a majority decision delivered on 1st September 2017 and ordered fresh presidential election to be conducted within 60 days of the nullification. However, the Right Honorable Raila Odinga and his political coalition, the National Super Alliance, withdrew from participating in the fresh presidential election, which took place on the 26th October 2017. Subsequently, Right Honorable Raila Odinga and the NASA coalition vowed not to recognize the government that was formed as a result of the fresh presidential election. This led to some incidents of violence that brought about tension in the country. After months of tension, the President and the Right Honorable Raila Odinga, in an act of statesmanship, patriotism, and bipartisan accord, emerged on 9th March 2018 to announce to the public that there was cessation of hostilities between the two political sides in what they called a handshake, through a joint communique, building bridges to a new Kenya. It is in the quest to implement this noble objective of promoting national unity and overcoming other challenges identified in the joint communique that the President appointed the Building Bridges Task Force. On 26 November 2019, the BBI Task Force released their report, which was unveiled to the public. On 10 January 2020, the President appointed the BBI Steering Committee with the terms of reference that were stated therein. As far as the President's actions with respect to setting up the BBI Task Force and BBI Steering Committee to further the agenda of promoting national unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution. This article demands nothing less from the President, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the pursuit of the building bridges to unity project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution-making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of a popular initiative is linked to the fact that it is conceived as a means for direct sovereign power to be expressed as contradistinguished with the parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from below at the initiative of the citizenry, as opposed to representative institutions. In other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating a constitutional amendment process through a popular initiative is projected in the book that was referred to us by Joe Coron Lois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, although persuasive, indicates that a popular initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinguished in Article 1, 2, and 3 of the Constitution. In other words, it is a means of direct democracy, and indeed direct democracy can only be exercised by the people, not their representatives, since that would convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process ought to be seen as an avenue through which citizens engage in the exercise of their sovereignty. As such, state organs, being not bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be appreciated that the Constitution provides normative markers for how, when, where, and by whom particular powers are to be exercised. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that the institution of the presidency has the authority to initiate a popular initiative in light of the overarching motive of the Constitution, which is concerned with tampering or limiting the powers of the presidency. In its architecture and design, the Constitution strives to provide explicit power to the institution of the presidency and at the same time limit the exercise of that power. This approach of explicit and limited power can be understood in light of the legacy of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the president and how such power is to be exercised. Another reason that supports the finding that the president was not envisaged as an initiator of a popular initiative is the role of the president with respect to entrenched matters listed in Article 255(1) of the Constitution, Article 256(5) as read with Article 257(10) of the Constitution, which grants the president a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the president has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the president ought not to be both a prayer and an umpire in the amendment process. The last reason for finding that state institutions and presidents are excluded from using the popular initiative is to be found in Article 255(3)(b) of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It therefore follows that a state body like the institution of the presidency cannot fall within the rubric of the people, as the very text of the Constitution makes this distinction. This brings me to the inescapable conclusion that state institutions and state organs, such as the presidency, cannot initiate constitutional amendments via the popular initiative route provided for under Article 257 of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the president and even the Attorney General sustained an argument that barring the president from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the president's political rights as protected for in Article 38(1) of the Constitution. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38(1)(c) of the Constitution. However, there is an additional handle in deciding whether a right is applicable in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature and the right of the fundamental freedom. What I deduce from this provision is that a court is under an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that Article 38(1) grants the freedom to make the political choices to every citizen. The citizen qualifier speaks to the range of application of the freedom to make political choices by limiting the rights enjoyments to the citizens. Therefore, for one to be a beneficiary of the freedom to make a political choice, they must fall within the category of the citizen. Based on the citizenship qualification, the freedom to make political choices is a right that does not accrue to state organs or institutions. State organs or institutions cannot be citizens because under Chapter 3 of the Constitution, citizenship is limited to living human beings, excluding state organs. Consequently, while the president, when acting in his private capacity as a citizen, can enjoy freedom to make political choices, this right does not accrue to the institution of the presidency, which is a state organ. The presidency and other state organs do not fall under the rubric of citizens. I therefore find that exclusion of the institution of presidency and other state institutions from initiation of a process to amend the Constitution through the popular initiative route does not violate the political rights protected under Article 38(1) of the Constitution. The last aspect of this issue relates to whether it was established through evidence that the process to amend the Constitution through amendment bill was initiated by the President. At the outset, it should be pointed out that the concurrent findings by the two courts below was that the President, by a number of antecedent acts, and initiated the process, and the state was the real force behind the amendment process, including through the use of state resources to support the process. In a challenge to this finding, it was argued by the Attorney General and the BBI National Secretariat that it is the BBI National Secretariat, through Honorable Dennis Wawero and Honorable Junet Mohammed, who are the initiators and promoters of the impugned constitutional amendment initiative, and not the President. An examination of the evidence before the courts revealed a number of things relevant to this factual determination. For starters, the President and the National Executive took certain actions which portray its role in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. One, the President signed off the communique in March 2018. The official title of the President, the communique was published in a paper bearing the coat of arms of the Republic and the seal of the President. The President appointed the BBI Task Force and the BBI Steering Committee Task Force through Gazette Notice of 51, 54, and 264 of 2018, respectively. The President received the official reports through a state function as President. As a result, it cannot be disputed that the President was involved in the initiation of the amendment bill. However, in my considered view, the President cannot be blamed for this because it is the promoters who took over the amendment bill under the auspices of the BBI National Secretariat, who had, by invoking the popular initiative route under Article 257, to pursue the amendment process. It is my finding that the genesis of the amendment bill can be traced to all these actions. I therefore affirm the factual findings by the two superior courts that the President was involved in the amendment bill and agree with the finding by Tuyot J. I believe I have stated enough to support by conclusion that the President of the state institutions are not permitted to initiate or promote a constitutional amendment process through the popular initiative route envisaged in Article 257 of the Constitution. This now takes me to the third issue, whether the second schedule to the amendment bill was constitutional. To put this question in context, it ought to be appreciated that the second schedule was intended to serve as a transitional scheme of implementing Clause 10 of the amendment bill. Clause 10, which intended to amend Article 89 of the Constitution, provided, and I quote, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute, therefore, with words 360. Clause 1(2) of the second schedule proceeded to distribute the additional 70 constituencies as per the schedule. It is in the above context that the constitutionality of the second schedule, directly allocating and apportioning the proposed constituencies to specified counties, were challenged. The two superior courts were unanimous in their findings that the second schedule to the amendment bill was unconstitutional. This finding was based on the substantive grounds that the second schedule violated the basic structure of the Constitution by purporting to take away the mandate of the IEBC, an independent body under the Constitution. Further, it was contended that the second schedule impermissibly directed IEBC on the execution of its constitutional functions. It is imperative to begin the analysis on the constitutionality of the second schedule of the amendment bill by pointing out that given my earlier finding that the basic structure doctrine does not apply under the Constitution of Kenya 2010, my determination of this question rests on the procedural concerns linked to whether there was public participation in coming up with a second schedule. This is because the provisions of Article 89 are amendable as long as due process is followed. It ought to be appreciated that amendments touching on matters falling within the remit of Article 255(1), which are the core fundamental commitments of the Constitution, ought to be undertaken through a highly participatory and inclusive process. It should be noted that directly allocating and apportioning constituencies usurps the mandate of IEBC, an independent constitution commission, removing the possibility of judicial review of the delimitation as an effect on the independence of the judiciary. The centrality of the constituencies as units of political representation in the National Assembly means that they ought to be apportioned and allocated by a neutral and professional actor, much more so because malapportioned constituencies have the potential of diluting the power of the vote, hence threatening the animating goal of fair and effective representation, which is at the heart of the foundational value of democratic governance enshrined in Article 4.2 and 10.2a of the Constitution. Further, since the constituencies are units of social and economic development through allocation of national government constituency development fund and the recruitment into disciplined forces such as the Kenyan Defence Forces and the National Police Service, the delimitation of constituencies has implications on the constitutional values and principles of equity and social justice enshrined in Article 10.2b of the Constitution. It goes therefore without saying that the delimitation of constituencies must be accompanied by a process that is fair and just, which is the golden thread that runs through our constitutional order as elaborated in the preceding chapters. I've also considered that this process was not subjected to public participation and referred to cases by this court, the British American Tobacco case, that provided that the tests for adequate public participation should be reasonableness. That should be the threshold. Following from this case, I now examine whether there was reasonable notice and opportunity afforded to the public for generating the views and deliberating on apportioning and allocating the disputed 70 constituencies as provided for in the schedule. An examination of the process leading to the BBI task force and the BBI steering committee reflects that there was reasonable participation and involvement of the people in coming up with the recommendations of the bill that was published on 21st October 2020. There is, however, no evidence of any form of public participation or deliberation between 21st October 2020 and 25th November 2020, when changes to the draft constitution of Kenya bill was made, including the addition of the second schedule. This leads, therefore, to my conclusion that the constitutional threshold of reasonable public participation was not met when the second schedule of the amendment bill was presented. Consequently, I come to the conclusion that the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Article 10(2) of the Constitution. I move now to the fourth issue on the presidential immunity. At the outset, it is important to point out that given the Court of Appeal held that the President was not served with the petition number E400 of 2020 in the proceedings before the High Court in which this question arose, it was improper for the Court of Appeal to proceed and adjudicate the question of interpretation of Article 143(2) of the Constitution. However, as considered in the President's written submissions filed before the High Court, there is a public element in this matter, so this Court should clarify and settle the law on the nature and scope of protection of the President from civil legal proceedings, considering the findings of the two courts below. It is generally recognized that immunity from legal proceedings usually takes two forms. First, immunity from liability protects officials not from proceedings being undertaken, but from personal liability at the end of the proceedings, which relates to enforcement. Second, immunity from proceedings is a broader form of immunity that overthrows the court's or tribunal's jurisdiction to hear a matter because the parties against whom the proceedings are undertaken enjoys immunity. Further, there is absolute and qualified immunity. Absolute immunity has no limitation as to its application, while qualified immunity usually has limitation, like extent of actions and other related to other official function, whether done lawfully or done in good faith. The Constitution contemplates immunity of certain officials in the performance of their functions. For example, Article 160, a member of the judiciary; Article 250, a member of the commission; Article 143, criminal proceedings shall not be instituted against the President or a person performing the functions of that office during the tenure. From the structural ending of the above provisions, there are glaring distinctions that illuminate the nature and scope of presidential immunity envisaged under Article 143(2) of the Constitution. Firstly, all the officials set out above enjoy immunity as persons, holder of office or member of a commission, but not their offices, whereas the President enjoys immunity as both the person in the office and the office itself. This is evident from the choice of phraseology used in Article 143 to the effect that the President or the person performing the functions. To make the point clearer, one can contrast the nature of immunity envisaged in Article 143(2) to Article 259 for an holder of an independent office. Consequently, this brings me to the inescapable conclusion that the immunity of the President is unlike that of the other state actors. The President not only enjoys functional immunity like all public officials who perform state duties, which protects them from civil liability for official functions, they further enjoy sovereign immunity as the end of state and the single representation of the sovereignty of the Republic. Indeed, it is only sovereign immunity that can immunize anyone against both proceedings and criminal liability, because any other immunity would be related to official functions and therefore would inherently be a qualified immunity. The two courts below, especially majority opinion of the Court of Appeal, relied on the phrase "in the exercise of their powers under this Constitution." I am conscious that part of the President's role in the performance of their functions is the interpretation of the Constitution as to whether or not it gives them power to perform particular roles. Upon such interpretation, the President either acts or fails to act in the belief that either that power exists or does not exist. It would follow then that if proceedings were to be instituted against the President after the interpretation, which is considered to have been wrong interpretation, then such proceedings would fall within the immunity contemplated in Article 143(2), in that it would be within the performance of the President's functions. There is no provision allowing or requiring the President to seek an advisory opinion from the judiciary before exercising their duties or before determining whether they have power to perform any official act. And in any event, this would generally blur the separation of power. Further, the two superior courts held that the President or the person performing the functions of the President is not above the law and should be amenable to the law if they act against the Constitution. The implication of this finding is far-reaching and therefore calls for a very careful analysis and consideration by this court. It is necessary to state that the Constitution has provided for how the President and the Executive in general can be kept in check through political accountability, with the provision that the President is liable for impeachment under Article 145 of the Constitution. The grounds for impeachment listed under Article 145(1) of the Constitution includes gross violation of the Constitution or any other law, commission of a crime under national or international law, or gross misconduct. This means that there is a clear avenue to check the President's conduct as acknowledged by this court, by the Court of Appeal in the case of Minister for Internal Security and Provincial Administration versus Center for Rights, Education and Awareness. With respect to legal accountability, the protection of the President from legal proceedings under Article 143 does not mean that President's actions or omissions cannot be challenged in court. Anybody or a party aggrieved by the President's actions or failure can initiate proceedings against the Attorney General, whom by virtue of being the legal representative of the government in legal proceedings also represents the President. As such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein a court may issue appropriate remedies. In effect, the findings of the two superior courts and the ramification of rendering Article 143(2) of the Constitution ineffective or superfluous. This is an interpretive path that, in my view, is not open to the courts. An interpretation of the Constitution that resorts to an amendment via a judgment is tantamount to judicial overreach. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or a person performing the functions of the President during the tenure of the office. I hold that civil proceedings cannot be instituted against the President or a person performing the functions of the President of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Such proceedings can be instituted against the President via the Attorney General. Issue number 5 on public participation, whether there was public participation the issue was framed by the court with two components. The first relates to the role of IEBC under Article 257(4), whether IEBC is under an obligation to ascertain that promoters of a popular initiative have undertaken public participation during the collection of signatures. It is clear to me that there is no direct requirement arising from the provision of Article 257(4) that imposes an obligation on IEBC to ascertain that the promoters of the popular initiative have undertaken public participation. Nonetheless, the High Court held that IEBC was obligated to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation as provided for under Article 10(1) of the Constitution. It is necessary to keep in mind, to keep reminding ourselves that IEBC, being a creature of the Constitution and statute, can only discharge a mandate vested in it explicitly by the law. This is a direction given under Article 10, which identifies the rule of law as a national value and the principle of governance. It follows that IEBC, like all other public bodies, cannot by craft or innovation or interpretation extend its power to include ascertaining whether a promoter or a popular initiator has complied with the public participation requirements under the Constitution. Equally, courts should not encourage extension of powers by constitutional or statutory bodies. Such bodies must operate strictly within the four corners of their constitutional and statutory mandates. Given this view, unless there is a statutory framework enacted that confers power on IEBC to ascertain whether a promoter has undertaken public participation, the exercise of such a mandate would be a mere overreach. In the upshot, therefore, it is my finding on the first part of the question as framed that there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining that the amendment bill had met the constitutional requirements for transmittal to the county assemblies. As regards the second part of the question as framed, relates to whether there was public participation in respect to the amendment bill. In determining this question, it ought to be appreciated that while participation of the people has been identified as foundational value and principle of governance under Article 10(2), it is even more crucial with regard to processes that would lead to constitutional amendments. This is so because it is the people's acceptance and ownership that grants democratic legitimacy and authority to the Constitution. It is against the standards that are set in the case of BAT by this court that I proceeded to examine whether there was public participation as regards the Constitutional Amendment Bill 2020. From the provisions of Article 257, it is discernible that there are four stages in the amendment process under the popular initiative route. The initiation stage, that is the collection of signatures, which typically involves the promoters of the initiative setting the referendum agenda. However, this is to be within the context of the constitutionally guaranteed opportunities for citizens to influence the process. It is also not lost to me that an onerous requirement that a promoter conducts public participation before presenting signatures for verification at this stage would be unreasonable, because the whole process may be rejected by IEBC like it did the two popular initiatives dubbed Okoa Kenya and Punguza Mizigo. Moreover, unlike subsequent stages where the cost of public participation is borne by the public bodies, that is the county assemblies, the IBC, the cost of public participation will be borne by citizens or a group of citizens. In such a context, I'm of the view that the requirement of public participation during the period proceeding and during the collection of signature under the popular initiative process should not impose onerous requirements on a promoter of the initiative. The second stage, which is the assembly stage, seems to lend itself more to public participation. This is because the Constitution imposes a normative obligation for the public participation in legislative affairs. Moreover, a timeline of 3 months within which county assemblies ought to consider the bill of the constitutional amendment supports a reading that assemblies must solicit for input from the public. The third stage, that is passage through the Houses of Parliament, is another key stage for public participation. The fourth, the referendum stage, is intended to serve as a national deliberative moment. Hence, duty bearers, including IBC, have an obligation to facilitate a broad participatory process that includes voter education. It is important to reiterate that the requisite mode, degree, scope, and extent of public participation or sufficiency thereof is to be determined based on the peculiar circumstances of each case. Nonetheless, public participation must not be an illusion, but a meaningful engagement. On the question of whether there was reasonable public participation and the question of burden of proof, Okwengu and Kiagi JJA held the view, and rightly so, that by dint of Section 112 of the Evidence Act, once there is an allegation of lack of public participation, the burden shifts to the person charged with the responsibility of performing the same to establish adequate participation. However, JA arrived at a slightly different conclusion. In his view, the burden could only shift to the promoters of the amendment bill if there was evidence to the effect that the persons or person who appended their signature in the support of the bill were not aware of the amendment bill. The evidence before the court shows there was a reasonable attempt at public participation with respect to the impugned initiative. This view is supported by the evidence of Dennis Wawero, co-chairperson of the BBI National Secretariat, in his affidavit sworn on 5th February 2022, which was in response to petition number 416 of 2020 by Morara Omoke. He reports that BBI Task Force Steering Committee and the amendment bill were products of comprehensive consultative public engagement all over the Republic, which process entailed voluntary nationwide public participation. In addition, he annexed to his affidavit invitations, deliberations, reports, and memoranda to that effect. I have also taken time to go through the BBI Steering Committee report, and there is evidence of public participation with regard to the process as documented on page 2 of the report, which I have reproduced in my judgment. There was no challenge to the contents of the BBI Steering Committee report and the deposition by Dennis Wawero, which therefore leads to an unavoidable conclusion that there was reasonable public participation with respect to the amendment bill, save for the second schedule thereto. As far as the second schedule of the amendment bill is concerned, as I have discussed earlier, it was a late addition to the process. It is worth reiterating that the evidence of public participation runs up to the launch of the Steering Committee report that took place on 21st October 2020, wherein the draft amendment bill was attached and unveiled to the public. This version did not have the second schedule in question. There is no evidence of public participation between 21st October 2020 and 25th of November 2020, when the amendment bill was published and introduced in the second schedule for the first time. Having made the above findings, I need to point out in obiter that there is need for Parliament to enact a legislative framework to guide and regulate the process of public participation. While the Constitution sets a broad normative obligation for public participation in various governance processes, there is no legislative framework regulating how this obligation ought to be implemented. It is instructive to note that there have been 3 bills tabled in the Houses of Parliament with respect to providing a legal framework, but none of them have been successful. It ought to be appreciated that legislature has a duty to fulfill its obligation under the Constitution by enacting laws to actualize constitutional imperatives. In the end, I hold that there was reasonable public participation with respect to the amendment bill, save for the second schedule of the impugned bill. I now move to issue number 6, the composition and quorum of IEBC. The above issue was raised in the High Court, find petition number 416 of 2020. It was arranged that IEBC lacked quorum for consideration and approval of policy matters relating to conduct of referenda, including verification of signatures under Article 257(4). As at the time the verification process was undertaken, only 3 commissioners of IEBC were in office, while 4 commissioners had resigned and they had not been replaced. The High Court was persuaded by the petitioners in the aforementioned case and held that the requisite quorum for purposes of carrying out its business, as well as the verification of the signatures, was lacking. The position was affirmed by a majority of the Court of Appeal bench, with Sishar and JEA dissenting. In light of this background, that this court is called upon to determine whether IEBC was constitutionally infirm in terms of its composition. It ought to be appreciated that the legal regime on the composition of IEBC is regulated by the Constitution. While Article 88 of the Constitution establishes IEBC, provides for eligibility of appointment of its members and its mandate, this provision does not touch on its composition. It is Article 251 which provides for the composition of the commissions and independent offices. Article 248, 2C lists IEBC as one of the commissions and independent offices, making Article 251 the constitutional provision regulating its composition. The Article 251 provides as follows, I quote, "Each commission shall consist of at least 3, but not more than 9 members." Section 5(1) of the IEBC Act, which statute, according to its long title, is an act of Parliament to make a provision for the appointment, effective operation of the IEBC, provided that the commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution. Section 5(1) appears to have influenced the reasons of the 2 courts below as regards the quorum. It is readily apparent that there is a possibility of the provisions of Article 250 of the Constitution and Section 5(1) of the IEBC Act being read as imposing different requirements with regard to the composition of IEBC. This leads to the question as to whether IEBC, composed of 3 commissioners, would be infirm to conduct its constitutional mandate, including the verification process provided for under Article 257. My finding on the above question is that Section 5(1) of the IEBC Act should be read in a manner that conforms to Article 251 of the Constitution. The reason being that Article 2, which expresses the supremacy of the Constitution, demands that no legal norm, including registration, should have an effect contrary to that expressed in the Constitution. In other words, the provisions of the Act of Parliament cannot erode the Constitution. The expressed intention of Parliament in legislation cannot trump the normative command of the Constitution in a legal system where the Constitution is supreme. And this has been emphasized by the decision of this court in the case of Hassan Doho and also in the case of Mumo Matemo. I have also looked at persuasive jurisprudence from other courts in other jurisdictions which support this approach to statutory interpretation. Therefore, the implication is that IEBC is legally constituted when composed of the minimum number of 3 commissioners stipulated in Article 251 of the Constitution. As such, I find IEBC was constitutionally and legally composed when it undertook the verification of the verification process under Article 257 of the Constitution. This now takes me to the last issue. Issue number 7. On this issue, the High Court determined that Article 257(10) of the Constitution requires all specific proposed amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot paper, which are to be voted for separately and distinctively. This finding was affirmed by Nambuye, Okwengu, Kiagi, Gatembo, JA, and a qualifier subject to the nature of the proposed amendments. Musinga JA disagreed with the learned judges of the High Court and held that what is to be subjected to the referendum is an amendment bill which the people are to approve or disapprove. On his part, Tuyot JA held that since IEBC had not received the requisites and had not discharged its responsibility of framing the questions, the matter was not ripe for determination. The first question for determination is a preliminary one, which is whether the question on formulation of referendum question was ripe for determination. The doctrine of ripeness focuses on when a dispute has matured. It prevents parties from approaching a court before a party has been subjected to any prejudice or real threat of prejudice as a result of a registration or conduct that is challenged. At the time of filing of the subject petitions, particularly petition E400 of 2020, the amendment bill was yet to be subjected to the county assemblies for debate. This means that IEBC was yet to be invited to make a determination on the manner and form of the referendum questions, taking into consideration that IEBC obligation under Article 257(10) of the Constitution had not arisen. Tuyot JA was right in finding that there was no live controversy before the High Court, which ought to have declined to make a determination on this case. Accordingly, I find that the issue of whether Article 277(10) of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. On the issue of costs, this being a public interest matter, I also find that each party, like it was found in the courts below, should bear their own costs. My findings, therefore, are number 1, the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the 2 superior courts below are not applicable in Kenya under the Constitution of Kenya 2010. Number 2, the President is not permitted to initiate constitutional amendments or changes through a popular initiative route. I find the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. And lastly, on costs, this being a public interest matter, I find each party should bear their own costs of this litigation and also the other courts below. That is my judgment. I will now request the Honorable Justice Ouko to read his judgment.
Thank you, Judge President. This is a summarized version of my judgment. This appeal, consolidating two others, marks the first time in the history of the Supreme Court of Kenya to determine the remit of constitutional amendment through a popular initiative and Article 257 of the Constitution. The road traveled by Kenyans since 1991 in search of a new constitution, culminating in the 2010 document, has been sinuous and meandering. A road characterized by violent demonstrations, protests, mass actions, and even loss of life. Like the biblical narrow road which leadeth unto life, it was the way, the only way to a new beginning. And so at 10:26 a.m. on Friday, 27th August 2010, with a single stroke of his pen, President Mwai Kibaki endorsed the draft constitution, and there was a dawn of a new era. Before an ecstatic Kenyan people, and as cannons broke into a 21-gun salute, the President released two white doves as a sign of peace, love, hope, marking the birth of the Second Republic. Having emerged from this phase, Kenya embarked on building constitutionalism, giving meaning to the terms and values of the supreme law to which Kenyans must turn to for protection in times of need. It was time for the people to read meaning into its words. It's only through this robust enforcement, application, and interpretation by courageous citizens, lawyers, legislature, executive, and even more so by judges, that the Constitution will be safeguarded to realize the Kenyan dream contained in the preamble. And so, with the difficult history of constitutional making enumerated in the lead judgment of the Honorable Chief Justice, the question I pose: have the Kenyan people stayed true to the promise in the preamble that we, the people of Kenya, adopt, enact, and give this constitution to ourselves and to our future generations? So there were 7 issues that were framed, the first one being that on basic structure doctrine, and that's the one I now turn to. In the last 50 years, since the Supreme Court of India decided Casavananda case, the name Casavananda has been synonymous with the basic structure doctrine, and although the term basic structure has not been used, has been used in a few cases in this country in the past, it is during the hearing of this case from the High Court through to this court that it became a household name. I suppose, knowing Kenyans in our true unique sense, there may be children today who are called basic structure, perhaps basic structure George Ochola, just as there may be also in India children born in the 1970s who are given the name Casavananda after the Hindu spiritual leader who lent his name to the iconic case as the petitioner. Unfortunately, I believe you are all aware, Mr. Kesavananda passed on the 6th September 2020 at the age of 79 years. The origin of basic structure doctrine has largely been attributed to the Indian Supreme Court decision in Kesavananda, with very little or no acknowledgement at all of Professor Conrad's contribution. Yet it is this German scholar who exported it to India. Professor Conrad's theory, which was applied in Kesavananda, postulates that there are implied limits on the power of Parliament to amend certain protected provisions of the Constitution, called the basic structure. Under Article 368 of the Constitution of India, it is Parliament and Parliament alone that is reposed of the power to amend the Constitution. And indeed, clauses 4 and 5 even explicitly limits the power of the courts to review any act of Parliament to amend the Constitution. No amendment of the Constitution made by Parliament pursuant to the provisions of the Constitution can be called in question in any court in India on any ground. However, in construing Article 368 and the limitations on the powers of the court to question the power of Parliament, notwithstanding, the Supreme Court in Kesavananda held that although the article donates exclusive power to Parliament to amend any provision of the Constitution in accordance with the procedure in that article, the powers could not be used to damage, emasculate, destroy, abrogate, change, or alter the basic structure or the framework of the Constitution. The theory was itself influenced by the Germans' political and constitutional history. Under Article 76 of the Germans' original constitution, called the Weimar Constitution, Parliament had the power to amend the Constitution with the procedural restraints that required two-thirds votes of the members of its parliament to pass an amendment. Adolf Hitler, that well-known but reviled figure in history, used this same procedure, a procedure which is anchored in the Constitution, effortlessly to overhaul the entire Weimar Constitution and arbitrarily took away rights to freedoms of speech, expression, association, and habeas corpus. He then declared the state of emergency. This experience was to inform Germans' constitutional reforms. In their new constitution, the Grand Gazette, the Basic Law, substantive limits have been introduced to the amending power of Parliament. Article 79 of the Basic Law explicitly bars any amendment to the provisions concerning the basic principles like federalism, democracy, rule of law, separation of powers. Our own history is equally replete with the examples and instances that led to agitation for constitutional reforms, as the former constitution was in no better ranking than the Indian or the Weimar constitutions. The former constitution provided for its alteration as opposed to amendment under Section 47 and vested wholly the power to amend it in Parliament, a common denominator with the Indian and the Weimar constitutions. Our Parliament under Section 47, like parliaments of the two nations, could indiscriminately change and did, in fact, change the Constitution at will in any manner whatsoever without reference to the people. The history of agitation to reverse the trend and save the Constitution leading to the promulgation of the 2010 Constitution is well known and are chronicled in details in my main judgment. But why is this history important? Just like India and Germany, where the seed of basic structure doctrine was planted, it is their unique history that influenced the path of constitutional reforms and the decision of the courts in those jurisdictions in applying the doctrine. Constitutions the world over reflect the uniqueness and specificity of each society, even if lessons or experiences can be drawn from those places. In the Kenyan situation, drawing from the past, informed by the present, and focusing on the future, the 2010 Constitution has set up a framework which returns Kenya to the path of democratization. Parliament cannot be used to pass amendments to the Constitution in the manner it did before 2010 because of the current inbuilt mechanisms and safeguards, as well as the complex and elaborate procedures in the Constitution itself. The situation the Supreme Court of India was addressing in Kesavananda is unique to India based on the specific provisions of the Indian Constitution, Article 368 to be exact, their experience, and also based on their history generally. Therefore, in relying on Kesavananda, hook, line, and sinker to address the peculiar circumstances of Kenya, the superior courts below ought to have exercised caution and followed the guidelines repeatedly emphasized by this court in various cases, Judges and Magistrates Vetting Board and the Rai case. Courts ought to avoid mechanistic approaches to president because it is inappropriate to pick a president all over the world simply because they appear to provide an answer to a matter at hand. Each of those presidents has its place in the jurisprudence of its own country of origin. There was justification to rely on Kesavananda in interpreting Section 47 of the former Constitution in the Njoya case because at the time our constitutional framework was more or less similar to Article 368 of the Indian Constitution in the sense that the power to amend the Constitution reposed in Parliament and Parliament alone. But this is no longer the case in Kenya. Throughout the constitution-making process, from the Bomas draft, the Wako draft, the revised harmonized draft, and the proposed draft constitution, it has been made abundantly clear that since the Constitution embodies the will and aspirations of the people, they must be central to its amendment, and that there ought to be a balance to have a Constitution that is flexible enough for posterity and unforeseen needs, but rigid enough to prevent the abusive hyper-amendments of yesteryears. This balance was achieved by clear, unambiguous, and distinct tiered or multi-stage design model, codified in Chapter 16, applying different procedures of amendment for different provisions of the Constitution. Specifically, amendment process of any matters in Article 255(1) is complex and onerous. It requires support of 1 million voters, requires the promoters to draft a bill, which then must be verified by the IEBC, and finally, and approval by the county assemblies and parliament, meeting a certain threshold, and finally ratified in a referendum. Attempts to utilize both parliamentary and popular initiatives have failed essentially because of the tiered or multi-stage design of Chapter 16. You remember the Okoa Kenya Bill of 2016, Punguza Mizigo Bill of 2019. To this extent, even the two courts below agree that Article 255(1) embodies the basic structure of the Constitution of Kenya. For me, the most difficult part of the two judgments of the two courts below and the dilemma flowing from them is the imprecise scope and extent of basic structure doctrine. Which provision in the Constitution of Kenya, for instance, are not amendable through the procedure in Chapter 16? What does it mean, for instance, when the High Court and the Court of Appeal accept, on the one hand, that all articles in the Constitution are amendable in accordance with the constitutional procedures provided, but on the other, qualifies the statement by declaring that basic structure of that very Constitution cannot be altered using the amendment power in the Constitution. What does it mean when they declare that the basic structure consists of the preamble, the 18 chapters, the 16 schedules? Is it the Constitution is in entirety as a basic structure? Where do Kenyans who wish to propose amendments to the Constitution go to be shown which provisions cannot be amended using Chapter 16 procedure? Do they go to some deity, some oracle of Delphi, for instance? In interpreting the Constitution, courts must provide pragmatic solutions without adding confusion to the controversy that the parties have brought to them for resolution in the first place. Amending the Constitution is not a light matter, therefore, limitations to its amendment must sufficiently be specific and unambiguous. In India today, because of the nebulous nature of implied limitations to constitutional amendment since Casavananda case, every court has attempted to identify by listing some of the essential structural elements of the Constitution that in their individual perceptions constitute the basic structure of the Indian Constitution on a case-to-case basis. Chapter 16 exhaustively sets out the process of initiating an amendment to the protected provisions. Of course, that process includes public participation and a referendum. That is in answer to the question of where is the juridical basis in the Kenyan context for the proposition by the two courts that the basic structure of the Constitution can only be amended through primary constituent power, which must include four sequential processes, namely civic education, public participation, and coalition of views, constituent assembly, debate, and ultimately a referendum. The last matter under this ground is to consider the unanimous conclusion by both superior courts below that the proposed amendments in the draft bill amounted to dismemberment of the Constitution. Besides the number of articles sought to be amended, the courts were concerned about their overall effect, that they were so far-reaching in character, scope, and content as to, and I quote, shake the foundation and alter the identity and character of the Constitution as to effectively dismember it. The learned judges variously defined the word dismemberment to mean doing any of the following in the Constitution: unmaking, replacing, disassemble, completely change identity, abolish, tear apart, amputate, and rough mutilation. Do the proposals in the amendment draft bill create a new constitution? Do the verbs unmake, replace, disassemble, completely change identity, abolish, tear apart, amputate, employed by the learned judges to describe the proposals in the bill and to suggest that the proposals were a dismemberment of the Constitution, are they so? In my most respectful view, these words were an overkill, and the sledgehammer employed to deal with them was in itself disproportionate. I end this ground where I started. However great, however progressive a written constitution may be, history, experiences, and changes in society would necessitate corresponding changes to the written text of the Constitution, with each generation having the right and freedom to determine the law under which they wish to live. And no generation should bind the course aspirations, constitutional expectations, values, principles, and objects of generations to come. The language of Chapter 16 is clear and plain, leaving no room for conjecture, inference, or implication. Neither the explicit nor the implicit language of the Constitution, the history of constitutional making, or any principle of constitutional interpretation in this country permits the courts to do what the courts have accused previous parliaments of perpetuating, that is, to undertake indiscriminate and radical amendments to the Constitution by imposing an alien method of amending it. In the result, I would set aside the judgment of the Court of Appeal and hold that to the extent that the basic structure doctrine limits the amendment power contrary to the express terms of Chapter 16 of the Constitution, it does not apply to the Constitution of Kenya, and that there are no four sequential steps for the amendment of the Constitution other than the steps outlined in Chapter 16. The second issue is on the role of the President in the process. This question to me, and of course the question of basic structure doctrine, are the real nerves of this dispute. This particular question seeks to answer the issue of legality, legitimacy, and constitutionality of the process leading to the formulation of the draft bill based on the true construction of Article 257. The High Court was persuaded and declared that the President does not have authority under the Constitution to initiate changes by way of amendment, that a constitutional amendment can only be initiated either by Parliament through parliamentary initiative under Article 256 or by a popular initiative under 257. The Court of Appeal, in a unanimous decision, agreed and affirmed that conclusion. Friday afternoon, March 9th, 2018, which was the same day the justices of the Court of Appeal elected me as their president at Safari Park Hotel, will be remembered as one of the many defining moments in the history of Kenya. It was on that day that, in a move that took many by surprise, the President and his political opponent, Honorable Odinga, with whom he had recently engaged in fiercest and bare-knuckle political contest, met and agreed in what has come to be known as the handshake to end their political rivalry that had been witnessed in the previous elections. The last political contest between the two was so fierce that at the end of it, both laid claim to the presidency. It has been argued that the President and Honorable Odinga, both well-meaning, intended to ease the seething tension and restore peace, unity, and tranquility in the country. To realize this objective and as an understanding of the handshake, the two agreed to pursue a 9-point agenda styled the Building Bridges Initiative, or BBI. A series of events followed, and I traced these events to mark out the role of the President in the process. By a Gazette notice of 31st May 2018, the President appointed a 14-member team known as the Task Force on Building Bridges to United Advisory. By a subsequent Special Gazette notice of 10th January 2020, the Steering Committee on the Implementation of Building Bridges to a United Kenya Task Force report was also established, and as the name suggests, to implement the report of the task force. Of interest, one of its mandate was to propose administrative policy of constitutional changes that may be necessary. The Steering Committee's report was presented to the President on 21st October 2020. It was subsequently launched on 26th October 2020 at Bomas of Kenya in an event presided over by the President. A third entity, the Building Bridges National Secretariat, whose origin is not clear to me, since I have not been able to trace on record any appointment letter or a gazette notice, appears on the scene. So, co-chaired by Honorable Dennis Waweru, a former member of Parliament for Dagoretti South constituency, and Honorable Junet Mohammed, a sitting member of the National Assembly representing the people of Suna East. On 25th November 2020, at the Kenyatta International Conference Center, the President launched the draft bill and rolled out the collection of signatures to support the initiative. A popular initiative for amendment of the Constitution according to Article 257 is commenced by the promoters getting at least 1 million registered voters to support it. It is the promoters who must formulate the draft bill. They are required thereafter to deliver the bill and supporting signatures to IBC. And from this point, the process is self-executing along the lines in Chapter 16. The term popular initiative has not been defined in the Constitution, but for the present purpose, the definition sources employed by both the High Court and the Court of Appeal are unanimous that the term popular initiative can only be an initiative by the general public. In common parlance, simply the people. The citizen who was described by Madan, Chief Justice in Githunguri, as the man in the market, the man on Pangani bus. On the other hand, the word promoters in the Constitution is used only in Article 157. It is apparently a term of art in the context of amendment of the Constitution, describing the persons not in the company law sense or in the colloquial sense, but those who initiate or champion constitutional changes. Beside the definition of the term popular initiative, there is history behind the process for the intendment of the framers. The CKRC final report 2005 acknowledged and recommended that apart from Parliament, it was necessary for the people, in brackets, citizens and civil society, in exercise of their constituent power, to be involved in the constitutional changes. The term popular initiative originated from this report. With that history in mind, there cannot be any debate as to the target of Article 257. It is the people. The suggestion that Honorable Waweru and Honorable Mohammed, as co-chairpersons of the Secretariat and not the President, were the promoters cannot be accurate. First, the Secretariat emerged, as I've said, from the blues, as it were, for the first time in the process. However, Honorable Waweru himself, on behalf of himself and the co-chairperson, swore an affidavit of 5th February 2021 to state that the Building Bridges to a United Kenya was created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other roles. That the task force and the Secretariat conducted a robust nationwide public engagement and collection of views, and that from these views, it made various legislative, policy, and constitutional amendment proposals in various fields affecting Kenyans. So that, although the Secretariat does not disclose its origin, its ancestry, its family tree, its gene cannot be concealed. The affidavit says it all. The great-grandfather is the handshake, the grandfather is the task force, its father is the steering committee, and the surname of all of them is Building Bridges Initiative, alias BBI. The bill which the Secretariat presented together with the signatures to the IEBC was clearly, so to speak, inherited from the steering committee, almost a replica of the bill annexed to the steering committee's report to the President. The draft bill was curiously signed by Building Bridges Initiative as the promoters, and not Honorable Waweru or Honorable Junet, or even the Secretariat. It's not clear how they went about collecting the signatures, but on record, at least, there is some evidence of state involvement, going by the letter written by the Principal Secretary, State Department for Sports, directing the Director General, Sports Kenya, to supervise the staff in the organization to complete the forms and sign appropriately and urgently the forms. The conclusion I reach, as should be apparent on the first limb of this ground, is that the President, as a matter of fact, commenced and spearheaded the process from its inception and only passed on the baton to the two co-chairpersons when it was too late in the day and beyond recall, that the President is ineligible to directly or indirectly initiate a constitutional amendment to the Constitution under any of the prescribed circumstances, that he cannot act as an ordinary citizen because he is not, and at the same time claim to be exercising executive authority. He cannot, in the circumstances of Chapter 16, run with the hare and hunt with the hounds. It has been argued that by barring the President from initiating the process of constitutional amendment, his right to equality and freedom from discrimination would be violated. The nature of violation has not been demonstrated. Looking at the facets of the rights and fundamental freedoms under Article 27, I cannot see any that could be breached by simply asking the President to stay on his lane of constitutional amendment process. Similarly, the guarantee of his political rights, which are specific under Article 38(1), that is to make political choices, to be registered as a voter, and to vote by secret ballot in any election or referenda, have not been violated. The President's role in the constitutional review process has been preserved and is intact. The power to assent to a draft bill passed by Parliament and to request the IEBC to conduct a national referendum for approval of the bill are indispensable roles and essential cogs in the process. Apart from these, the President, as indeed any other voter, is entitled to support a popular initiative by signing it, and in fact, he did so in public. Indeed, nothing stops the President from campaigning for or against the initiative. For these reasons, I agree with the learned justices that to the extent that the President took certain steps and actions at the inception of the popular initiative process, as explained, the entire process was irredeemably flawed. I would, in the result, affirm the conclusion of the Court of Appeal. The third framed issue is on the second schedule to the draft bill. The number of constituencies today, by dint of Article 89(1), stands at 290. The superior courts below were unanimous, and I am in agreement with them, that Article 89 is amendable in accordance with Chapter 16 to increase or even decrease the number of constituencies as proposed. The quarrel with the second schedule relates to paragraphs 1, 2, and 3 of the draft bill. After delimiting the constituencies for the National Assembly to 360, an additional 70 constituencies, the schedule sets out the manner and the period of review of the names and boundaries of those constituencies. This task, in terms of the Constitution is donated to the IBC, the period being at intervals of not less than 8 years and not more than 12 years, but on condition that any review must be completed at least 12 months before a general election of members of parliament. Furthermore, if a general election is to be held within 12 months after the completion of a review, the new boundaries cannot be used in that election. The second schedule went against Article 89 and all that I've said by providing only for a single criterion, the population quota, as the basis for delimitation. It went ahead and distributed the newly created 70 constituencies to specific counties. It directed the IBC to delimit the boundaries on the new constituencies on the single criterion. It ignored the irreducible constitutional consideration and the existing scientific criteria in Article 89. And finally, it ignored the principle of public participation. In view of the foregoing, the inescapable conclusion is that I'm in respectful agreement with the learned justices of the Court of Appeal that the second schedule to the bill was inconsistent with the Constitution, to which extent it was correctly so declared. I would reject this ground of appeal. The fourth issue is on presidential immunity. In his petition, Force 26 of 2020, Isaac Alochier versus Uhuru Muigai Kenyatta, Mr. Alochier asked the court to determine whether the president can lawfully initiate a constitutional amendment through a popular initiative process, whether the president can establish a steering committee, and whether the steering committee had locus standi to promote constitutional changes pursuant to Article 257. It also sought from the court to determine whether civil court proceedings can be instituted against the president during the tenure of office in respect of anything done or not done in excess of powers donated by the Constitution. Before us, while highlighting his submissions, Mr. Alochier complained that the two superior courts below made pronouncements that were wider than his original prayers, where he had only sought a declaration that the president had acted outside the functions of his office by unlawfully establishing the steering committee, for which he ought to have been held liable. The Court of Appeal, having arrived at the conclusion that the president was not heard in his defense on allegations of breaching Chapter 6 of the Constitution, it was moot to consider whether the president was properly sued in his personal capacity, all the orders made against him in that capacity having been set aside. Consider, too, that both courts nullified the popular initiative on the ground that the president was not qualified qua president to initiate it, confirming that his actions, the gazette notices and so on, were official. Mr. Alochier's question was effectively answered, that no civil proceedings could be instituted against the president in his personal capacity in respect of his role in the proposed amendment. That would have been sufficient to conclude this ground. I cannot agree more that the route taken by the High Court and the Court of Appeal in responding to Mr. Alochier's contention was respectfully slightly overboard. Their determination of the matter in the manner they did has, however, presented a chance to this court to express itself directly on the question for the first time. Under Article 131 of the Constitution, the people of Kenya acknowledge the immensity and the enormity of the office, and declared that the president shall not hold any other state or public office except that of the president. Again, because of the exerting nature of those responsibilities, the Constitution grants the President immunity to enable him or her to discharge the functions enumerated above with as much freedom, flexibility, and peace of mind as possible. Because the President's actions while in office are actions of the state and not personal, any person who is aggrieved by the exercise of state power by the President has a recourse. First, to challenge the action in court by naming the Attorney General as the respondent in a judicial review application or a constitutional reference. Or secondly, to institute civil action at the end of the President's tenure, because Article 143.3 holds the time from running for the wrongful actions committed while in office until the President leaves office. And of course, there is the option of impeachment motion, which may be moved in Parliament against the President for engaging in gross violation of the Constitution or of the law, or committing a crime under national or international law, or for gross misconduct. The Court of Appeal fell into error in the manner it construed Article 143 of the Constitution, and for these reasons, I would set aside the judgment of the Court of Appeal to the extent explained. The fifth issue was the place of public participation. The twin questions before us are specific. The place of public participation under Article 10 in relation to the role of IEBC under Article 257(4) of the Constitution, and whether there was public participation generally in respect of the draft bill. Public participation today is a constitutional imperative, recognized as one of the principles of good governance and accountability. A reading of Article 257(4), the role of IEBC is to verify that the initiative is supported by at least 1 million registered voters upon receipt of the draft bill and the 1 million signatures. I've already, in the previous paragraphs, found, in agreement with the two courts in respect of the delimitation of constituencies, that there was no public participation. However, in respect of Article 257(4), the role of IEBC does not extend beyond verification that the initiative is supported by at least 1 million registered voters, without going behind the process to inquire if the promoters did conduct public participation. It is the duty of the promoters to carry out public participation before or as they collect signatures. On their own volition and initiative, the promoters make a proposal to amend the Constitution. They must persuade 1 million Kenyans to vote in support of their venture, to convince the assemblies and parliament about the prospects of the initiative, and ultimately Kenyans in a national referendum. It is the promoter's burden. Was there public participation by the promoters and later by the assemblies and parliament? According to the Secretariat, according to the steering committee, both houses of parliament, some county assemblies, Honorable Odinga, there was public participation prior to and in the course of signature collection. Whether or not there was public participation is a matter of evidence. The burden of proof is always upon him who affirms and not on the one who denies. The burden was upon those who allege that there was no public participation to prove that assertion. Not a single person was presented to support the statement and to rebut the evidence in support of public participation. In support of public participation at the two levels, that is the promoters on the one hand, county assemblies and parliament on the other, there was sufficient evidence. For these reasons, I would set aside the determination of the Court of Appeal on the question of public participation. The sixth issue is on the composition and quorum of IEBC. And it is a common factor that IEBC was not fully constituted when the bill and the signatures were presented to it. Not fully constituted in the sense that it did not have its full complement. The vacancy started with the departure of Commissioner Akombe, who fled the country and announced her resignation while abroad on 18th October 2017, 16th April 2018. Commissioners Mwachanya, Dr. Kibiwot Kurgat, and Consolata Nkatha was the vice chair, held a press conference at which they announced their immediate resignation. By a Gazette notice of 14th April 2021, the President formally declared the 4 vacancies. The vacancies were not filled until September 2021, nearly 4 years from the date of those resignations, and 1 month after the decision of the Court of Appeal in this very matter. Article 250 of the Constitution is what may be called a provision of general application for the reason that it applies to all the Chapter 15 commissions. It declares that each commission shall consist of at least 3 members, but not more than 9. Section 5 of the IEBC Act has fixed the membership at 7, the chairperson and 6 members. For the conduct and regulation of business and affairs of IEBC, Section 8 of the Act refers to the second schedule, which at paragraph 5 provides for a quorum of 5 members. I've discussed in my main judgment the amendments in 2017 to this paragraph, how it was challenged in the case of Katiba, and the decision of Mwita J. I have also considered the effect of the decision in Isaiah Kibiwot Kangwon case, considered too the CKRC report on the management of elections, the Hansard recording the debate on the Election Laws Amendment Bill 2017. I have taken into consideration international best practices and borne in mind that IEBC is a body corporate with perpetual succession. The IEBC, whether fully constituted at 7 members or with the minimum number of 3, is responsible for the formulation of policy and strategy, as well as providing oversight. The Secretariat and supporting units, directorates, divisions, and committees, being the professional and technical arm of the IEBC, perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the commissioners. It is therefore a contradiction of terms for the Court of Appeal and the High Court to say in the same breath that the IEBC was properly constituted with 3 commissioners but lacked quorum to transact business and conduct its affairs. I arrive at the conclusion that with 3 commissioners, the IEBC was properly constituted, quorate, and competent to carry out all its constitutional and statutory duties. In the result, I would set aside the conclusion by the Court of Appeal that the IEBC lacked the necessary quorum to conduct any of its business under Article 257 of the Constitution. The final framed question is on the referendum question. Whether Article 257(10) of the Constitution requires that proposed amendments to the Constitution be submitted as separate and distinct referendum questions or question was raised by Mr. Murara. Again, the details of my analysis of this issue is contained in my judgment, where I have explained in conclusion why I think the issue was premature. Noting that the draft bill had not been returned to the IEBC from Parliament, IEBC had been restrained by an order of injunction from facilitating and submitting the draft bill to a referendum or taking any further action to advance it. The nature of a question or questions to be framed by the IEBC was not ripe. In the end, the Court of Appeal erred in failing to set aside the determination of the High Court on this issue for violating the doctrine of ripeness. I would set aside the majority decision of the Court of Appeal to the effect that Article 257(10) of the Constitution requires the specific proposed amendments of the Constitution to be framed as question or questions. The details of what I've just rendered is in my main judgment. I thank you, Judge President.
Thank you, Justice Ohuko, for rendering your opinion. I will now call upon the Honorable Mr. Justice Renaura to read his opinion.
Thank you, Chief Justice, colleagues and counsel. My judgment is 149 pages. I will greatly summarize it for purposes of this delivery. And there's a presumption that all counsel can read. So please do read it, because other teachers of law tell me that counsel hardly read judgments these days. Please try and read these ones. 2, I have read the judgment of the Chief Justice and President of this court, and I will adapt it for purposes of my judgment. I also agree with the reasoning and findings, save where I shall express myself to the contrary. In that context, when the Kenyan people gave themselves the Constitution 2010, it was a matter of public knowledge that certain parts of it would require amendments at some point in the future. There was, however, no agreement as to what these parts were, and it was left to a political class to raise a number of issues over the years that debatably required amendment. Third Way Alliance, for example, initiated the Punguza Mizigo, Lighten the Burden initiative at a referendum on a number of issues. That initiative failed. I have therefore taken into account the pleadings, the submissions, and my opinion on each issue is summarized as follows. On issue number 1, I delved into the history, the genesis and history of the basic structure doctrine. Like my colleagues before me, I looked at Kesavananda at length and the history of Kesavananda and the findings in Kesavananda. I also delved in the history of Article 257 on amendments through a popular initiative as opposed to legislative amendment under Article 256. I specifically looked through the CKRC reports, and in the final report, I reproduced sections, page 75, where the Commission said this: a distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions, which should include supremacy of the Constitution, the Bill of Rights, land, the judiciary, security, finance, and the system of government. The final report then came up with the following recommendations. I'll only pick on 2. Recommendation number A: the new Constitution should have some entrenched provisions. For example, human rights that Parliament does not have power to amend. And Roman D2, the entrenched provisions should include the procedure on amending the Constitution itself, the provisions establishing the Republic of Kenya, the provisions of sovereignty of the people, the provisions on supremacy of the Constitution, the Bill of Rights, the separation of powers, provisions on existence and powers of independent commissions and bodies. Those proposals by CKRC are important because, like Professor Migai Akech, amicus curiae, I have said that the above recommendations are what morphed into Chapter 16 of the 2010 Constitution, and by those provisions, the people attained the right balance between constitutional flexibility and rigidity and provided sufficient and strong safeguards against the culture of hyper-amendability that characterized the Independence Constitution. Chapter 19, in fact, of the Boas draft and Chapter 19 of the Wako draft are also identical as to what is contained in Chapter 16 of the Constitution today. History has shown us that the people did not intend to immunize the 2010 Constitution. To the contrary, they envisioned that they could amend the provisions of that Constitution through exercise of secondary constituent power, provided that the amendment procedure under Chapter 16 is strictly observed. If the people wanted to entrench provisions other than those set out under Article 255(1) or to immunize any of the provisions of the Constitution, they would have done so expressly. It is therefore correct to say that courts should not, by judicial craft or innovation, impose hurdles to prevent the people from amending the Constitution, provided that procedural requirements under Chapter 16 are complied with. In my judgment, I made reference to my own decision in Commission for the Implementation of the Constitution versus the National Assembly of Kenya and two others. I had counsel in this court say that that was the introduction of the basic structure doctrine by courts in Kenya. That is not anything near the truth. That judgment was addressing amendments by Parliament to Article 260 of the Constitution in order to remove the office of members of Parliament, members of county assemblies, judges and magistrates from the list of designated officers under that article. The dispute, much like Kesavananda, related to the amendment power donated to Parliament under Article 256 and not the popular initiative processes under Article 257 as read with Article 255. In that judgment I said, where the basic structure or design and architecture of the Constitution is under threat, this court can generally intervene to protect the Constitution. The threat was from Parliament and not the people. At the hearing of this appeal, I posed a question. What matters are outside Article 255 and which form the basic structure of our Constitution and which require exercise of the primary constituent power? I got no satisfactory answer precisely because, in fact, there are no such matters. And Article 255 speaks for itself. The issues that are ring-fenced from Parliament's amendment powers are set out in that article. I will not repeat them. These provisions cannot be implied because they're expressly provided for by this Constitution. I have also, in my judgment, separated amendments of a Constitution and constitution making. The courts below fused amendment and constitution making. If you look at what the people of Kenya did prior to 2010, civic education, public participation, constituent assembly, and the referendum, they were making a constitution. They were not amending a constitution. So that any attempt to fuse the two processes would be wrong. And I have said why in my judgment. I've also referred to other jurisdictions, to Taiwan, to Malaysia, to Singapore, to Israel. And I have said in my judgment that each country has taken a different approach on the basic structure doctrine because each country has its unique circumstances, and we must do the same. I've also looked at the Njoya case, and I've explained why the Njoya case, the circumstance it was made, the context in which it was made, and the reason why the Njoya case cannot be relevant in processes under Article 257. And going to the four sequential steps, I've said those processes are indeed relevant and useful, not in amendment under Chapter 16, but making of the Constitution, should we as a country ever decide again to do with the present constitutional order and create a new one. And therefore, in summary, on issue number one, my finding is that the basic structure doctrine does not apply in Kenya in the manner suggested by the first, the fifth respondents, and that the four sequential steps set out by the High Court and the majority of the Court of Appeal only apply when a new constitution is being made and not in any amendment process under Article 257. In addition, based on our history, the text of our Constitution, and the context as outlined in my judgment, it is legislation such as the CKRC Act 2008 and 1997 that the four sequential steps should be anchored when and if the people ever want to change the present constitutional order. Those are my findings on issue number one. On issue number two, I have read the Chief Justice's judgment. I have looked into the history of Article 257. And if you look at the CKRC reports, Article 257 was intended to be exercised by the common man and civil society, and not anyone outside that category. I have therefore no hesitation in holding that the President cannot and should not initiate amendments to the Constitution under Article 257. Like Toyota JA, I'm certain that popular initiative is people-centric, and while the President has certain rights as a citizen, there are certain other things that are curtailed by the Constitution as regards him. The President cannot initiate the process by collecting 1 million signatures and crafting an amendment bill and then retire to await the same bill under Articles 257(9) and assent to it as President. That is an absurdity that could not have been the intention of the framers. Neither can he initiate a bill under Article 256 5A, and then under B, request the IEBC conduct within 90 days a national referendum for approval of the bill and then retire to assent to it as a president. And therefore, my finding is that he cannot initiate a popular amendment under Article 255. But I've said, knowing the politics of this country, if the president has parliamentary muscle, he can then invoke Article 256 and initiate amendments through Parliament. On the second limb of this question, I have disagreed with my colleagues. My finding is that there are two processes involved in this whole situation. The first process is the presidential political process, which ends with the creation of the steering committee. And then there is the process under 257.1, which is the process of the secretariat led by Junet Mohammed and Dennis Waweru. And I've said that if you look at 257 properly, the process begins with the signature collection and creation and the drafting of the bill or suggestion. And that process was only undertaken by Dennis Waweru and Junet Mohammed, and there is no place in which I have found in the record the role of the president. And therefore, on that narrow issue, I have disagreed with the Chief Justice. On the second schedule of the Constitution of Kenya, whether it's unconstitutional, I have looked at Article 89.1, and I have said you cannot, as that was done by the initiators and promoters, purport to amend Article 89.1, leave Article 89.2 to Article 89.12 untouched, and then purport to bring this amendment bill and create new constituencies without involvement of the IEBC and the people, especially those who would be affected by the creation of new constituencies. Boundaries of constituencies are a very emotive question in Kenya, and that is precisely why Section 89 is very elaborate as to the procedure to be undertaken when new constituencies are being created. And therefore, for those reasons, and for the reasons given by the Chief Justice, I've agreed that that schedule is unconstitutional. But I've said something a little more. Let those who wish to create new constituencies follow the process under 89. Do not ignore IEBC, don't ignore the people, and if you wish to start the process within Section 89, Article 89, you are permitted to do that, but do not go outside the remit and permits of Article 89. That takes me to issue number 4, proceedings against the President. I agree with the Chief Justice on this question, and I've also addressed the remedy of impeachment of the President should there be a violation of the Constitution. I've also addressed my judgment in the High Court in the Isaac Aluochir case on representation of the President by the Attorney General when the President is sued in his personal name. I have said that the President cannot be sued in his personal name for violations of the Constitution, and should he be sued for whatever reason, then the proper respondent should be the Attorney General and not the President in his personal capacity. I had lawyers for the President pray for costs in favor of the President for having been properly sued in his private capacity in this case. While I agree with them that such an order would have been efficacious, in fact, the nature of this particular litigation being in the public interest, I would not grant the President orders of costs, despite my findings in his favor. On issue number 5, public participation by the IEBC and the initiators and promoters of the bill, I have looked at the BAT case, a recent decision of this court. I've also looked at Justice Pauline Nyamoya's judgment in Republic versus County Assembly of Kirinyaga, and I've agreed with the judge that in processes under 257, there are certain rules attributed both to IEBC and to the initiators and promoters. Looking at the stage at which the IEBC was stopped, or the whole process was stopped, it is very difficult for me to say that public participation was not sufficient. In fact, the two most important public participation elements in a popular initiative are voter education by the IEBC and popularization of the bill by the promoters. None of these processes had been reached by the time the High Court stopped the process. A last issue on this point is this. Gatembo Kairu and Tuyot raised a fundamental question. Why are we as a country still struggling with lack of a legal framework to govern processes under Article 257? There is no law on collection of signatures. There is no law verification of those signatures. There is no law on how county assemblies should pass the amendment bill, the processes by Parliament despite the standing orders, the receipt of the bill by the President, transmission of the bill to the President, the referendum. I have said it is about time to avoid the confusion that I'll address shortly as address issue number 6 and 7, that we need a law. And so I agree with Justice Tuyot and Justice Kairu that this law is absolutely necessary. And therefore, the second schedule, in my mind, is an exception. The public participation processes were properly undertaken, save for the second schedule, where I have said that it's unconstitutional for the reasons that I've given. Articles 88 and 250 with regard to composition and quorum of the IEBC. I have looked in my judgment at the Katiba case by Chacha Mwita J. I have looked at the Isaiah Biwott case by Frida Okwan J. I have looked at Article 250, sub-Article 1. I have taken into account the very lucid submissions by Esther Angawa regarding Article 88.5, and I have said that, to my mind, looking at the law as I understand it, IEBC was correct at all material times, its processes were lawful, and therefore a contrary finding would, in my view, be in error. There was a second issue raised by Ms. Kituku regarding nullification of the laws. Well argued as the point was, and lucid as arguments were, I've declined the invitation to address that question, because once I've found IEBC correct, other matters are irrelevant. The last issue is issue number 7, on the proposals, whether proposed amendments should be submitted as separate and distinct referendum questions. Like the Chief Justice, I have looked at the law of ripeness and mootness. I have looked at the law on justiciability, and I have come to the firm conclusion, like Justice Tuyot, that this question was premature. IEBC had not had the opportunity to exercise its mandate as the body to conduct the referendum, to draft the question or questions, and I've said only this as regards that mandate. Section 49 of the Elections Act and Article 257 do not sit well together. And I've asked IEBC to, as they reconsider this question, to look at Section 49 of the Act and Article 257, harmonize the language. I've shown why, in my judgment, why there's a problem with that issue, and only then would any party with a dispute go to court once the IEBC has determined the matter within its mandate. Once courts start taking off the mandate of independent commissions, we shall walk into a minefield. And therefore, in conclusion, summary of my findings are as follows. On the basic structure is my finding that the doctrine as enunciated in the Casavanada case has not attained wide acceptability and cannot certainly be applicable to Kenya, noting our history, context, and constitutional text. The 4 sequential steps identified by the High Court as necessary in an amendment process are also not applicable, save in the creation of a new constitutional order, which is not the case in this dispute. Number 2, on whether the President can initiate a popular initiative to amend the Constitution Article 257, it is my finding that he cannot, but I've said also that in this particular dispute, he did not. On whether the second schedule of the Constitution is unconstitutional and purported to limit boundaries without the input of IEBC, without amending Article 89, 1 to 12, without involving affected persons and the public at large, I have held that it is indeed unconstitutional. Can civil proceedings be instituted against the President during the term of office? I have said no. And should he be sued, then the proceedings should be against the Attorney General, and any remedy for a suit directly against the President should lie in costs awardable to the President. On public participation, at the time the High Court stopped the process, I cannot find reason to fault either IEBC or the initiators and promoters, with the exception of the second schedule, which I found to be unconstitutional for inter alia lack of public participation. On the quorum of IEBC at all material times, I find that IEBC was correct and all its undertakings were lawful. On the question whether referendum single multiple questions should put the people by IEBC, I find the matter was premature and was not ripe for determination. On costs, the public interest exhibited in this matter will lead me to the conclusion that each party should bear its cost. My reasons in detail are contained in my judgment, which you shall get copies of. I thank you, Chief Justice. I thank you, Counsel.
Thank you, Honorable Mr. Justice Renaura, for rendering your opinion. I will now call upon Lady Justice Jokindongo to deliver her opinion.
Thank you very much, Chief Justice. I will proceed to summarize my judgment. On some issues I will be brief, others I will interrogate them a little bit more. Issue number one, is the basic structure doctrine applicable in Kenya? In order to determine whether the basic structure doctrine is applicable in Kenya, there is need to define the term doctrine under international law and establish whether the basic structure doctrine is indeed such a doctrine and if it is applicable here. I recognize that there are differing opinions on the definition of a legal doctrine, but to my mind, the basic structure doctrine as presented by the parties to us is a judge-made law emanating from the municipal court, which is the Supreme Court in India, in the Kesavananda case. That basic structure doctrine has been upheld and relied on in subsequent decisions in India, and I note that there are few jurisdictions around the world where basic structure doctrine has been applied, while in others it has been rejected. It is my considered view that the basic structure doctrine as presented by the parties does not constitute a widely adhered to a legal doctrine. It is my observation that the basic structure doctrine has been both applied and rejected. I have listed the countries in which that has happened, and therefore it is my considered opinion that the states only constitute a very small percentage of countries in the world that have attempted to apply or have applied the doctrine. Furthermore, there have been no pronouncements made at the international level, no international case law on the same. The only available cases are from domestic courts at national jurisdiction, and therefore it cannot be said that the basic structure doctrine has attained the status of a general principle under international law, and it cannot be applied by this court as a general rule of international law as contemplated on Article 2(5) of the Constitution of Kenya 10. The above notwithstanding, is the basic structure doctrine as presented by the parties applicable in Kenya? It is my considered opinion the answer to this question can only be deduced by our constitutional past. Kenyans stressed the fact that they needed a constitution that had entrenched provisions on certain aspects, was not too simple to amend, and one that required their participation in terms of amendment. The final report of the Kenya Review Commission captures these sentiments where the people's voice is summarized. And these sentiments made it into our current constitution, where Chapter 16 of the Constitution is unequivocal on how to amend the Constitution. It is therefore my position that it was the intention of the drafters of the Constitution to protect or entrench the specified 10 matters in Article 255(1) by stipulating their specific amendment procedures. If the drafters of the Constitution intended to entrench or protect any other provisions or deem them eternal or unamendable, they would have expressly done so. On my part, I do not consider any article in the Constitution unamendable or constituting eternity clauses. A textual reading of the Constitution confirms this view. It is evident, therefore, that the Constitution itself expressly provides an inbuilt amendment procedure for any anticipated amendments, consequently, reasons which I shall expound upon. However, before I expound on my views, I must state I am rather disturbed and concerned by the way the superior courts framed their issues for determination. The High Court framed its issue 3 for determination and used words not in the constitutional text, attached meaning to them, and made determination on them. At paragraph 388 of its judgment, the High Court framed the issue as follows. What is the constitutional remit of amendment of the Constitution through a popular initiative? This issue further twins into two sub-issues. Who can initiate a popular initiative under our constitutional setup? And two, the BBI process, is the BBI process of initiating amendments to the Constitution in conformity with the legal and constitutional requirements? And 5, was the President in contravention of Article 73(1) of the Constitution for claiming authority and purporting to initiate constitutional changes through BBI? Similarly, at the Court of Appeal, Musinga, President of the Court of Appeal, listed the following issue for determination: whether the President of Kenya can initiate the process of amendment of the Constitution as a popular initiative, and who the initiators and the promoters of BBI initiative were. The learned judges of appeal unanimously agreed with the High Court that the BBI amendment process under Article 257 of the Constitution was intended for ordinary citizens. Further, they stated that this is a citizen-conceived, citizen-initiated, and citizen-driven process. A lot of time and attention was dedicated to the meaning of certain words. This would not be problematic if these words were found within the body of the Constitution to interpret an appropriate meaning to them. However, interpretation of words not in the Constitution bring confusion. In my view, a constitutional court must confine itself to interpretation of the letter of the Constitution, and if any word or phrase is read in, it must be clear that this is the rule of interpretation at play. The words I'm concerned about include initiate and initiator, citizen initiated, and private citizen. None of these words appear in Articles 255 to 257 of the Constitution. The High Court in particular went on a spirited approach to expound on these terms and paid little attention to the words that actually appear in Chapter 16 of the Constitution, which are the words promoter, popular, and initiative. In my opinion, the learned judges introduced a non-constitutional actor called an initiator, who performs a non-constitutional action, initiate, when the Constitution only provides for a promoter whose definition is vastly different from an initiator. As such, the emphasis was laid on the actor initiator. This, in my opinion, fundamentally changed the import and meaning of Article 257 of the Constitution, and I am of the opinion that the correct approach should have been to define what a popular initiative is and who can be or who is a promoter of a popular initiative. The Superior Courts ignored the fact that the drafters of the Constitution used certain words and went in to read in words whose effect is to change the entire meaning of the constitutional text. The tool of reading in is only applied where the framers have left out a word or phrase from a provision. Further, this reading in must be supported by other connected provisions of the Constitution. I have perused carefully all the judgments, looking for proper reasons for the decision to exclude the President from the amendment process, and I cannot find a logical, constitutionally based explanation for the conclusions and findings of the Superior Courts on this question. I can only term it as interpretational misadventure, if not judicial constitutional overreach or judicial invention. As such, the learned judges erred fundamentally on this, and in my considered view, which I shall now expound on, I will specifically look at the constitutional amendment process as provided for in Chapter 16, the interpretation of constitutional silences, the exercise of the authority of the people under Article 1, the authority of the President under Article 131 and 132 and 141(3), and the political rights under Article 38. The Constitution 2010 provides for two processes through which it can be amended. These are the parliamentary initiative and the popular initiative. For the popular initiative, promoters, after collecting the signatures of at least 1 million voters, submit the signatures and the bill to IBC, who sends the bill to the counties. The bill must then be approved by a majority of the county assemblies, and then approved by a majority of the Houses of Parliament. And if Parliament passes the bill, it is submitted to the President for assent. It then goes to referendum, where the majority of voters must support it. Article 257 does not define popular initiative. Nevertheless, I am of the opinion that at the heart of construing the meaning of popular initiative, it lies with the numbers. It is proper to lay emphasis on the numerical value of at least 1 million registered voters who have to sign, the numerical value of at least half of the counties who have to vote to support, the numerical value of 2/3 of the votes in both houses in Parliament, and the numerical value of half the votes cast by registered voters at the referendum. It is the numbers that count. It is the numbers threshold that the promoter must meet. It is the numbers that makes the initiative popular. In the context of Article 257 of the Constitution, a promoter needs at least 1 million registered voters to support their proposals. That's what triggers the IEBC verification process. It is therefore my considered view that the popular initiative is primarily about numbers that the promoter must attain and not about who the promoter is or who the person who brings the amendment is. As such, the Superior Courts made a fundamental error by determining that popular, the word popular, relates to who moves the amendment and not the numerical threshold that the promoter has to attain. So, for example, in 2016, the Court of Coa Kenya Bill were not able to achieve the 1 million signatures, and it collapsed through the operation of the law. It is important to note also that Section 257 does not in any way specify who may move a constitutional amendment process by popular initiative. It does not contain an explicit bar against any person promoting a constitutional amendment by popular initiative. It specifically provides what actions the promoters are tasked with in order to begin and complete an amendment process, but it does not state who the promoters must be. The unsaid is influential in constitutional law. Some matters of constitutional relevance sometimes are left unaddressed. Sometimes, knowingly or unknowingly, the drafters of the Constitution may underappreciate how much power rests in the silence around the text. Constitutional silences are functional and inevitable, and enabled by a lack of very strict textual restraints, constitutions have the capacity to grow with time, experience, societal needs and changes, thus allowing successful constitutions to thrive. This Supreme Court has played a crucial role in interpreting silences in the Constitution, but it must be cautious, though, so as to avoid judicial legislation. This court must interpret silences judiciously. Taking recourse to this doctrine, therefore, how do we interpret the silence as to who can originate a popular initiative amendment? In my considered view, the first step leads us directly to the constitutional text itself. Article 1 of the Constitution is categorical, that all sovereign power belongs to the people of Kenya and shall be exercised in accordance with the Constitution. Further, in that article, sovereign power may be exercised either directly or through their democratic elected representatives. The National Executive enjoys delegated sovereign power under Clause 3 of Article 1 of the Constitution, and according to Article 36(1) of the Constitution, the President shall be elected by registered voters in a national election conducted in accordance with the Constitution. In addition, Article 1 of the Constitution elaborates the tenets of a functioning republic, anchored in the concept of libertas populi, which defines the characteristics of a functioning republic. It envisions a system that has responsible citizens who exercise their rights democratically and consciously. A free res publica is the highest value of all for citizens. Article 1 preserves the exercise of the actual legal authority of power, which is exercised by the people directly or through their democratically elected representatives. From the foregoing, there is no doubt that the President is a democratically elected representative of the people who, under Article 1, can exercise delegated sovereign power of the people. Indeed, this is one of the ways in which constituent power is exercised under our Constitution, and therefore I am confounded by the fact that the Superior Courts address the constituent power of the people at length, but for whatever reason fail to take into account that the President is a directly elected representative of the people and he can exercise delegated power on their behalf. Furthermore, it is a fundamental right of the Kenyan people to elect their representatives and that those so elected to speak on their behalf. To limit the ability of an elected representative to speak, to act, to work, on behalf of his or her electorate is itself a limitation of the people's political rights under Article 38 of the Constitution. Such proposition would amount to limited republicanism, limiting the extent to which people exercise their powers either directly or through their elected representatives. More poignantly, however, limiting the powers of the people donated to the elected representatives reorganizes the architecture of the Constitution's order of delegated governance. It is not in dispute that the President bears an elevated status by virtue of his office. The President has additional roles and obligations in comparison to the ordinary Kenyan. In addition, Article 132 of the Constitution mandates the President to safeguard the sovereignty of the public, promote and enhance unity of the nation, promote and respect the diversity of the people and communities of Kenya, and ensure the protection of human rights and fundamental freedoms and the rule of law. Article 132(1)(c) of the Constitution stipulates one of the many mandatory functions of the President. The President must, once every year, report in an address to the nation on all measures taken and progress achieved in the realization of the national values referred to in Article 10. In my considered view, the President is not limited as to those measures he can take he is not limited as to the measures he can undertake in the exercise of his functions under Article 132. The said measures could constitute a policy, statutory, or constitutional frame. Clearly, in promoting and enhancing national unity, the President can promote constitutional amendments through popular initiative. This would qualify as a measure taken under Article 132 on which progress achieved can be reported. It is directly within the four corners of the Constitution of Kenya. I am convinced that when the President takes measures in the exercise of his functions, including a proposal for the amendment of the Constitution, he is bound by the oath prescribed by the Constitution and which he swears when he takes office to act in the best interests of Kenyans and not to undermine democracy. One need not worry about the President overstepping because the parameters in the Constitution are sufficient to rein him in. How can I claim this so boldly? This is informed by our constitutional history. When one looks at the history of constitution making in this country, it is clear that one of the intentions of the drafters of the Constitution was to discard parliamentary monopoly over the constitutional amendment process and to make it more inclusive. Kenya's journey to democratic constitution was arduous, taking into account that most of the amendments made in the taking into account most of the constitutional amendments made in the first President Kenyatta's era. In the first President Kenyatta's 15-year reign, he oversaw 16 amendments. President Moi, in his 24-year presidency, oversaw 14 constitutional amendments. Both presidents were members of parliament and used parliament to amend the constitution in a manner that excluded participatory democracy. The people were not involved in any way. By 1992, and because of this, all key institutions, the judiciary, parliament, public services, security forces, and the provincial administration were instruments of authoritarian control. Concentration of power in the president was one of the factors that prompted demands for a new constitution, and the 2010 constitution aimed to curb dictatorship by parliament in the amendment process. Kenyans wanted to have a head of state who would not whimsically amend the constitution. They wanted to limit the powers of the constitutional amendment by the head of state, but not to take it away altogether. In other words, the intention was to make it difficult, but not impossible, for a president to make a constitutional amendment. This is the mischief that the framers of the Constitution sought to address. In my considered view, therefore, there is no historical evidence that the drafters of the Constitution intended that the President be excluded from the popular initiative amendment route, or that it be limited to a specific class of people to the exclusion of others. If anything, the resultant very expansive Chapter 4 on the Bill of Rights in the Constitution of Kenya 2010 proves otherwise. The President enjoys all constitutional rights and freedoms like any other Kenyan. He is first and foremost a Kenyan citizen by birth. A president does not lose his or her political rights under Article 38. he or she does not cease to be a registered voter by virtue of ascendancy to presidency. There is no law pursuant to Article 24 of the Constitution, which is the limitation clause, that limits the president from enjoying political rights under Article 38, especially that of campaigning for a political cause, which in my view includes constitutional amendments. In addition, trusting citizens with public office does not in any way muzzle them or take away their rights as provided in the Bill of Rights. Article 27(1) of the Constitution provides that every person is equal before the law and has the right to equal protection and equal benefit of the law. Additionally, equality includes the full and equal enjoyment of all rights and fundamental freedoms, and the President, like all Kenyans, is obligated to respect, uphold, and safeguard the Constitution. If any Kenyan has the right to initiate a popular amendment to the Constitution, while respecting, upholding, and defending the Constitution, so too does the President in his official or personal capacity. It would be restrictive, unjust, unprogressive, and unconstitutional to limit that right. At this juncture, I find it prudent to comment on the submissions that the President is excluded from promoting changes to the Constitution by popular initiative because he can do so through Parliament. According to Article 256 of the Constitution can only be amended through a parliamentary initiative. Under Article 256 of the Constitution is silent as to who can introduce a bill into either of the Houses of Parliament. However, the composition of Parliament is clear, and the membership of the National Assembly is provided for under Article 97(1), and that of Senate under Article 98(1). The President is excluded as a member of Parliament. In other words, the President is not a member of Parliament, and by parity of reason, he cannot introduce a constitutional amendment through a parliamentary initiative. Apart from making the finding that the President cannot initiate constitutional changes, the Superior Courts also found that state organs similarly cannot initiate such changes. However, it is important to note that all state organs and state officers form part of the national executive, county governments, the legislature, the judiciary, independent commissions, and independent offices. Accordingly, then, all holders of such offices under Article 1 also exercise delegated power from the people and must perform their functions in accordance with the Constitution. If those functions require measures or policy actions that would require constitutional changes, then they must be able to use their delegated authority to exercise those functions. To suggest otherwise would result in an absurdity. For example, let us assume that Chief Justice, as the chair of the Judicial Service Commission, wishes to make proposals on judicial reforms. And she puts together a draft bill and presents it to the IEBC as a promoter. If we are to follow the findings of the Superior Courts, the Chief Justice would find herself barred from proceeding. However, if her Chief of Staff or the Deputy Chief Registrar were to take the same document, it would be acceptable. Similarly, if the Speaker, as the chair of the Parliamentary Service Commission, wished to make some proposals, constitutional proposals around parliamentary reform, the judgment of the Superior Courts would prevent him from taking such amendments himself, although the clerk of the National Assembly and the head of the legal department in Parliament can do so. The result is leadership without authority. In a democratic government, it is an untenable absurdity. In conclusion, I'd like to say on this point, the popular initiative amendment is not a preserve of specific persons. Any Kenyan can originate and promote the popular initiative amendment, and the people, as defined in the Constitution, also mean their representatives exercising donated sovereignty. As such, it remains an inclusive process and not a process that excludes and that empowers every person to propose constitutional amendments. Having found that the President and the state organs can promote a popular initiative, who then was the real promoter in the impugned bill in the dispute before us? A perusal of volume 34, page 22 226 of Marara Omoke's record of appeal reveals the replying affidavit of Dennis Wawero, whereby he swears that he and Junet Mohammed are the co-chairpersons of the Building Bridges to a United Kenya, created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other things. From the record, IEBC's press release acknowledges the receipt of the Constitutional Amendment Bill 2020 and the 4.4 million supporter signatures. There is also a letter from IEBC which specifically talks of the promoters as Dennis Wawero and Junet Mohammed. It is therefore my conclusion that the promoters referred to in this bill are Dennis Wawero and Junet Mohammed. The record speaks for itself. Further, having perused the Constitution of Kenya Amendment Bill 2020 in Annexure B of the report of the Steering Committee of the Implementation of Building Bridges to a United Kenya Task Force report of October 2020, and the Constitution of Kenya Amendment Bill 2020 dated November 25, 2020, and the promoters' bill that was forwarded to county assemblies and parliament, I make observations that the bills are vastly different in terms of content and proposed amendments. For instance, while the Steering Committee Annexure Bill does not propose amendments to Articles 82, 89, 1, 96.3, 115.4, 168, 188.1, 204, 206, 207, 228, and 250 of the Constitution, the promoters' bill does. The bill as presented by the promoters to the IEBC does not contain some of the amendments contained in the Steering Committee bill, namely amendments to Articles 91, 200, and the repeal and replacement of Article 218, insertion of 218A, amendments to Articles 221, 223, and the repeal and replacement of Articles 246. In addition, there are new Articles 108A, 153A, 206A, which only appear in the promoters' bill and do not appear in the committee steering bill. There are also major differences in the preambles, in the first and second schedule, which are substantially different. So there are two different documents. None of the superior courts examined this fact, leading them to the erroneous conclusion that the BBI Steering Committee, the BBI Task Force, and the promoters were one and the same. Neither Junet Mohammed or Dennis Wawero were part of the BBI Steering Committee or the BBI Task Force, both of which were gazetted by the President. They are similarly named initiative of which their part has no legal nexus with the two gazetted entities. It is clear in correspondence between IEBC and the promoters that they engaged the IEBC as individuals and were not representing any entity, including the President. As I conclude on this issue, I fault the superior courts for making declarations of unconstitutionality without specifically itemizing the article of the Constitution that was either denied, violated, infringed, or threatened. For instance, the superior courts found the BBI process of initiating amendments to the Constitution unconstitutional. Which specific article of the Constitution it offended or threatened, it is still unclear. The superior courts ought to have dissected the issue to specific actions that were taken against the constitutional provisions against which they could be measured. Instead, it would appear that the focus was on actions, actors, and processes which are not within the constitutional ambit, and in particular, which are not to be found under Article 257 of the Constitution. In summary, my finding on the issue is the President did not initiate the amendment process in dispute. He was not the promoter of the popular initiative under 257. I now move to the third issue, which is whether the second schedule to the Constitution of Kenya bill is unconstitutional. Before ascertaining the unconstitutionality of the second schedule, it is important to interrogate the legal standing of the impugned bill. In Black's Law Dictionary, a bill is defined as a legislative proposal offered for debate before enactment. Article 109 of the Constitution says that Parliament shall exercise its legislative power through bills passed by Parliament and assented by the President. In addition, Article 116 of the Constitution talks about the coming into force of laws and speaks of the bill passed by Parliament, assented by the President, shall be published in the Kenya Gazette as an Act of Parliament within 7 days after assent. Accordingly, a bill does not become law until it is passed by the legislature, and the President completes the legislative process by formally assenting or giving his consent to the bill. Articles 2.4 and 165 of the Constitution contemplate scenarios where laws are unconstitutional and can be declared so. The Constitution does not provide for pre-enactment mechanisms to determine whether a bill is constitutional or not. So in this instant matter, the judges of the Court of Appeal did declare the second schedule of the Constitution unconstitutional, but considering that the Constitution Amendment Bill had not yet been promulgated into law, I find fault with the Superior Court's finding on the basis that they did not have jurisdiction to interrogate the constitutionality of a bill before it's been passed into law. I reiterate, it's only after a bill has been enacted and attained the status of a law that the courts acquire jurisdiction to entertain the same. But before a bill is enacted into law or an act of Parliament, the courts don't have jurisdiction to determine the same for lack of ripeness. Now, having found that there's the issue of lack of ripeness, what can this court do? Can it proceed to address the same? And if so, under what circumstances? In the case of Aramat, this court did state that this court's jurisdiction is to develop rich jurisprudence that develops and respects Kenya's history and traditions and facilitates its social and economic growth, and that the Supreme Court is the guardian of the Constitution and the final arbiter. And the same principle was stated in the matter of Speaker of Senate and several other cases of this court. In light, and I've laid out the decisions, in light of all those decisions above, it is my considered view that the issue before us is one that cannot be ignored. However, there needs to be a test to assess whether indeed, despite the lack of ripeness, whether this court can actually address the issue. So this court needs to evaluate the fitness of the issue for judicial determination, and secondly, assess the hardship to the parties and the general public if judicial relief would be denied at this stage. In other words, is this the kind of question that can be determined only when ripe without occasioning any hardship to the parties or general public? I've then laid out a number of cases and writings around the fitness test on issues of ripeness and how one can assess whether an issue is fit despite the issue of ripeness. I do find, having laid out the issues around the test, I do find that in this particular situation that this court can apply the test and we can address the issues despite the lack of ripeness surrounding the bill. Thus, I have perused the second schedule to the Constitution of Kenya Amendment Bill and noted that it seeks to introduce an amendment to Article 89(1). However, the schedule that is attached then purports to amend Articles 81, 2, 3, 4, 5, and 6, but it purports to do this on its own without an accompanying proposed amendment to that section. In the UK Court of Appeal decision, Mohan versus Her Majesty's Senior Coroner for Oxfordshire, Lady Arden observed the follows: it would be contrary to drafting conventions for a schedule to be used to make what should clearly be what has a change or have what will have some change or of consequence in the law. It is improper for a schedule to have matters of principle, and nothing should be placed in a schedule to which the attention of Parliament should be particularly directed. Flowing from the above, I am persuaded that the second schedule to the Constitution Amendment Bill, even if it were to be enacted into law, cannot amend Article 89 of the Constitution. It would be contrary to drafting conventions if the schedule of the Constitution was to propose an amendment to a substantive article of the Constitution on its own. What ought to have happened is that there needed to have been a standalone provision that brought the substantive amendments to Articles 89.2, 3, 4, 5, 6, 7, and 8. Therefore, the second schedule to the Constitutional Amendment Bill conflicts with the substantive provisions of Article 89 of the Constitution, and it is therefore unconstitutional. On issue number 4, on whether the President can be sued for performing functions of his office, I will be brief. The rationale for presidential immunity comes from the enormous responsibility bestowed upon a president as a single source of executive power. Therefore, immunity from legal proceedings is designed to permit a president to just discharge his obligations with as much autonomy as possible without anxiety that court proceedings would probably disturb, humiliate, or encumber him from focusing on his duties. This protection is also envisioned to shield the dignity of the office of the President and not him personally, particularly because he makes far-reaching and sensitive decisions. I have considered the parties' pleadings and submissions, and it's obvious that the point of divergence is whether or not the President is immune from constitutional violations during his tenure of office. It is not contested that the President appointed the Building Bridges, the BBI task force, to document and recommend practical administrative reform processes that will build the country's long-lasting unity and implement modalities for each identified area. The President has a unique position in the constitutional scheme, and as already discussed in issue number 2, he has a responsibility to promote and enhance the unity of the nation. It is my finding, therefore, that if the President... No, I'm sorry. That's not where I want to go. It is my finding that the President, in appointing the BBI task force, was discharging his constitutional mandate, promoting and enhancing the unity of Kenya, and consequently, there is no basis for concluding that the President's actions contravene the Constitution to deprive him of immunity provided for under Article 143 of the Constitution. There is no evidence tabled before the trial court to dispute this, and that his actions were not within the four corners of his constitutional mandate of promoting and uniting the country. One may ask what recourse is available to a party who is aggrieved by the presidential actions or omissions that grossly violates the Constitution and is outside his constitutional function. And Article 145 provides any member of the National Assembly, supported with at least 1/3 of members, the ability to move a motion of impeachment. And that is how to deal with it. To this end, I do disagree with Justice Tuyot on his conclusion that Article 132 leaves it open for the President to be held personally liable once out of office for any act or omission not done in office. And my finding is that the President's actions or omissions entitle him to immunity as provided for in under 143 of the Constitution. I'll move quickly to the next issue, which is public participation. And this is what I'll say. To determine whether the Constitution Amendment Bill 2020 was subjected to public participation within the parameters of Article 257 of the Constitution, we need to examine the steps and inbuilt mechanisms that are provided for therein. In my opinion, the steps are as follows: the submission of the bill and the minimum 1 million signature of registered voters. Then the verification of signatures by IBC. Then the consideration of county assemblies. Then the consideration of the House of Parliament, and then the referendum. So when we go to the first step, Mr. Omoke urged us that the promoters ought to have conducted public participation prior to the collection of signatures. But on this, it is my finding that the collection of signatures is not a constitutional process under Chapter 16 of the under Chapter 16, and the promoters are not under any obligation to conduct public participation prior to the collection of signatures. In order to assess whether the public participation has been conducted in accordance with the specific provision of the Constitution, the test which a court ought to apply is against a particular provision. So to my mind, Article 257 of the Constitution does not first provide for the collection of signatures, but for the submission of a bill with at least 1 million signatures. This, in my opinion, is the first step. And then second, it does not make provision for public participation during the collection of signatures. Having found that Article 257 does not expressly provide for public participation during the collection of signatures, the standard to apply when assessing the same, if any, will be lower than the law, than where the law is expressly provided for public participation. I am unable to agree with the Court of Appeal's findings that there was a constitutional requirement to conduct public civic education at the point of collection of signatures. And I cannot concur with Nambuye's finding that there was need to give the public the reports, the bill in Kiswahili, Braille, sign language before the referendum. Having found that the constitutional amendment process commences with the submission of signatures and that the Constitution is silent on pre-bill procedures, it is my considered opinion that the promoters were not required to take public participation at this juncture. From the foregoing, it is my presumption that when a supporter signs in support of the draft bill, then such a supporter must have read, understood, and agreed to the proposed as amendments, asked questions about any unclear proposal, and taken the decision to be bound by his or her signature. It therefore goes without saying that the promoter, before urging the support of his or her proposal, must talk to people or must have made his bill understood by the people. I disagree that there was no. I disagree with the court's conclusion that there was no public participation during the collection of signatures. And moving on to the next step is to consider whether there was public participation at the county assemblies. I take judicial notice that in compliance with the Constitution and the County Governments Act, county assemblies have standing orders with set guidelines on public participation, and in that regard, a bill in the county assembly, having been read for the first time, is committed to the relevant select committee, where it takes into account views and recommendations from the public and reports back to the county assembly. I've looked at the record, and it's my conclusion that none of the petitioners before the High Court specifically alleged that any of the county assemblies failed to conduct a public participation as per the standing orders. Similarly, there is a similar process before the two houses of Parliament, and there is no evidence that this public participation did not take place. It is my finding, therefore, that there was public participation at the county level and at the House of Parliament. The final step in assessing public participation under Article 257 is at the referendum stage, but we had not reached there. Lastly, on this question of public participation, I believe it is time for the legislature to urgently provide for the parameters of public participation. I recommend it does so through a statutory enabling framework. Such legislation should provide precision and clarity on the various processes involved and address issues like mode, extent, stages, proof of public participation, funding, responsibilities of who does what and when. Does the IBC have the requisite quorum to conduct business? It is my finding that it does. And I'm sorry. And I have then come to the two conflicting decisions in the High Court, which were raised by parties. It is my considered view that even though horizontal stare decisis is not binding on courts of equal jurisdiction, The trial courts need to follow the decision of other judges of the same court unless there are compelling reasons to depart from the same. This is to ensure consistency, certainty, predictability, and sound judicial administration. In this context, having found that paragraph 5 of the second schedule of IBC Act is constitutional, it is my finding that it was justified for the trial court in the Isaiah Biwott case to depart from the Katiba case. Furthermore, in this present case, I'm not persuaded that there existed compelling reasons to warrant the trial court in this case to depart from the Isaiah Biwott case. I have then laid out my reasoning around retrospective unconstitutionality and prospective unconstitutionality, and I think that I will leave that for parties to read when they read my full judgment. Finally, on the last issue, I do agree that the issue is not ripe, like the Chief Justice has stated. However, once again, the fitness and hardship test, which I developed when I was writing issue number 2, I think does apply, and I have made findings that there can only be one question at referendum, and that the provisions of Section 49 are unconstitutional. They are unconstitutional. Thank you very much.
Thank you very much, the Honorable Justice Joaquin Dongo, for rendering your opinion. It is now my pleasure to invite the Honorable Mr. Justice Wanjara to deliver his opinion.
Thank you, Chief Justice and President of this court. Mine is a summarized delivery of my judgment, because I know that, I expect counsel to read the judgment. But even if you don't read, I know that out there are Kenyans who will read it and contribute to the growth of jurisprudence in our country. And so I begin by also acknowledging the fact that I have perused the lead judgment by the President of the Court, and I'm in agreement with how the contents of the background have been captured and the submissions by the parties have been paraphrased. And so this enables me to immediately go into the consideration of the 7 issues that we formulated for ourselves with your concurrence. But before I do that, I must also pay my gratitude to our colleagues at the High Court and the Court of Appeal for their gallantry and industry which they invested in this enterprise. It's due to those efforts that at this stage I can say we now find ourselves in the fog of the season's end, for those of you who read beyond the legal text. And now to the first question, whether the basic structure doctrine is applicable in Kenya, and if so, to what extent. And I begin by acknowledging the fact that never since the promulgation of the Constitution of 2010 have our courts been confronted by so polemical, elastic, and indeterminate notion as the so-called basic structure doctrine. And it all began with when a group of distinguished citizens, aggrieved by what they perceived was an imminent overthrow of the Constitution, approached the court, the High Court in particular, seeking its intervention to stop that overthrow. And I've also, like my colleagues, traced the origin of now what is being called the basic structure doctrine. And I don't think I need to go into the stages, the historical stages of how this notion, in my view, sprouted and continues sprouting in parts of the world. I think that my colleagues who have spoken have done a sterling job, and I do not intend to retrace the history of this doctrine. But I do ask, how did we find ourselves enmeshed in this kind of theorizing? Because right from the High Court and now up to this court, what we appear to be doing when addressing this notion of the basic structure of the Constitution is really a preserve of legal and social science scholars. It is hardly an occupation of court of law, not to mention an apex court of law like this one. So how did we find ourselves in this process? It's because there can be no doubt that in approaching the court, the petitioners had been aggrieved by what they perceived as an imminent threat to the Constitution posed by this amendment bill. But instead, what they should have done, in my view, they would have laid down a prayer in which the alleged the fear of violation of the Constitution, and in support thereof, they were at liberty to deploy any arguments, propositions, and analytic tools to convince the court that indeed such a declaration was warranted. But instead, what we have here is a fundamental departure from a long-established tradition of invoking the jurisdiction of the High Court. The petitioners instead presented the court with a theoretical construct, a fait accompli, whose declaratory validation they sought. And unfortunately, the High Court elevated this proposition as designed by the petitioners into an issue for determination, even at a preliminary level. And later they would be joined by our colleagues at the High Court. But be that as it may, now that the applicability of the basic structure doctrine in courts has snowballed into a ubiquitous inquiry, we at the Supreme Court may not, without stirring justified indignation, disregard it altogether. And so I have been compelled, just as my colleagues have been, to go into an exegesis of what then is the anatomy of this basic structure doctrine. I have asked myself whether indeed it is a doctrine, juristically speaking. I have come to the conclusion, after not just a soul searching, but serious thoughts, that what we are faced with as a basic structure doctrine is no such doctrine. Instead, it is what I consider as a school of thought, or at best, a heuristic device, which a court of law, when faced with the question as to whether a proposed constitutional amendment is of such a nature as to destroy, destabilize, or distort the constitutive authority of the Constitution, a court of law faced with such kind of question can deploy this heuristic device in its effort to answer the question. But I find no fault with this rich and diverse array of opinions, so eruditely crafted by some of our finest in the judicial system, the legal profession, academic institutions, and from far afield by way of amici curiae. And indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of a real or perceived violation of the Constitution. But to begin by seeking a declaration that there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry, first through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra-constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thuds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like, attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that, contrary to what was decided in error, if you ask me, there is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions which are capable of withstanding any efforts from whichever quarter of abrogating it, distorting it, or fundamentally changing its equilibrium. That is the question that we should ask. And when I asked that question, I arrived at an answer in the affirmative. So that leads me to the next issue, whether the President can initiate changes or amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through the parliamentary initiative. In agreement with my colleagues at the High Court and Court of Appeal, I am of a firm opinion, having read the relevant provisions regarding that issue, and in context, I am of the opinion that the President cannot initiate what is referred to as a popular initiative under Article 255 and Article 257 of the Constitution, because those articles talk about an initiative to amend the Constitution by the people. And the word people here is not an ornamental one. It is a serious expression of what forms what we consider a social contract. And both the High Court and Court of Appeal held that such an initiative is reserved for what they call the common mwananchi. But before answering this question, I had to ask myself as to what really constitutes a popular initiative. In my view, a proposal to amend the Constitution through a popular initiative comes into being when there is a felt need for such an amendment by the people. But care must be, however, taken, as advised by Professor H in his amicus brief, not to anjikunize, no, but that's my expression, not to anjikunize every stage of constitution making or amendment. In his comprehensive analysis of the history of the constitution making in Kenya, the good professor, rightly in my opinion, decries the tendency to underestimate the role played by what he calls the political elite in the making of the Constitution of 2010. And why do I agree with him? Because, in my view, a democratic polity such as ours comprises of a complex mix of the ordinary, the elite, and the philosopher, each of whom is entitled to meaningfully participate in the popular initiative of constitutional constitution. At no stage, is very clear to me, is the role of the president, qua president, contemplated by the provisions of that article. It cannot have been lost on a casual observer of our painful history that it was the imperial presidency that mutilated the independence constitution through unchecked amendments to such an extent that at the end of the day, this country had lost any pretensions to democracy, rule of law, human rights, or social justice. And by the early 1990s, the Kenyan people were terrified, tormented, and dehumanized lot, deprived of any sense of self-actualization in the manner in which they were governed. It was from such despondency that the people would rise to demand a new social contract, a new order that would not only restore their dignity, but also prevent the executive arm of government, if you like, read the president, and to a certain extent the legislature, from reversing the new equilibrium, from taking them from the paradigm shift to which they had cutted themselves. And so to this question, I have no hesitation in holding that the president cannot initiate a popular initiative. That takes me quite quickly as to whether indeed the president did initiate this popular initiative. It's on record via the Gazette notice number 514 dated 24th May 2018 that the President appointed a task force named Building Bridges to a United Kenya Task Force, or the BBI task force, if you like. This task force was composed of eminent Kenyans whose mandate it was to address the 9 key challenges facing the country. And these challenges have been identified in a memo of understanding signed between the President and Right Honorable Raila Odinga. Thereafter, the President, Vide Gazette Notice number 264, published on 10th January 2020, appointed a steering committee on the implementation of the to United Kenya Task Force report. One of the terms of reference of that steering committee was to propose administrative, policy, statutory, and constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report. It is out of which the steering committee that we now have the Constitution of Kenya Amendment Bill of 2020. I, on my part, find, although the High Court later described the task force as an unconstitutional outfit, I, on my part, find that there was nothing unconstitutional in the appointment or composition of either the task force or the steering committee by the President. What remains is whether the President can be regarded as having heeded the reasoning by the 2 superior courts. I have looked at the relevant law and I come to a similar conclusion that this second schedule to the Constitution of Kenya Amendment Bill 2020 is actually unconstitutional. Fourth, I consider whether civil proceedings can be instituted against the President in person or a person performing the functions of the office of the President during his tenure of office. And I know I have taken into cognizance the submissions by the Attorney General urging the court to find that such proceedings cannot be instituted against the President or a person performing the functions of that office. I also know that there are those who have strenuously opposed the Attorney General's submissions and have argued that such immunity is limited, so limited that the President can on occasion be sued where or if he violates the Constitution and if he violates any other law when he is not acting in his capacity as the President. And I have, having carefully considered those arguments, I find considerable difficulty in appreciating the rationale or basis upon which first the High Court found that notwithstanding the clear and unambiguous language in Article 1432 of the Constitution, that the President can still be sued in his personal capacity for acts or omissions alleged to be in violation of the Constitution. Why did the High Court introduce the phrase "only protected"? And then turning to the finding by the Court of Appeal, I find similar difficulty because it is clear that should the President engage in an act or omission that is violative of the Constitution, there are constitutionally recognized pathways through which such violation can be put right. And I have mentioned and discussed them in the body of my judgment. But a more profound legal reason for presidential immunity in both its private and official capacity is to be found in Article 1433 of the Constitution, which provides that where provision is made in law limiting the time within which proceedings under Clause 1 or 2 may be brought against a person, a period of time during which the person holds or performs the functions of the President shall not be taken into account in calculating the period of time prescribed by that law. And what is this law referring to? It must be referring to the law of limitations. And then why would the president be denied the benefit of limitation of actions? Precisely because the president cannot be sued in his private capacity during the tenure of his or her office. And I also state that once a president, always a president until he or she vacates the office, because you cannot be a president today and tomorrow you are not a president, so that you may be so sued. That brings me to issue number 5, the place of public participation under Article 10 vis-a-vis the role of IEBC and whether there was public participation. And in response to this, after serious analysis, I find that there was no obligation on the part of the IEBC at the time it embarked upon the verification of signatures to satisfy itself as to whether there had been public participation before the bill and signatures were transmitted to it. I do not find anything in the Constitution that obliges the IEBC to carry out that function. But what about the promoters of the popular initiatives? What about Dennis Waweru, Mr. Waweru, Honorable, and Honorable Junet, who have defined themselves as promoters? Were they not supposed to undertake meaningful public participation? The argument that I see here against such a proposal is that the process of popular initiative begins with the collection of signatures. And I do not agree with that proposition, because before you collect signatures, there must be something you are offering the people. You are taking to the people either that general suggestion or a draft bill. And if you are seeking their signatures, surely the people must understand the contents of the bill to which they are appending their signatures. I have read the contents of the affidavit sworn by Honorable Waweru, the contents of which state that there was a comprehensive and robust process of consultation. But the contents of that robust consultation are not clearly stated. And so I'm concluding that when it comes to the promoters of the popular initiative, I do not myself think that they undertook sufficient or meaningful public participation under within the meaning of Article 10 of the Constitution of 2010. And now this brings me to the interpretation of Articles 88 and 250 of the Constitution with respect to the composition and quorum of the IEBC. This one has been thrust to us because somewhere along the line, the petitioners did allege that at the time it undertook the verification of signatures, the IEBC lacked the requisite quorum to be able to constitutionally undertake that task. And then I have also looked at the history of the legislative form that prescribes the quorum of IEBC. I've looked at the contents of the Article 251 of the Constitution, and I come to this conclusion, that if, as indeed we must conclude, that at the time the IEBC undertook the verification of signatures, it was constitutionally and properly so constituted, how on earth can we then say that it lacked quorum to undertake the tasks for which it was properly constituted? And then my attention has been drawn to the contents of paragraph 5 of Schedule 12, I think, to the IEBC Act, which sets that quorum at 5. And I'm simply saying that as between a constitutional provision You cannot use the provisions of a statute to override the majesty of a constitutional provision. And having so said, I find that the IBC had the requisite quorum to conduct the verification of signatures and any other task that the Constitution requires it to undertake. And finally, I come to this vexed question of whether the interpretation of 25710 of the Constitution entails that all, or requires, that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions. I had no difficulty in disposing of this particular issue because it was not ripe, as rightly observed by my colleague Tuyot J.A. of the Supreme Court. And I'm not the kind of person to engage in abstract exercises. Because if we did that, then we would be also encouraging Kenyans, as indeed they have done to us in this basic structure imbroglio, to come with abstract questions and expect us to expend valuable judicial time disentangling the same. So what are my conclusions? One, the basic structure doctrine is not applicable in Kenya in the way and manner in which it has been formulated, because it's no such doctrine, neither does it have a force of law juridically so understood. I've said it is a heuristic device. The four sequential steps of civic education, public participation, and the rest are not also applicable to the process of constitutional amendment envisaged under Articles 255, 256, and 257. Such steps, and not necessarily in that order, would become operative in the event of a seismic constitutional moment which dictates that the people must exercise their primary constituent power to make a new constitution or re-establish the constitutional order. And three, the president cannot initiate or activate any constitutional changes through a popular initiative process as envisaged under Articles 255 and 257 of the Constitution. For the president actually did initiate the proposed constitutional amendments, and the effect of that, I believe, should be able to come out in the final disposition of this dispute by this court. The second schedule to the Constitution of Kenya, Amendment Bill 2020, is unconstitutional. Civil proceedings cannot be brought or instituted in any court of law against the president or a person performing the functions of that office in their personal capacity during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. And seven, the IEBC is not under any obligation to ensure that the promoters of a popular initiative have facilitated public participation before transmitting the resultant bill to it. But I also say that in this particular instance, no meaningful public participation was conducted by the promoters of this bill. 9, the IEBC had the requisite quorum at the time it undertook and completed the verification of signatures. And finally, the interpretation of Article 25710 in the manner in which the issue has been formulated is not ripe for consideration, not just by this court, by any other court in this country. Before I sign off, my mind races back to those 3 days in this tent during which I and my colleagues here sat patiently, pensively, and attentively, listening to the impassioned pleas from the bar so commandingly assembled. Not that this was the first time I was finding myself having to endure the perorations of counsel. Some of them experienced jurists and others not so senior. But it was such a moment when the basics of a basic structure were basically spewed unto us with such aplomb, hitherto unseen, save during the hearing of a presidential election petition. What we were told, however, I also remember that it was on such occasion that we were reminded that our colleagues at the High Court and Court of Appeal, the colleagues at the High Court had built a foundation, and those ones at the Court of Appeal had constructed a wall upon it, and that now it was our turn to paint that wall. But we were not told with which colors we were to undertake this alluring task. I also remember being urged to roar like lions in the wild as we asserted the supremacy of the Constitution. But who could fault counsel for invoking our hallowed symbol of nationhood? Yet at that moment I could not help but cringe, for the sound of a roar of a lion in the wild stirred in me images of the terrifying language so beloved by our politicians, the language of tsunamis, of earthquakes, volcanoes, war and thunder. And that is why I cringed. And then I remembered that not so long ago this court had in one of its judgments, and really in true oracular rendition, also I thought, decreed as follows. But it does appear, as my colleague Judge Lenaola here apprehended, counsel do not read the judgments of this court, and now I am forced to read this decree to you so that even if you don't reread it, it shall be acted in your mind. And this is what this court said at that time. What of the argument that this court should not subvert the will of the people? This court is one of those to whom that sovereign power has been delegated under Article 13C of the same Constitution. All its powers, including that of invalidating the presidential election, is not self-given nor forcefully taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular that invitation may seem. Therefore, however burdensome, let the majesty of the Constitution reverberate across the lengths and breadths of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the trees. Let it sprout from our institutions of learning. Let it toll from our sanctums of prayer. And to those who bear the responsibility of leadership, let it be a constant irritant. So I say no more. Thank you, Chief Justice.
Thank you very much, Justice Wanjara, for that rendition. I now request the Honorable Mr. Justice Ibrahim Mohammed to deliver his opinion.
Thank you very much, Honorable CJ, the President of the Supreme Court of Kenya. Every judicial officer or judge has his style of delivery, but when there is a pressure of time, you elect how to do it, considering the question of time also. The art of brevity does not come or are not bestowed on everyone. So you may find that I may take a bit longer on some issues, but to save time also, I may summarize. I may give a summary of my findings in some of the issues, and also the dispositions on each issue, while in others I may give some more elaborate explanation for my conclusion and disposition. The Honorable Chief Justice and President of the Supreme Court of Kenya, Honorable Lady Justice Martha Koome, has in the lead judgment aptly captured the history and background of the appeals before us. She has also pertinently set out the written and oral submissions by all counsel, as well as the amici, for which I thank her on our behalf. I see no need to replicate or rehash the same. I referred to the 7 issues which were framed by the court on the 9th of November 2021. The 7 issues, I'll not read them out. Thank you. I'll not read them out as they are already on record and have been referred to by all my colleagues. I'll also refer to them one after the other. I find myself substantially in agreement with the arguments and conclusions by the Honorable Chief Justice Koome, President of the Court, on some issues. Just as well, on some I'm of divergent views. I render my opinions and pronouncements on the issues as delineated by the court. The first question is regarding the basic structure, whether it's applicable in Kenya, and if so, the extent of its application, whether the basic structures of the Constitution can only be altered through the primary constitution power, and what constitutes the primary power. In answering and determining these questions, I trace the history of what is the basic structure and what it comprises of in the framework of a constitution. I trace that history globally from the Federal Republic of Germany to India, the US, France, then also to the other countries like Malaysia, Singapore, Bangladesh, Uganda, and many more. Some of these states, particularly the ones which came to consider later the basic structure, some were disinclined initially, that's the courts in those countries, but later some of them adopted and accepted the Say doctrine. I finally came to the applicability of the Say doctrine of basic structure to Kenya. I followed our journey of constitutional making from the CKRC to the Bomas Conference. During the Say process, Justice Ringera, as he then was, grappled with the question of the basic structure of our repeal constitution. He concurred with the majority pronouncement in the case of Kesavananda that Parliament did not have the power to alter the basic structure of our constitution. This was in the case of Timothy Njoya and others versus CKRC and another. The application of the doctrine also arose in the case of Patrick Ouma Onyango and 12 others versus AG 2008. The court, consisting of Justice Nyamo, Wendo, and Mkule, found and declared that the basic steps in constitutional making, they declared the basic steps in the constitutional making. Then there was the case of Commission for the Implementation of the Constitution versus National Assembly of Kenya, 2013, where Honorable Justice Lenaola, as he then was, analyzed the question of the basic structure of the Constitution, although that was not really a direct issue, and also the issue of its applicability was not before the court. I just want to refer that it was considered and it was a known principle before this case, which is before us. Then there was a case of Priscilla and Ndululu, Kivuitu, and another versus AG 2015, wherein the 3-judge bench, Korir, Mumbi, Ngugi, and Odunga, held that some amendments under Article 255, 1 or Article 257 can only be done with the involvement of the citizens by way of referendum. They relied on the sentiments expressed by Honorable Ringera J. in the Njoya case. The three judges, I'll refer to paragraph to what they said. I'll go directly to that, what they said. They say that we agree with the sentiments expressed by Ringera J. in Joya 2 that an amendment that upsets the basic structure of the Constitution could not be effected by Parliament without involving of the people. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in the Joya 2 case was necessary. This may explain why the people of Kenya, aware of the frequent and frivolous amendments to the repealed Constitution provided in Articles 255 of the 2010 Constitution, and I refer to the contents of Article 255, where strict conditions were given before any amendments could be carried out, and I don't have to refer to that. It is clear from the above cited provision that there are amendments that can only be done with the involvement of the citizens by way of a referendum of Article 255(1) or popular initiative involving at least 1 million registered voters, Article 257(1). So it means that the judges themselves in this case, referring to the basic structure, identified Article 255 as containing principles of basic structure. Even where Parliament has been mandated to amend the Constitution, it can only do so after the amendment bill has been subjected to public discussion, Article 256(2). The voice of the people is a voice that cannot be ignored when it comes to the amendment of the 2010 Constitution. We wonder, and they continue, we wonder whether in light of the provisions in 2010 Constitution, the proposition that Parliament cannot amend the Constitution in a manner that may result in the distortion of the basic structure, again they use the word basic structure, still has a place in our jurisprudence. However, this is not an issue that has been taken up and with us, and we will say no more about it. So I'm just giving the background that these issues have been before the court, but not directly. But now, in our case, it is directly before us, and we have to deal with. There's been a discussion and contestation of whether this basic structure is a doctrine or even a principle. An uncontentious example of popular doctrine, for instance, is that of the separation of powers in a tripartite form of separation comprising the executive, judiciary, and legislative arms of government. We credit the French jurist with a long name, Charles Louis de Secondant, Baron de la Brede de Montesquieu. I'm not very good in French, or in fact, I don't know French at all. Or Montesquieu, I read him in history, simply referred to as Montesquieu, as the father of the doctrine. This doctrine is embedded in our legal system by direct reference in various, and we have adopted it even in the structure of our Constitution. However, even as we make reference to the doctrine of separation of powers today, it is not to say that the doctrine has not evolved since 1748, or that it is only Montesquieu who discussed it. In Kenya, we have not only laws, however, That incorporation was with some modification to suit our peculiar circumstances, such as the addition to the independent commissions and offices. Yet in doing so, we have not explicitly provided for it or even defined the doctrine of separation of powers in our laws. Still, it is evident that we have applied it. So the question of the basic structure as a doctrine, what is it? What does it encompass? Is it applicable in Kenya? This is the duty we have, and we cannot just dismiss this. Many times it has been said that this doctrine of basic structure, origin came from the case of Kesavananda, 1973, where by the majority of 7-6, the court in India, Supreme Court, held that the Article 368 of the Indian Constitution does not enable Parliament to alter the basic structure or framework of the Constitution. And there's a quotation or citation by two judges, Justice Hedge and Justice Mukeji. But after tracing the history, we find that actually these principles did not emanate from India. It emanated from the scholar, a colleague referred to that, the scholar called, there's a Professor Conrad of Germany. He gave us a talk in some Indian university, and this idea was captured or was captured by some lecturers and some professors, and finally it reached the ears of some judges who, in the case of Golaknath versus State of Punjab, 1647, who applied those principles, and that was the first foothold in India, that case of Golaknath. Even though the court then did not accept any limitations on Parliament's power to amend the Constitution. So regarding the Germans, it's not easy to see why a German jurist would propagate implied limits to amending the constitutional powers. Article 79.3 of the Basic Law of the Federal Republic of Germany, adopted on 8th of May 1949, explicitly bars amendments to provisions concerning the federal structure and to basic principles laid down in Articles 1 and 20 on human rights and democratic and social setup. The Germans were healing from the Nazi era, and it is for that reason that the framers of the Basic Law sought to create a constitution that would safeguard against the emergence of either the Weimar Republic's overly fragmented multi-party democracy or the Third Reich's authoritarianism. And there have been arguments in various cases in support of this. Now, in France, the same thing happened, where a scholar called Schmidt was, where a scholar called Maurice Hariot, a professor of administrative law and constitutional law, published two constitutional treatises, and the difficult name it has, I can't read it, setting out the history of implied limits on constitutional amendment. Now, coming back to, I'm referring now how this has been discussed in Kenya. Yaniv Rosner, in his article on constitutional amendments, the migration and success of a constitutional idea, in the American Journal of Comparative Law, drew attention to the debate of the first American Congress, more particularly the debate that took place on August 1789. So there's a lot of discussion in the US, and I don't have to go to the cases. Everything is in that judgment. I've gone rather into some detail. Legal doctrines and principles are often traceable to a particular school of thought, and more specifically to a certain scholars who sought to elaborate them. The importance of this is to address the contestation regarding whether the basic structure doctrine was a creature of judicial craft, or even whether the courts are capable of creating doctrines. This is not to make a case for incorporation, or rather reading into our laws. All doctrines and legal principles are in existence. From this, however, it is evidence that the doctrine of basic structure was not invented by the judiciary in India and some of the other countries. It has been submitted that the doctrine of basic structure has yet to gain universal experience. And for that reason, we are asked to find that it is not applicable. I do not think it is necessary that before application of a doctrine or legal principle, the same must have universal application. I say this because not all legal doctrines and principles are universally applicable due to the differences in legal systems, such as the civil and common law. This is also because of our unique peculiarities, such as states due to our historical, cultural, and social systems. My thoughts on this are further fortified by our Constitution, read together with the Judicature Act, Cap 6, laws of Kenya, which allow us to apply the doctrine that are in line with our laws, more so if they assist us better to interpret and apply them. There's a lot of reading material which I've referred to. So directly is the doctrine. Is the doctrine of basic structure applicable to Kenya? The basic structure doctrine is not only new to our, is not entirely new to our jurisdiction. Much like the other countries, Kenya has had opportunity to grapple with the doctrine of basic structure in our circumstances. During our journey of constitutional making, we had the CKRC appointed in November 2000. The commission chaired by Professor Yash Palgai convened the National Constitutional Conference for discussion, debate, amendment, and adoption of its report and draft bill, famously dubbed the Bomas Conference, due to taking place, which was taking place at the Bomas. The Bomas Conference was convened and adjourned 3 times, out of which a draft was amended and adopted by the acclamation by the conference, sitting in plenary on 23rd March 2003, then handed over the Constitution to the Kenya Review Commission. However, before the conference was adjourned, there was a number of challenges to the validity or legitimacy of the entire constitutional review process and its outcome, one of which was the case that I have referred to, Timothy Njoya and others, versus CKRC. The applicants sought inter alia, that was 2004. The applicants sought inter alia a declaration that certain provisions of the Constitutional Review Act transferred, diluted, and vitiated the constitutional power of the people of Kenya to adopt a new constitution. The court held that the new constitution needed to be ratified through a national referendum, as the right to a referendum was a fundamental right of the people in exercise of their constitutional power. Ringera J., who is now retired, who was in the majority, concurred with the pronouncements of Kesavananda that Parliament did not have the power to alter the basic structure of our Constitution. And there's a citation here, which I don't have to go through, where Justice Ringera, and which means our courts, recognize the principle of, this is my submission, principle of basic structure. Application of the doctrine again arose in the case I referred to, Patrick Ouma Onyango. One of the issues that arose was whether Parliament, in its limited delegated role, had the power to debate, alter, or amend the Bomas draft constitution, which was the product of the view of the people. It was also questioned whether that interference by Parliament had the effect of elevating the members of National Assembly above the people of Kenya as sovereigns. The court, consisting of Nyamo, Wendo, and Mkule, held and I think, I think I should refer to it very quickly. We further find and declare that what will give purity to the process is the enactment of the proposals as a constitution by the people in the referendum. It is the enactment by the people which gives purity and validity. Yes, they are the touchstone of validity, the people. The applicants in their final written submissions did concede that constitutional power cannot be restrained. We exercise judicial power on behalf of the people, and we cannot restrain for them in making their choice. These are three judges of our courts speaking for the people of Kenya. We find and declare that the basic steps in constitution making are 1, popular consultations, 2, framing of the proposals, 3, referendums or constitutional assembly elected and mandated. We find the challenge process has satisfied all the 3 steps. We find and declare that the process is not flawed. In our view, the real judges of the process are the people of Kenya in view of the past involvement with the process as outlined. I'm not going to go through all that. There's a lot of material which I will let you read when you get this, this judgment. Basically, it is to show that Kenya itself, due to the constitution-making process that led to 2010, people discussed in depth the history and the problems that Kenya went through, the hyper amendments that we had gone through, and the result was the 2010 Constitution, and in particular, Chapter 16 and Articles 255, 256, 257, which I will be persuading you in this opinion that contains the basic structure that supposed to protect the people from amendments by even the delegated power, which is Parliament. After the promulgation of the Constitution in August 2010, there was a case of the Commission for the Implementation of the Constitution versus National Assembly of Kenya, where the National Assembly, by the Constitutional Amendment Bill 2013, sought to amend Article 260 of the Constitution in respect of the definition of state office. I'd already discussed that. Then there was the case of Priscilla Kivuitu. Then we have various cases. Attorney General versus Randu Nzai, whereby the court held that in view of the foregoing, the appellant's contention that the respondent's agenda of succession is unconstitutional has no basis in law. The respondents have a constitutional right to demand succession, but that can only be done within the confines of the Constitution as stipulated under Articles 255, 256, and 257 of the Constitution. Now, in all these cases, the applicability of the basic structure doctrine was not a substantive question of the courts. The courts were asked to determine, unlike the present one. So in this case, through my proposals here, which I don't wish to go through, and I have told you the art of brevity is not donated to everybody, and I'm not one of them. So I'll let you read. But I'd refer to what I've said here. That there was this decision by Justice Mativo in the Third Alliance case, Kenya versus another versus Head of Public Service, Joseph Kinyua, and others versus Martin Kimani and others. In that case, Justice Mativo said, he referred to this doctrine and stated as follows: the command in Article 259 is instrumental in shaping the constitutional jurisprudence in this country. Call it by any name, basic structure, or whatever. But Article 259 provides the manner in which the Constitution is to be interpreted to maintain its fabric, which cannot be dismantled by any authority created by the Constitution itself, be it the Parliament, the Executive, or the Judiciary. Couched in this doctrine are a few crucial aspects. First, that constitutions are considered to be the act of the people as the almighty sovereign. We see this as the power of the people recognized and documented in the preamble of our Constitution, which begins as follows, and I quote, "We, the people of Kenya, exercising our sovereign and inalienable right to determine form of government of our country and having participated fully in the making of the Constitution." So I've gone through this and I invited you, as some of my colleagues have said, some of our judgments are long. Mine is 125, and I would not wish to read through it. I invite you to read carefully, but after going through all my arguments and citing various cases and showing the historical road we passed to acquire, to get this very important Constitution 2010, of which I'm sure all of us are proud of and all of us cherish, I came to the conclusion, my disposition on this issue, first issue, noting our history, context, and constitutional text, I find that the doctrine of basic structure is applicable to Kenya. Further, that the basic structure of a constitution can only be altered or denatured through the primary constituent power. C, it's my further finding that the primary constitutional power is the unbound power of the people to make or unmake constitution, and genuine exercise of the same can be identified by the 4 sequential steps of civic education, public participation, constitution assembly, plus referendum. So I've set out in the judgment what the basic structure entails. And I've set out and I've discussed the issue, where, can the basic structure of the Constitution only be altered through primary constitutional power, and what constitutes the primary power? I've discussed that, and that was my dispensation. So that is my dispensation in that question, and I invite you to read that. So in the interest of brevity of time, I'll go to another issue. Issue number 2. Issue number 2, whether the President can initiate changes, amendments to the Constitution, and whether constitutional amendment can only be initiated by Parliament through a parliamentary initiative under the Article 256 of the Constitution, or through a popular initiative under the Article 257 of the Constitution. I'll give a summarized view of this, which is contained in this opinion and judgment, and also one more issue. The other issue is the place of public, issue number 5, the place of public participation under Article 10 vis-a-vis the role of IBC. The other 3, I wish just to set out and read and state my disposition without going into the details, and I leave that to you to read when you have the time. Regarding question 2, Gatembu J.A. rightly observed that Article 257 makes no qualification of who may or may not promote a popular initiative, and there is no explicit bar against any person, including the President, from promoting a constitution amendment by popular initiative. It is therefore upon the court to interpret and determine the parameters of the same. Now, Justice Tuyot gave the historical context of highlighting the genesis of popular initiative, the clauses in the Constitution. This can be traced back to the CKRC final report, where the Commission noted that although the conference agreed the process of constitutional amendment, this must not be left entirely to Parliament. Different options needed further thought, particularly with regard to the exact modalities of engaging the constituent power of the people. The Commission, in addressing the issue, recommended that that citizen and the civil society may initiate constitutional amendments through a process called popular initiative. This was then captured in the zero draft at Article 346, and the same was retained in the Boma's draft as follows, and I quote, an amendment to this constitution may be proposed by a popular initiative signed by at least 1 million citizens to vote. So the genesis of the issue of popular initiative was way back during the CKRC conferences. The same survived the Naivasha Accord of November 2004 and the Kilifi Accord of June 2005. And also, it was retained in the harmonized draft. The objective for the popular initiative, as captured by the final report of the Technical Working Group of Group K of the Constitution of Kenya Review Commission on Constitutional Commission and Amendments to the Constitution held up to the creation of 2010 Constitution, the report said a committee introduced a novel idea called popular initiative. This is an innovative where the citizen can only own motion by their own motion initiate amendment to the Constitution by way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament. Tuyotjeye went to hold that, contrary to the AG's submission that the intention of the popular initiative was to curb parliamentary monopoly for both people and state organs, the historical perspective demonstrated that the popular initiative was a preserve of the citizens. It's for this reason that I concur with Kiage J when he concluded that the popular initiative route must be citizen-conceived, citizen-initiated, and citizen-driven process, and the citizens are the ordinary people, whether as individuals or as organized civil groups. Regarding the assertion that the President can initiate process of constitutional amendment by way of popular initiative in his capacity as a private citizen, two pertinent issues arise. First is the fact that Article 257.5 subscribes the President a role in the amendment process. Article 257.5 provides that if a bill to amend the Constitution proposes an amendment relating to matters under Article 255, the President shall, before assenting to the bill, request IEBC to conduct a national referendum within 90 days. The import of this provision is it assigns the President the power to decide whether or not to hold a referendum. To ensure the integrity of the process of constitutional amendment pursuant to Article 257, we cannot have the President playing the role of umpire, who is expected to be neutral and act in the interest of the nation, in a process where he is also a player advocating for his own personal interests and agendas. Clearly, there would be a serious conflict of interest. This would be detrimental to the interests of the people and the nation. Second is that the President ceases to be an ordinary citizen the minute he takes office. Article 131 describes him as the head of state and government, who exercises executive authority of the Republic. He is also the Commander-in-Chief of the Defense Kenya Forces. He chairs the National Security Council pursuant to Article 240, which exercises supervisory control over national security organs, including the Kenya Defense Forces, the National Intelligence Service, and the National Police Service. He is also the symbol of national unity. He plays the various powerful roles pursuant to Article 132, including appointing cabinet secretaries, attorney general, principal secretaries, high commissioners, ambassadors, as well as diplomatic and consular representatives. He is empowered by virtue of Articles 132, 4D and E to declare a state of emergency or declare war, respectively. He may also, pursuant to Article 192, even suspend county governments, either in emergency arising out of internal conflict or war, for any other exceptional circumstances. By virtue of holding this office, the President is accorded immunity with Article 143. So you can see the special position of the President. And we are saying, and I'm saying that the President cannot act as a promoter or initiator, even if you have to use that name, initiator, you cannot commence or get involved. In this particular case, there is evidence that not only did he start the process, but he was also involved throughout, and all steps taken by others the genesis was his own actions through the Gazette notice and the legal steps that he took. This power and control that the President exercises by virtue of his position was evident in the inception of the amendment bill, as rightly pointed out by the learned judges of the superior courts. Right from the handshake that was between him as the elected president following the contentious 2017 general elections and rerun, and his competitor and challenger, Honorable Raila Odinga. He then proceeded to appoint that. So I gave, in this narration, I give the history of all the steps and that he was involved in directly, in the building bridges to a united Kenya, from a nation of blood ties to a nation of ideals, the appointment of the teams, the Gazette notices throughout. The first step had a domino effect, and throughout he was involved, and the government's role was also very clear. The difference in the amendment bill that was launched on 25th November 2020 from the amendment bill contained in the BBI Steering Committee report presented to the President on 26th 2020 are better contextualized in discussing the place of public participation under issue number 5. My conclusion there is that on whether the President can initiate a popular initiative to amend the Constitution under Article 257, it is my finding that he cannot. Issue number 3, on whether the second schedule to the Constitution of Kenya, Amendment Bill 2020, was unconstitutional, I find that on issue number 3, I find that the second schedule of the Constitution of Kenya Amendment Bill to have been unconstitutional. On question number 4, it is my finding that pursuant to Article 143(2), no civil proceedings can be instituted against the President or person performing the functions of the office of the President during their tenure of office with regard to anything done or not done contrary to the Constitution. And regarding public participation, I wanted to say more, but I will wish to save time, and I will invite you to read the judgment. On issue number 5, I find that by the time the process was stopped by the High Court, the public participation undertaken was not sufficient, reasonable, or meaningful. Issue number 6, I find that the IBC was not properly composed or quorate while it undertook the verification of signatures pursuant to Article 257(4) of the Constitution. However, in the light of the decision in Isaac Biot case, IBC's undertakings in compliance with the decision were lawful. Number 7, it is my finding that the interpretation of Article 257(10) on whether the proposed amendments should be submitted to the people as separate but distinct referendum questions, this issue was not ripe. It was not ripe for determination for determination. On the issue of costs, I recommend that, being a public interest matter, the parties ought to bear their own costs of proceedings in the High Court, Court of Appeal, and in the present appeals. Orders of this court are as will be contained in the lead judgment of the Chief Justice and the President of the Court, and which he will advise the court before we end these proceedings. I've had to do this, but I invite you please carefully read my whole judgment. Thank you.
Thank you very much, the Honorable Mr. Justice Ibrahim Mohammed. Allow me now to invite the Honorable Justice Mwiru, the Vice President of the Court, to render her opinion.
Thank you very much, Judge President. The modus operandi today from the side of the court was to deliver summarized versions of the judgment. The 150 plus pages will be at your disposal to coexist and flourish. Whilst we see this across our courts every day, there are certain matters that attenuate our constant pursuit of socio-political perfection. The petition before this court is one such. Within the context of our national journey towards perfecting our constitutional democracy, the important role of this court and all parties to this petition becomes all the more apparent. The crux of this petition, as I said, is the extent and nature of constitutional amendment in Kenya, especially within our nation's history of constitutional development, and more specifically, the experiences and processes that birthed the Constitution of Kenya 2010. Any initiative that seeks to change that body of fundamental principles according to which we as Kenyans have agreed to be governed, our Constitution deserves the most attention of all Kenyans, whose duty under Article 3 is to respect, to uphold, and defend the Constitution, and all state organs who under Article 2 exercise their delegated authority only through and in accordance with that Constitution. The history of constitutional development in Kenya has been laid out concisely and in detail, both in the High Court and the Court of Appeal, and even in our decisions. This history is most relevant, in my view. This court, the Supreme Court, has on numerous occasions asserted the importance of historical context as a key tool for courts and tribunals in the interpretation of the provisions of our transformative charter. Though a significant factor, it is not and ought not be the only lens through or the weightiest factor upon which we consider the questions of constitutional interpretation. Professor Richard Albert referred to in both the judgments of the superior courts below, speaks of the, quote, rise of unamendability, unquote, and the quality of formal amendment rules in terms of their availability for both good and ill, as posing a challenge for constitutionalism, in that though rules of change are indispensable for the functioning of constitutional democracy, they at once, quote, open the door to the demise of constitutional democracy itself, unquote. Therefore, may poses the question, How then, quote, can we protect constitutional democracy from the misuse of its own devices, unquote? The late Professor H.W. Okoth-Ogendo illuminates this discussion by pointing out that it is pointless having a constitution if constitutionalism is not our concern. I am most cognizant of our history as a country, as well as the history of the development of our much cherished 2010 Constitution. I'm also aware of the principles developed by this court regarding historical context in the interpretation of the Constitution, a living document that speaks from the past through the present to the future. I must, however, state that the role of our courts must remain within the architecture of the Constitution. It is bound by it. All courts are bound by it. The exercise of discretion must be judicious. Though it is the court's task to breathe life into the Constitution and to ensure that its text is constantly speaking to the transformative and emancipatory ideals therein, on the other hand, the text of the Constitution cannot be seen as devoid of meaning and content, merely to be filled by ideas and opinions by those on the bench, no matter how laudable and noble and well-intentioned those may be. A balance must be maintained, and such balance is crucial to the very architecture of our constitutional democracy, for the courts too must not see themselves as immune to being inimical, despotic tendencies. This is especially true in regard to constitutional amendment and the exercise of sovereignty as acknowledged in the Constitution, directly and indirectly through processes that are prescribed in our Constitution. The courts must seek to steadfastly and purposely defend and protect the Constitution and constitutional processes through which the people of Kenya express their sovereign power, not on the basis of justifiable apprehension, and no matter the nobility of the cause, employ judicial craft to retain certain moral or doctrinal limits into the exercise of such sovereign power. It is the sovereign, the people who must decide, and responsibility of all state organs only exercise state authority as delegated by the sovereign. That is to remove all extra constitutional impediments to the free exercise of such sovereign power. This Constitution has been stretched in its over 10 years existence, and perhaps this is the most serious attempt yet to espouse its limits in the wake of attempted amendments. To demonstrate the magnitude of this case before these courts, while the High Court framed 13 issues for determination arising out of the consolidated petitions, the Court of Appeal expanded them to 21. On our part, we found 7 that required determination, and that's what we are doing this morning, this afternoon. That said, I now proceed to determine the 7 issues as framed in summary as my understanding of the Constitution and the law allows me to do. And the first issue is that doctrine and the basic structure itself. If a doctrine is a legal principle of long usage that is widely accepted as such, then my finding is that the Kesavananda case is a judicial reasoning which cannot be elevated to a doctrine above the Constitution. And therefore, the Constitution of Kenya 2010, I find, has a basic structure. But as for the basic structure doctrine, I find that the same is not derivable from our Constitution, and that structure, wherever else it may be found and applied, does not, in my view, apply in the Kenyan constitutional context. The manner and process through which sovereign power is exercised in this country is by the citizens in its different forms and is fundamentally important under our constitutional architecture, and the Constitution can be changed through other mechanisms, not limited to the primary constituent power. The second issue, the President, in my reading of Article 143, cannot, no, not 143, sorry, Article, issue number 2, the President cannot directly initiate changes or amendments to the Constitution. An amendment of the Constitution can only be initiated through a parliamentary or popular initiative under Articles 256 and 257 of the Constitution of Kenya 2010. Consequently, therefore, the Constitutional Amendment Bill 2010 is unconstitutional. On the third issue, the second schedule to the Constitutional Amendment Bill 2010, I find no difficulty in finding that that bill is unconstitutional insofar as it directs the IEBC on not only the elimination of the number of constituencies, but also the distribution of the proposed new constituencies and the timelines within which to operationalize the same within the constitutional parameters that are given in Article 87 of the 2010 Constitution. The Commission cannot be directed. Article 89 was not even sought to be amended in its entirety. The bill, therefore, is unconstitutional in my finding. On issue number 4, even before I decide whether or not the President can be sued first, it's important to note that there really was no proper service of the process, and the President was therefore not accorded an opportunity to participate in the pleadings in his personal capacity, as he had been sued in his personal capacity. And I find further that Article 143, any interpretation of that article must come to the conclusion that the President or the person performing the functions of the office of President cannot be sued during tenure. And although their immunity is not absolute immunity to impunity, it is nevertheless absolute immunity during the tenure of office. In my judgment, you will see that I have said if any proceedings were begun before assumption of office, they are stayed. That's what the Constitution says, and they are resumed or fresh ones initiated after leaving office. On public participation, issue number 5, I have said where it mattered most, I found no reasonable or any degree of public participation, which is a value in Article 10 of our Constitution that I could consider allowing the standing of the actions that were done without public participation. This court set the test in BAT versus the CS Health, and I find, therefore, that for me, the test was not met. On issue number 6, the totality of my finding, even considering what the findings in Isaiah B. Watt and in the Katiba case and the effect of the Katiba case on Section 5 were, I would rest with Article 250 of the Constitution and say that the IEBC was not only properly constituted with the minimum number that was required by Article 250, it had quorum, and nothing was shown to the contrary. The last issue, on the last issue as to the referendum question, I agree with all my colleagues in this court and in the courts below that have said that the matter was not ripe. It still is not. The bill never went past the IEBC for it to be submitted to referendum. I find, therefore, that engaging in a discussion in that matter is a complete waste of precious judicial time, and I would not get myself entangled in such a non-issue as that one. As to costs, this being a public litigation issue, I would say that they lie with each party, and those are the orders. The body of the judgment shall give my explanations for each of my findings. I thank you, Judge President.
Thank you very much, the Honorable Lady Justice Mwiru, Vice President, for that rendition. Before I read the final disposition of the court, allow me to express the court's appreciation to all counsel and all parties and amici appearing in this matter for your erudite and well-researched oral and written submissions. We also wish to thank you for patiently sitting and bearing with us for the last 6 hours as we delivered this judgment. The court notes in a special way the galaxy of legal luminaries, among them distinguished legal scholars, professors of constitutional law from Kenya and other jurisdictions who joined this case to enrich our judgment. We found their views very useful, although they were varied and divergent, especially on the applicability of the basic structure and doctrine and whether it had acquired international application under the provisions of Article 2.5 of the Constitution. The court's decision has been enriched and benefited a great deal from the arguments advanced by all the parties who appeared before us. We hope with the full noise of time, even our local scholars will find their way in other jurisdictions, in other countries, America, Germany, or even Africa, to share our rich jurisprudence with those courts. We also wish to thank our law clerks for their research and exceptional industry in supporting the work of this court. That said, in the course of writing this judgment, the court observed with concern some commentaries on the pending judgment carried out in the social media by some counsel, some of whom are appearing in this matter. The contents of those social media commentaries were, in our view, meant to influence, intimidate, or scandalize the court. This unfortunate practice is emerging, and unless it is checked, it will erode the confidence and the dignity of the courts. It would also amount to unprofessional conduct, especially by counsel appearing in this matter, and even counsel who are not in this matter, but know very well that they cannot comment on a matter that is pending judgment. It is a well-established practice that counsel and indeed parties should refrain from directly or indirectly trying to improperly influence the court to rule in one way or the other. Once judgment has been reserved and judges retreated to consider submissions and write judgment, learned counsel Mr. Nelson Avi and Ms. Esther Angawa, who appeared for the first to the fifth respondents, took to the social media, Twitter, on different occasions. On 19th February and 15th February 2022, and they cast aspersions on the court. For counsel to appear before the apex court, then proceed to hurl unnecessary diatribe, insults, and speculations on a pending judgment amounts to unethical conduct on the part of the counsel. The use of social media to disparage the court with the intention of lowering the dignity and the authority of the court or influencing the outcome of the case pending before the court is a trespass on the bounds of legitimate advocacy and moves to the realm of professionalism to professional misconduct. This is in line with the provisions of Section 61 of the Advocates Act that deals with dishonorable conduct incompatible with the status of an advocate. Equally culpable is the conduct of senior counsel, Mr. Amin Nasir Abdullahi, who, though not counsel appearing in this matter, took the lead role in disparaging and besmashing the court as evidence from his posts on Twitter on 8th February 2022, 15th February, and even as late as yesterday, the 29th March 2022. Section 17 of the Advocates Act envisages the rank and dignity of senior counsel is conferred on the basis of irreproachable professional conduct and exemplary service to the legal and public service in Kenya. These standards are expected to continue even after conferment of the rank of the senior counsel. Advocates should familiarize themselves with the code of standards of professional practice and ethical conduct, Gazette Notice number 5212, and strive to conduct themselves in a manner that preserve and strengthen the dignity, the honor, and the ethics of the profession. Consequently, advocates should refrain from conduct that amounts to indirectly attempting to influence decisions pending before courts. Relevant to the use of social media, we wish to draw the attention of advocates to the standard of professional practice and ethics conduct number 10 that spells out what is inappropriate conduct. This caution should always play in the mind of advocates who are tempted to utilize social media to advance their cause. I will now proceed to give the final disposition of the court. Having considered the 7 issues framed by this court for determination, the final orders are as follows. 1, the basic structure doctrine is not applicable in Kenya. Ibrahim, Supreme Court Judge, dissenting. B, in order to amend the Constitution of Kenya 2010, the 4 sequential steps as pronounced by the 2 superior courts below are not necessary. Ibrahim, Supreme Court Judge, dissenting. On the second issue, the first part A, the President cannot initiate constitutional amendments or changes through the popular initiative under Article 257 of the Constitution. Joaquin Dongo, Supreme Court Judge, dissenting. The B aspect of that, issue 2, the President initiated the amendment process in issue. Joaquin Dongo and the Naura Supreme Court judges dissenting. Consequently, under Article 257 of the Constitution, the Constitution Amendment Bill of 2020 is unconstitutional. Joaquin Dongo and the Naura Supreme Court judges dissenting. The third issue, the second schedule of the Constitution of Kenya Amendment Bill 2020 is unconstitutional for being in breach of Article 10.2 and 87.7a of the Constitution of Kenya 2020 for lack of public participation. Joaquin Dongo, Supreme Court Judge, concurring. 4, civil proceedings cannot be instituted in any court against the President or the person performing the functions of the office of the President during their tenure of office in respect of anything done or not done under the Constitution of Kenya 2010. That was unanimous. 5A, there was no obligation under Article 10 and 257.4 of the Constitution on INBC to ensure that the promoters of the Constitution of Kenya Amendment Bill 2020 complied with the requirements for public participation. Unanimous. B, there was public participation with respect to the Constitution of Kenya Amendment Bill 2020. Mwiru, Vice President, Ibrahim and Wanjara Supreme Court judges dissenting. Five, IBC had the requisite composition and quorum to undertake the verification process under Article 257.4. Ibrahim, Supreme Court Judge, dissenting. 7, the question raised regarding the interpretation of Article 257.10 of the Constitution on whether or not it requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. Joaquin Dongo, Supreme Court Judge, concurring. Each party shall bear their own cost, this being a public interest matter. Consequently, the consolidated appeal is determined as follows. The appeal is allowed on issue number 1. The appeal is allowed on issue number 4. The appeal is allowed on issue number 5. The appeal is allowed on issue number 6. The appeal is allowed on issue number 7. The appeal is disallowed on issue number 2. The appeal is disallowed on issue number 3. Those are the orders of the court. Ladies and gentlemen, thank you very much for your patience. We will seek your indulgence to perfect the final judgment. As you can see, we have so many pages to put together to come up with one judgment. Putting it together, it was very difficult because of the privacy involved and the logistics to put it together before delivery. We intend to do this and issue the judgment of the court on Tuesday next week. Today, we will issue a press summary of this judgment, which will come out shortly in about 1 hour. Thank you very much for your forbearance and for your cooperation. Is your mic on?
Thank you. I was saying, Madam President, Madam Deputy President, your Ladyship, my Lords, we take this opportunity on behalf of Council to thank you most sincerely for your very detailed decision on these very difficult and fundamental issues which have the effect on the future progress of constitutionalism in this country for many years to come. I think I talk on behalf of all council when I say they are very grateful for your patience, your industry, and the detailed means and effect by which this judgment has been delivered. I also take this opportunity to apologize on behalf of Solicitor General, who was here representing the AG, but had to leave because he is before another bench. Thank you, my ladies, my lords.
Thank you very much for those kind words. The court is now adjourned. Have a very nice afternoon, and God bless you.
Nyako Ramogi mana kamano endo ma en Ramogi TV kendo daher mondo mi anyisi ni en odiechieng' maduong' ahinya e piny Kenya ka otendore koda weche mag buche mag siasa kata buche motendore koda loko chike mag pacho ka ahinya to pend chike alunde mathur ka miluongo ni constitution kata katiba gi dhok machielo. Ma en odiechieng' moganda jo Kenya irito ahinya mar winjo ni to bura mar ywagruok kata mar ywagra manomaki e od yalo buche kata doho maduong' mogik ma pacho ka Supreme Court ne dhi chalo nade. Jogo ma osebedo ka winjo burano koro niendi e golo duoko margi. Kendo bende king'iyo burani kaka nomaki dwe mar achiel mar higani, okinde ne ochwalo paro mane gin godo e od yalo buche kata doho maduong' mogik e pacho ka Supreme Court. koro nochopo kama koro king'iyo tipo mari mar Ramogi TV odiochieng' masani ineno ka tipo dhi nyime kanyendo mabende yango malong'o ni bura no endo en bura ma odhi nyime kum thuolo mathoth ahinya chakre okinyi ma kawuono ka yango ni to gin jomage mane oboth kata gin jomage mane oyudo wach malong'o monjo bed ni dhi godo nyim jogo magin joyal buche e weche mag katiba kata timo lokruok ne chike mathurka. Chakro kinyi makawuono nyako Ramogi, weche osebedo kadhi nyime e doho maduong' mogik Supreme Court, kama jo ng'ad buche mopogore opogore manitiere e od yalo buche kata doho maduong' Supreme Court ogolo duoko mag weche manitiere. King'iyo kanyo nyako Ramogi ni wang' jowi mari mar Ramogi TV wantang'o ni moko kuom tipo manyiso kaka bura no endo chalo e od bura kata doho maduong' mogik pacho ka Supreme Court. Wadani mondo mwang'ia ne achiel kachiel ni to gin ang'o gini mowachore e bura ma kawuono ni endi. Ang'o gini mowachi ni ne otimore makare kinde mane idwaro mondo mi lokruok kalunde ne chike ma pacho ka ma iluongo ni constitutional amendment kokalo e paro mar BBI. To gin mage ma doho maduong' ni mogik oyudo ni ne nitiere both manotimie. Nyako Ramogi kinyalo paro chien ni doho ariyo mano doho mamalo kod doho mar winjo buche mag aywagra kata Court of Appeal ne owito paro mar timo lokruok kalunde ne chike mathurka miluongo ni constitutional amendment kokalo e ombulu mar paro kata dwaro mar mondo mi ne ni oganda jo Kenya no dhi ombulu mar paro kokalo e BBI. Kane wacho weche mane olieki gi doho ariyogo ni ne okoluore gi chike hie mathurka. Maendi nomiyo yawa mane ni kod dwaro mar dhi nyime koda paro mar loko chike mar BBI nomako bura koro e doho maduong' mogik thurka ma iluongo ni Supreme Court. Mane momiyo kawuono ni endi joyal buche nobedo piny mar koro nono kaka ne okinde mag kweth ma opogore opogore mane nitiere koda dwaro e bura no ne opedho neno margi gi nonro mane gin godo motelo ne ng'eto mar bura no odiochieng' ma kawuono. Nyako Ramogi weche nitiere mathoth ahinya kar kae nikech odiochieng' ma kawuono ni endi bende koro wadhi bedo gi wakili kata okil kamaloka Dr. Eric Komolo ma bende osedonjo e studio kar kae ndi wadawuoyo kode koro ni to fuonwa kong'injonwa matindo tindo weche ma owachi gi okinde kata mano owachi gokinde mano chwale nyim doho maduong' ma ogik e pacho ka Supreme Court to kora kaka joyal buche mag Supreme Court oyudo wachni. Koro ni endi wadani mondo mi wadhiane achiel kachiel mar ng'iyo ni to weche chalo nade. Kata kamano pod adaro mondo mi anyisi nyako Ramogi ni wadhi bedo gi twak mararie ahinya. Twak wadhi bedo gi mararie kendo maduong' ma pok nodwaro yudi mar mondo mi wafuon ni kendo wang'ijni gi dhowa nikech kiwinjo kuom thuolo malach jo ng'ad buche go wuoyo gi dho ngere ma samoro ne nyalo kalo ni. Mane momiyo wan koda wakili kata okil Dr. Eric Komolo kaendi nyako Ramogi mondo mi ofuonwa gi koro ng'injnwa gi matindo tindo e dhok ma in iwuon inyalo winjo. Ka wang'iyo kanyo nyako Ramogi en ni tipo pod dhi nyime kendo maendi e kaka duoko wacho ni nitiere kaka gwenyruok obedo e weche ma bende oket kanyo kod samoro paro mane ng'ato nyalo bedo godo ni doho maduong' mar piny Kenya maduong' mogik Supreme Court ne nyalo poko odok ne kweth mane siro lwedo dwaro mar loko chike yor alunde pacho ka kokalo e BBI. Kaluwore kod mano ni koro doho maduong' mogik e pacho ka ni bende koro chalo ka gimo siro kendo ong'ado ni dwaro ni endi mar loko chike mag piny Kenya kokalo yo machalo kod mar BBI ne ok oketie fuon kod aling'any makare mag chike kaka chike ma pacho ka ni dwaro. Mane momiyo wan ka kod wakili Dr. Eric Komolo. Nyako Ramogi kik idhi mabor mago mana tipo ma pod ineno manyisi kaka weche chalo od yalo buche maduong' mogik e pacho ka Supreme Court mar piny Kenya. Kendo nitiere bende jofwambo magwa mane odhi mondo mi ochwo wang'i kaka ing'ado bura e wi wach mar paro mar BBI no. Mano Walter Nyambaga kachiel kod Lydia Okeyo gin bende wabro winjo ni to gin korgi kono gi wacho nade e wi weche machalo gi mano. Ni mondo mi koro ni endi watudre ne gi jafwambo marwa Lydia Okeyo ma bende ochopo doho maduong' mogik e pacho ka Supreme Court bure Nairobi ka mondo mi owinjie gi ite ka bende obedo piny oluwo kaka wechegi kichalo achiel kachiel e nyim joyal buche ma bende ong'ado bura odiochieng' ma kawuono e wach mar paro mar chik mar BBI. Lydia, kopo ni winjowa to inyalo miyowa king'ado matindo tindo gima iwinjo kata mineno kaluwore koda kaka joyal buche mag doho maduong' mogik e pacho ka BBI ong'ado bura kotenore koda wach mar lipota mar BBI no endo. Lydia, Supreme Court ne chalo nade to ginang'o gini ma samoro ineno ma samoro noko otang'nwa e wang' jowi minyalo ng'iso nyikwa Ramogi Ajwang'?
George Batia winji e yo makare wabiro ni achiel kachiel koya e kar doho maduong' mano Supreme Court e bure Nairobi kaka mabende ne ntiere jong'ad bura abiriyo mane bende koro nigi noketi mondo miwa wach mogik kaluwore gi kes mar BBI bende notere doho. Parne burani okwongo to nong'ade kendo nowite oko e High Court mano doho mar High Court kata bang'e doho mar appeal bende nokawe ochako wite oko eka bang'e jogo mabende ne siro lwedo BBI nowuok achiel kachiel kendo ne gidhi koro gibire e Supreme Court ma bende en doho maduong' ma pacho ka to kendo kawuono waneno kane en duol mar jong'ad bura ne gin ji abiriyo. Kata kamano ne en achiel kachiel mane onge kata mana yweyo nikech ne giramo ni nyaka gimiwa duoko kawuono. Kata kamano George nyalo nyisi ni kaluwore gi weche ma bende owach kanyo chalo kagima ma en musmwal mogik makoro ogo e sanduk mar BBI nikech oyudo kane thoth jong'ad bura gi ne ok owinjore e weche bura ka bende kata mana mondo anyisi matin achiel kuom weche mane okelo nyim doho ne en ni inyal donjne mano jatend piny Kenya Uhuru Kenyatta nikech ne gitemo wacho kanyo ni en mano okelo wach BBI ka bende ne gitamore ma giwacho ni ok nyal donje. Moko kuom jong'ad buche gi ne wacho ni president owuon kata ma jatend piny Kenya owuon en nogolo mana paro eka bang'e kamoting'o Junet Mohamed mano kanyo mar ODM kanyakla kod Dennis Waweru mag joma nodhi ir jopiny mondo jopiny ogo kokgi e wechego mag BBI eka bang'e koro giwacho ni president kata jatend piny Kenya en no onge kanyo. Mano weche mabende nowach gi thoth jong'ad buchego mano odagi ni president ka jatend piny Kenya ok nyal ket wachne kanyo nikech en be ne onge nogolo mana paro kato kacha boedo ka jaje moko kata jong'ad buche moko bende ne owacho kacha ni kata kamano jatend piny Kenya en be en mana ja Kenya kendo en gi ratiro mar golo pache e weche mopogore opogore. Kato bende oyudo kanyo ne giwacho ni noko nitiere kuonde manoko manye pach jopiny mabiluongo ni public participation ne oko manye pach jopiny kaluwore gi wechego manyaka sani iyudo ka nitiere judges mane wacho kata jong'ad buche mane wacho ni nitiere kuonde ne giyie gi wach to moko bende nigi paro mopogore. Kata kamano oyudo ni jok mane otamore gi paro ni ne ng'eny moloyo jogo mane yie kode ka bende koro giwacho ni public participation ne onge ka bende ntiere jong'ad buche adek mano Judge Mwilu, Judge Ibrahim kod Judge Wanjala to notamore kendo wacho ni ok giyie gi wach ma kamano. Kapok wadhi mabor aneno ka Walter pod ni ka gi wendo mondo miang' nwamiye mang'eny bang'e to wawuo gi wendo mondi. Walter
erokamano Joy Lydia wabilo mana wach ka chiel kendo bendo yudo mathoth motende koda ng'eto mar bura nogo ma nyaka chop seche gendi bende osemana rumo en mani koro mana bilo wach gi moko kumo kinde manochwalo bura maket kod maniende kendo bende oseng'inge ma koro gikone ni to koro ng'ade kendo bende obiro mana bilo kode wach mondo wawinj ni to kor kakore kit ng'eto ni odhi kode nade to bende mor kode to kien owuon e yo mowinje godo motendo kod chik to kelo nade. Mokwongo arwaki ni machiegni ahinya e Ramogi TV biro mana ulo nyingi ne jopiny mondo mi koka ichak dhi nyime kod twak kodgi kachiel kachiel.
Erokamano nyinga Owuor Jerry. Yes, case ni newa represent the 10th respondent 254 Hope. Kaluwore gi ng'eto ma kawuono ma kotogolo ok anyal wacho ni wamor ahinya bo ok anyal wacho ni odhi kodwa marach ahinya ni kaluwore gi gik mane wa expect ni koto nego bed ni golo. But most importantly what I think now exists is that there is a definitive clarity with how a constitutional amendment process in the Republic of Kenya should be taking place. Ntie gik ma koto ng'ado ma okadwa wacho sani but okwayie godo completely, like issue mar ni nentiere public participation or involvement of the people. Chik kaendi, Kenya kaendi, nitie gimoro miluongo ni appellate litigation. Appellate litigation ka ing'ado bura e court mokwongo, mar ariyo kod mar adek. Court mar adek okonego bed ni delve into issues of facts. Public participation was a fact of was an issue of fact and not an issue of law. Jurisdiction mar court ni kaluwore gi petition mane petitioners keto, negi cite article 163.4a. Article 163.4a noero miyo court jurisdiction to hear appeals only with respect to interpretation of the constitution or application of the constitution, not issues of facts.
Yes. Nyadi mang'eny waneno ga ka ne gin jong'ad buche abiriyo. Tido ka adek wacho kama, ariyo wacho kama, achiel wacho kama endi. Ma to koro mondo mi japiny owinje. Gini oulang'o, ang'o miyo ne ok gibedo gi ng'eto machal gi te mana maket?
Ber ahinya, especially in common law jurisdictions, ka court is being presided over by judge mokadho achiel, ka judges go eko ng'ado buchgi kigin, ng'at ka ng'ato ng'ado buche kigin. Adhi miyi example mar case moro miwacho hoga manyeng e chien mawakili mar jurisdiction is everything. Judge manowacho gino ero niluongo ni Nyarangi, to kuma nowache or case manowache nen minority decision. Koro it's important ni mondo mano timre mondo o create a very rich jurisprudence across the entire issues that the court is facing for determination.
Kapokora wei mondo dhia en ni waneno kacha ka giwacho ni IEBC ne nigi kwan moromo mar tayo chenro mage, to kendo bende gichak gilieko ni chik oyie ne ng'ata mopone dwa donjore ne jatend piny matiyo gi sejo, kata ng'ata mantiere apisi mar jatend piny kopone dwa donjo ne e ketho moro amora kata ok otimo tije yono makare, to ok nyal tere e do mana machwing, to nyaka luwore apisi mar Attorney General. Ma weyowa kanye ponono nitiere ng'ato kaka osebedo ka yware gi jatend piny kaka e yore mag chwalo tije mage?
Court owacho kamano, but court bende ochako wach e issue mar swing the president noero ni inyalo elect chako case gi president ka president osewuok e office or whenever he sees holding the office of the presidency. But if feel needs so urgent, inyalo institute the case against the Attorney General kaki wacho noero, because the Attorney General is the principal legal advisor of the government. Yeah.
Iro kapano ageno ni temo manang'ingo nogo kakoro wawuok wadhi ang'e ni nyawadwa iluongo ni Lydia Okeyo bende nyalo bedo gi penjo kanyo. Lydia, ang'e ni ipenjori to koro wabro rito mondo mi jatend piny owuogi apisi koka chwal kwayo moro amora koponi en koda koso mado nyalo miyo toke ruodhi koponi en kod penjo nyakoro Mogajwang' wabilo mana wach ka kod kinde mago mane ochalo bura niende.
Kapok wawe wendowa modhi to nitiere wacho bende ne chando pach jopiny mane okinde dendo ni basic structure en gima wayudo ni okoyie ne gimondo mi gilok chike mapacho ka dangi ngingno go matindo tindo ni to ento ula.
Basic structure en gima iluongo ni doctrine ma is implied in constitutionalism to limit the exercise of amendment power by those people who are exercising direct or indirect sovereignty under Article 1, Sub-Article 1 and 2. The President, kaka koto wacho kaendi, cannot exercise both direct and indirect sovereignty. Basic structure wacho ni kintiere gik moko ma kidwa amend constitution nyaka obed mana amended gi jopiny, ok gi parliament or ok gi ng'ama exercise delegated power kaka president. Yeah.
Samoro bende ng'ato penjore ni to bang' ma koro ang'o madhi timore nikech oyudo ka mano chalo ka musmwal moro mogik makoro ochwade wi BBI nenore ni noseluar diriyo sani koro aneno ka kendo luar mar adek kendo ma ulang'o bende nitie gimunya timo koso un koro weya kaka en no nitie udhi dhi mbele gi wach burani kendo
an noka support BBI koro mara urumo gi kanyo
tiparo kaka okil de wawuondri ne in the other side be gin gi teko kata gi right mar ratiro mar do kende doho to ka gin go to gidhi kanyo
ka gin godo to onego bed ni gichako gini all afresh nikech koto wacho two very critical things. Number one, the President Emma was the promoter of this Constitutional Amendment Bill 2020. And for that reason, the court has declared it to be unconstitutional. So if at all there needs to be another constitutional amendment process under the emblem of or ambit of the BBI to a united Kenya as it was disguised, onego chakre manyien kal gi jopiny ema biro chako dondruok mar lokruok mar constitution.
Ng'ato be ang'eni sani penjre ni to ere kaka jopiny dwar ni mondo bi okel lokruok ka bende gigo kura ne senators ne MPs mondo dhi olos chike. Ere yo minyal ketgo jopiny mondo giwinj ne gin achiel kata gin part of the process nikech kwang'iyo chini kacha neno ka noter utese moko ne jopiny kendo ne gigoe kogno ne gigo sign. Bentie gima nyalo nyiso jopiny kokalo
kuom ang'o
kaka yo ma jopiny nyalo duogo na penji kacha ni neno kwa jigo kura kao senator tere od senate kao jo MPs tero kucho to legislation mane gimwacho ne gitimoga koro japiny samoro penjre ni to ere kaka gibo bedo involved kaka inyiso wa ni nyaka chake mana gi jopiny manyien e ka bang'e koro odonj manyien e do
jo ideally framers make a constitution mar 2010 no anticipate ni gini onego chakre gi jopiny. MPs and senators pod bro bedo gi role mar play because pod gin magidhi kalo ginieri od bunge yaka president deri. Yeah.
Kora moja ajonga neno ka Walter Osako chopo gi wendo ka winja nena wach magin.
Erokamano Lidi ngeni bila wach yote moyo nito ng'eto ni ochalo nade nyakora mogajwang kendo wayudo jogo mabende seche moko no chwalo kit gine ma kit bura makedo kod mind kendo kako ng'ade chalni odwa nindo nyakor gi koro maybe nyaka chop seche gi chalni chuny gi ntie kaka mor malich mokalo gi ng'eto makedo kod mane iluongo ni Paul Wanga no kil kamaloka man koda rang'enye ma malo inyalo mana yori gi kaendi mondo mi japichana yud tipo mari e yono mong'ith. Erokamano iwinjori nade gi chop nyaka chop seche gi kalo ni ng'eto ni endi chal ni odhi kodi maber ano kibwonjo mokalo
wamor to kendo wakuyo en decision ore bura kaka kaluwore kaka ong'ade nitie joma mor to nitie joma okuyo to joma notero kese do gi joma ne nie do ka gore ne kago kes kapingo kes duto te oyudo sehemu mar judgment ma ginyalo wacho ni ginyalo tero home. Ane upande ma wakilisha rais Uhuru Kenyatta weche ariyo kende manyalo wacho ni ne wadil go e court. Mokwongo en ka bende jatend piny inyalo tere doho. Mar ariyo bende jatend piny nigi teko kisheria mar chako okang' mar loko katiba. Mokwongo mar jatend piny ka binyalo tere doho koto yie kodwa ni kalore katiba ma wan go sani e okang' mare mar rang'iny 143 mano gima onge. Kot or sheria katiba masani o protect maber. Namba mar ariyo kes mar namba ariyo mana deal gi whether jatend piny nyalo chako okang' mar loko chik mano koto dagi teko no onge go ki katiba. Katiba oyiene ni ka gino osechak gi joma moko to en gi okange monyalo timo.
ma include keto koke e bill ma loko chik.
Erokamano, kano warango chenro makende manochake noyudo ka iluonge ni jok manochake ma dho liech luongo ni the initiator to gi promoters tere jok mane siro malich mokalo. Jatend piny no oketo thuolo makende mar kamiti moro miluongo ni task force. Doho wacho ni ne en achiel kuom ng'at mane timo tije ma chik oyiene to jo ng'ad wach bende wacho ni ne nitiere moko kuom jo ng'ad wach 3 ewi 7 wacho ni gima ket kamani ne en tok chik. Kaka in ng'ama nochung' ne jatend piny iwinjori nade?
Mano ne okang' mane ikonyo gi jatend piny ne office mar Attorney General, lakini do kaka iwinjono jo ng'ad wach ogwenyore e parono. Number 1 giwacho ni jatend piny nokonego bed ni chako gino. Documents magin mane nie court wacho ni jatend piny noyie koke gazette notice mano oketo go task force, BBI task force, steering task force. Lakini king'iyo mos tiyudo ni ji ariyo promoters ne gin Dennis Waweru to gi jaod bura Junet Mohamed. Kok jatend piny pod iyudo kanyo ni en mano chako to jogi nokawe ka koro sedeko. Mane momiyo gimi iluongo ni second schedule maloko mamedo constituencies, boundaries, giwacho ni mano ne ataro mar chik.
To koro chal kagima nyawadwa iluongo ni Okeyo Lydia mabende buonjo ka nigi penjo moro mabende gido chunye manyalo konyo japiny. Erokamano Lydia, dhi mbele kod wendo wa odiochieng' ma kawuono.
Naneno ka kacha kane wan e mbui, naneno ka jomoko nyisowa ni wanyisgi gima gini oula ahinya to igombo ni mondo giwinji. Dang' inyisa japiny ni ang'o mamiyo judges 7 kata jo ng'ad bura 7 mobedo under same court, under same roof, guarded by same laws. Ere gima miyo jogi bedo gi paro mopogore ahinya to e wach machal kod
iwacho ke sheria ni opinion ng'eny kaluwore gi namba mag okinde. Ka in gokinde 5, you can be sure ni in go opinion but kata paro 5 mopogore. Jo od bura 7 gondo, jo judges 7 mag Supreme Court ne ni under pressure bende. Achiel, each of them moro ka moro dwani mondo paro mare mogolo bendo nere ni en bende osomo kendo winjo case mano ong'ade burano. King'iyo mos nitie areas kata weche manotere mbele doho moko giriwore paro to koro kaka ng'ato arrive at paro mogikno ema umata, lakini paro judgment mogik kata bura makoro ng'adi mogik king'iyo mos tiyudo ni koro 5 kuom 7 oriwore paro. Nitie mana Justice Ibrahim mogwenyore kodgi paro. Then kuom issues 7 mane giwacho ni mondo court kata do kata lawyers mabende ne submit mondo ogole pachgi kata maoni margi giriwore paro margi. En mana ni koro kaka each of the judges ondiko pache ema koro samoro gigwenyore, but conclusion gima ge arrive at cha to more or less the same.
Bende wasana chien kacha kane wach mar duol mataw yiero mano IEBC ni temo wach ni gitin ahinya ma ok ginyal bedo ni ginyalo arrive at a conclusion. Dang' inyis wang'o nikech kwa ng'iyo wach IEBC na achiel kuom gigo mabende giwinjore duto olongo ni unanimous giwinjore gite. Koro inyiswa ni to ere kako bedo to yeno bende wasana no kan nitiere tungni moko mane jomoko paro kacha ni ne gitin gima ji 3 kende. Ere gima dang' inyiswa iwacho
king'iyo kanyo nitie gimilongo ni interpretation mar chik wan gi katiba ma ine chik the mother law chik maduong' mogik. Then buo katiba nitie chik molos gi parliament. Koro IBC nitie IBC Act. King'iyo act mar IBC, namba mar IBC commissioners moketo ng'eny mopogore gi namba mar parliament ma constitution oketo. Constitution marwa king'iyo idara mar article 150 wacho ni IBC a constitutional commission kaka IBC is quorate kata namba mare oromo ka gin commissioners moktin 3. Koro kane commissioners akina Kurgat gino resign, namba manodong' ne pod 3. Koro emomiyo koto wacho ni ok inyal go ataro mar katiba ni wacho ni chik ma parliament oloso nyalo override kas katiba ma piny kar kae. Koro emomiyo parliament agree oyie gi or rather do oyie gi IBC ni gimane kaka IBC currently constituted ni
e wang'e kabisa gi chik mar constitution.
Awinjo kanya waduchane nyisowa kanyo ni ponono ni ng'ato dwaro mondo BBI odhi mbele kendo nitie kaka nyaka gidhi ma gichaka fresh gi jopiny. Ere yore minyatigo gi jopiny? Udwa luongo gi baraza konde ere gik munyatiyogo mar manyo pachgi e wi loko pend chike ma pacho ka?
Number one, mokwongo chakre sani nyaka watim uchaguzi, thuolo koro chwok minyalo timgo gibiluongo ni amendment. Kata ko chake to ken gima dhi affect election mambele, mano gima chando jopiny kabisa, nikech nyaka time at least higa achiel kapok otim yiero mapacho ka. Namba ariyo, bura ma doho ng'ado, ma doho mamalo sani ong'ado, konyo korka laying out what I would call parameters mag timo changes. Kidwa tim lokruok ne katiba, koro wang'e ni jatend piny nyalo timo ang'o kata ok nyal timo ang'o. Kech kaka wan joma ne wakilisha samoro ne wacho ni nutame interfere gi ratiro mare mar chik kaka ng'ama bende a citizen of Kenya. Kori no, en a citizen but chik ok oyiene mondo mi otim kaka notimono. To nitie role moko onyalo play. In fact, ka jomoko chako, onyalo kata support, onyalo kata campaign for. Koro a private citizen nyalo come up with a bill, I promote what kimene Johnny Waweru gini kata Honorable Junet Mohammed gini winjo ka wacho no. Initiate gimilongo ni public participation. Inyalo dhi e county government assembly kande mondo ikon gini mae gimo wa propose wadware kama kaka ne ng'ame wakili moro maniluongo ni Ikuru Aukot otemo imano fail cha Third Way Alliance. Kamano.
Mogik mondo hawe idhi aneno ka sa betrach. Ineno ka wach IBC gi duto kendo ne ntiere kacha gi nyabathe moro mane nyiso ni nyal losa kuonde chung od bura mano constituency Praberia. Lerno kanyo matin.
Mano king'iyo giba achiel kuom bura madong ng'ado kabisa ne en second schedule to the amendment bill mane gidwa loko godo boundaries. King'iyo onego beni mano ne di chenjo ibara mar chik article 89 mar chik marwa to ne process no kodhi e wang'e. Koro ne gi propose ni gidwa gine to kalore kaka doho amua nyaka bill no sik nyaka gine mondo olok chik mar katiba article 89 te kaka no chake ni ok odonjo. Koro mimi wacho ni no second schedule of the bill to the BBI null and as unconstitutional. Kamano.
Kamano ahinya. Nyakora Mugajuang mano pod wan mana Supreme Court kaka mabende wamedo mana winjo duonda kata paro mar jogo mabende iwacho ni no bedo kanyo jogo mano bede e kombego kama ni igole paro mopogre mabende no kelo ng'eto mar burano mar chikno mar BBI. Nyakora Mugajuang neno ka wan gi wendo machielo ang'no nyiso nyinge kendo
I have to speak in law.
Okay. You don't understand law?
A little bit of it.
Okay, please tell us about your take on the party.
My name is Miracle Mudei. I'm a third-year law student at the University of Nairobi, that is School of Law. And my take on the Supreme Court's BBI judgment today is that, so to say, the judgment in totality or in whole is good. Then to the common man or to the mwananchi, to the Wanjiku who does not understand the law, it's a tough one for them. Because when we put it on a scale, it is seemingly confusing. So most people are saying we've buried reggae, we've ended that political process that was dinted and filled with malice. But then from the Supreme Court's assertions and from the Supreme Court's holding, based on when the Supreme Court held out that the basic structure doctrine is not applicable in Kenya, I think they're leading us into some sort of legal lacuna in which a person can wake up tomorrow, follow the right procedure, but then dismember the whole constitution. So that's my take.
So you feel the law is now protected?
Not at all. I will not say it is. When they overruled the High Court decision and the Court of Appeal decision on the place of the basic structure in the Kenyan jurisdiction, I think they went overboard, and it does not expressly offer protection. Yes. Thank you.
Walter neno ka bendi chopo ka kendo chal ni gi wendo machielo uchoru mana gi ka mondo wayudo kang maber mwanyalo kawe picha maler. Walter.
Yes. Lydia, ingeni koro wadhi e kizungu, at least nyikora mogi en ni koro wayudo jok ma seche moko ok nyal winjo dhok ni to gibiro ng'ingonwa kit kaka ng'eto maket kod mani chalo. An ka kod okil Kamaloka Ndegwa Muhoro. Thank you very much, and please welcome. You can be somewhere right here. At least now my cameraman can get the senior counsel.
And then thank you for even bringing me close to Nyako.
Okay, thank you. You're welcome close to Nyako. In a summarized way,
yes.
What does this verdict mean to the appellant court? I understand you are representing the appellant court.
Yes, yes.
Okay.
What this judgment means is that it has found the judges of the High Court and the judges of the Court of Appeal to have done a fundamental error of law in saying that the Constitution is not amendable, in saying that there are some sacred and some eternity clauses in the Constitution. That has been declared, that has been overruled. It then means that the Constitution of the Republic of Kenya is amendable anytime that there is no clause or there is no provision of the Constitution that is protected from amendment. That is one achievement, in the sense that if today people feel that they do not want the Parliament of the Republic of Kenya, they can go and abolish it, as long as you follow through the process of the referendum. They've also said that you can, you do not have to follow the basic structure. And people don't understand what this basic structure is all about. The basic structure is the rigidity to amend the Constitution. That rigidity has been declared to be a nullity, that the same does not apply in this republic, and therefore there is no rigid provision of the Constitution, and therefore the Constitution of the Kenya can be amended so as to suit the circumstances of the times. For example, if people feel that they need the leader of opposition in the parliament, it can be created currently now. The other issue that is a big achievement is that we have been told that the bill followed through the entire process, but only faulted in the sense that the president was involved in the handshake and that he is the one who initiated the process.
Okay.
What that means, the content of the bill has not been challenged. What has been challenged is how it was initiated. What that means then, it is anybody, Kamau, Joroge or Tieno, can take that bill and follow through the process of the IBC to the county assembly to parliament, and then to a referendum.
Thank you very much. Now, if I feel like I will need also to involve myself or change the Constitution,
yes.
In summary, what would be the legal means that might not lead to seeing the same happening here in Supreme Court?
Sorry?
When we want to change the Constitution, what is the legal means and the most appropriate one to follow? Yeah.
The most appropriate one is making sure that you have done public participation. Is making sure that if the bill involves the sacred clauses, like it affects the sovereignty of the people, it affects independent institutions, it affects the Bill of Rights, it has to go for a referendum. That's the process. But don't you forget that currently with the bill the way it is, even parliamentary initiative can be triggered to ensure that the process go to a referendum. So that bill can still be passed by parliament. So a member of parliament can take, Junet can take that bill, take it to parliament and use the parliamentary initiative process. Yeah.
Okay, thank you very much. Before you leave, like you mentioned that you are close to Jaber,
yes.
She might be having some questions that might be very interesting. Ero kamano Lydia mana machigni kendo.
Ero kamano nya Walter, Walter kanyo ne miwa mana matin. Just before you go.
Yes.
Public participation.
Yes.
It's an issue that really needs to be understood.
Yes.
You've told us the way we can just have one of your colleagues actually talked about having a baraza kind of thing.
Yes.
What do you say about that?
Well, public participation, as the courts have said, that Parliament has not legislated on how public participation is to be initiated or how it is to be conducted, and therefore it is left to the person initiating the bill to decide which mechanism and which mode of public participation should you use. The court has said you can go to a public rally, you can go to a baraza, you can go to a church, to a mosque, whatever you want to be, as long as it is done.
Thanks so much.
As long as you involve them.
Appreciate. Ero kamana nyanya kura mag jongwa biro na chiel kachiel ko ya Supreme Court ma Nairobi kendo mano e makoro koro duto mane wan go ka kokalo kuom wach mogik mabende koro wachi kokalo kuom BBI ka bende giwacho kanyo ni ma en musmwal mogik kendo wach BBI ko lor chodho kata kamano pod nitiere geno nikech pod wawinjo kacha koya kuom okinde ni pod inyal duoge kendo kokalo kuom gino mabende gideno ni public participation kata rwako ganda nyoko kanyakla mondo giketie pachgi. But
Erokamano Nyalidio Keyo kaachiel koda Walter Nyambaga achiel kachiel kowuok e doho maduong' mogik mapacho ka Supreme Court kama bende chakro kinyi usebedo ka uluwe wach mar bura mane omaki kotenore koda dwaro kata paro mar loko chike pacho ka kitimo lokruok makama nalunde kokalo dwaro mar BBI. Nyakora Mogi wantiere koda wendo bende ma en wakili kata okil Kamaloka Kisumu e studio marwa ma Kisumu wan koda Green Odera ma bende wadani mondo mwawinji ane kore matin kapod ok wabiro kuom Dr. Eric Omolo ma bende wan godo e studio karkaini. Nyakora Mogi wadhi nyaka e studio wa ma Kisumu kama wadani mondo mwawinji ni to okil Kamaloka Green Odera to ni kod paro mane kaluwore koda ng'eto makawuono kata weche mogol koda joyal buche mag doho maduong' mogik mapacho ka Supreme Court joyal buche maromo 7 ma bende nyocha ne onkawo kenge manoketi e nyimgi koda okinde mopogore opogore seche manoter burano e nyim od yalo buche kata doho maduong' mogik mapacho ka Supreme Court dwe mar achiel mar higa ni kama ne gikete wechegi mane giparo ni nyalo miyo burani kata burano chop kama ochope kawuono kata mondo mi lokruok obede kaluwore koda buche manoseng'adi gi doho mamoko ariyo ma okalo. Nyakora Mogi wawinjane ni to Green Odera wacho nang'o. Okil Green Odera koro ni en thuolo mari ka intiere studio marwa ma Kisumu mondo mi imbe ni nyise Nyakora Mogi ni into ng'eto mar burani yo machalo kod maendi okawo gibuok koseno ka giluwore koda ling'any duto mag chike madwarore kotendo koda lokruok mitimo ne katiba kata chike mag piny Kenya.
Erokamano ahinya kuom rwaka e studio odhiambo ma kawuono. Wach ni en wach mane wachako twakne kawuono gokinyi kane wan gi Sharon. Kendo en wach mwasebedo kwawacho wik mangima kochakre tich ariyo kane waromo gi Cleophas okinyi mar tich ariyo. To kapok adonjo e judgment mar Supreme Court kaka owuok, asebedo kawacho ni jowinjowa kuom ndalo ariyo masebiro e studio kae ni judgment madhi wuok e Supreme Court e wach BBI ni dhi bedo judgment ma balanced. Nitiere weche 7 manotere Supreme Court gi jok mano appeal judgment mar Court of Appeal nyaka kwa High Court nyaka Court of Appeal. Ne gitero weche 7 mondo court maduong' mogik ong'adnwa bura e weche 7 gi. Wach mokwongo ne en ni dibed ni basic structure doctrine. Alo, iwinja? Iwinja?
Maber kabisa wakili, dhiadhi nyime wan kodi.
Awacho ne nitiere weche 7 mane otere court kaka appeal mane Supreme Court noripo ng'adnwa e bura kaka giseng'ado ni. Kuom weche 7 gi ne en mokwongo niya be basic structure principle mar basic structure doctrine bedo applicable in Kenya. Koro gima jowinjowa nyaka kuong ng'eyo kapok wang'eyo kaka Supreme Court odwoko wachno. Basic structure doctrine wacho ni nitiere vipengele moko mantiere e constitution ma ok oyie ng'ata mondo lok. To twak mwasebedo kwawachogo ni kwang'iyo article 256 gi 257 mar Constitution of Kenya, Constitution nolosonwa room moro mwanyalo loko go sheria, mwanyalo amend go Constitution marwa. Koro kane wadhi e High Court, High Court ong'ado bura ni principle mar basic structure doctrine apply, ma Court of Appeal bodhi bonwoyo ni principle no apply e Constitution marwa mar Kenya. Effect mare ne en ni loko katiba e Kenya kae ne dhi bedo matek kabisa. To sani waneno ka wachno notere Supreme Court mar Kenya ma judges mang'eny mogik ong'ado no principle mar doctrine mar basic structure ok apply e Constitution mar Kenya. To giduto ne gigolo paro mopogore opogore gimomiyo doctrine no ok apply e Constitution mar Kenya. Paro mokwongo ne en ni principle ni pok ochopo level mamalo mogik mokawe kaka international law momiyo ok onyal bedo applied e constitution marwa mar Kenya. Koro kwang'iyo e judgment mar Supreme Court kawuono, waneno mano gima court oyie gi jok ma no appeal kuome, giyie gi jok promoters mar BBI ni principle or doctrine mar basic structure mane jok mane pingo BBI wacho no apply in Kenya cha, court oyie gi promoters mag BBI na principle no ok apply. Gimar ariyo mane otere e Supreme Court ne en whether President Uhuru Kenyatta ne nyalo bedo a promoter mar amendment of the constitution kitiyo gi public initiative. King'iyo Article 256 gi Article 257 of the Constitution of Kenya, nomiwa yore ariyo mar amending the constitution. Yore gin, wanyalo amend constitution kwa dhi e bunge, kata wanyalo amend constitution kwa watero wach mwadwaro amend ni embele ji mondo ji ogone kura ki referendum. To go kura ki referendum king'iyo Article 256 ne giwacho no mondo kura no dhi e referendum nyaka obedie gi promoter. Koro court ma Supreme Court oyie gi jok mane pingo BBI ni number 1, President Uhuru Kenyatta emane en promoter mar BBI, to koyiene kisheria mondo obed promoter mar BBI. Koro kanyo e kuma jok ma support BBI okuongo lwarie. Mar adek ne en penjo mar duoko penjo mar niya, bende public participation notimre e yo makare. To wachni kane wagoye mbaka gokinyi ne wawacho ni public participation mar BBI notimre tieng' diriyo. Tieng' mokwongo ne en bill ni nokaw oter ni ji ma ji owinjo wach gi ba ji ogo nyaka sei margi. Kendo the other level of tieng' mar ariyo mar public participation nen indirect. Indirect ni nokawe motere county assemblies, ma county assemblies mathoth mang'eny okale, kowuok e county assemblies kendo odhi nyaka e National Assembly, National Assembly be nokale modhi nyaka Senate. Bang' Senate kae emane jok mane ok pingo BBI noringo bodhie e court mondo otem chungo process mar BBI. To waneno ka Supreme Court kawuono yie ni public participation notimre e yo makare, omiyo there was public participation. Number 4 ne en issue mar be ker mar Kenya inyalo donjne seche ma pod en ker, inyalo donjne e court, inyalo tere e court seche ma en court. Waneno ka High Court gi Court of Appeal nowacho ni nitiere room moro mane inyalo donjne go ker ka pod en ker. To waneno ka Supreme Court kawuono ka winjo burano, Supreme Court ong'ado wach ni ker ok nyal donjne seche ma pod en ker ka terms ge pok orumo. To reasoning mar Supreme Court wacho niya, constitution marwa omede immunity mar donjone seche ma jok ma promoters mag BBI okalo go e Supreme Court. Kendo kwa dhi e wach mar ang'wen ama mar abich ne en wach constituencies mane idwa med, constituencies 70 mane idwa med mane omed e bill mar BBI. To waneno kakanyo ema kendo okelo shida ni jok mane support BBI, nikech court owacho ni the way mane constituencies 70 go med, court ofwenyo number 1 there was no public participation with that aspect mar 70 constituencies, no, there was no proper public participation mokalo oko. Ka ng'ado yo machiwok mondo kika kaw sa mang'eny en ni kuom weche 7 manoter e doho mar Supreme Court, jok mane support BBI okalo e weche 5, to jok mane pingo BBI okalo e weche ariyo. Gimomiyo pod wacho ni BBI olwar en nikech wach ma important, question ma important mane court nodwoko was in favor of jok mapingo BBI. To nen question ni ng'ano manyalo chako constitution, amending constitution marwa through Article 257. To waneno ka Supreme Court odwoko ni president ma en ker ok nyal chako amending the constitution through a popular initiative under Article 257. To ka Supreme Court oseng'ado bura no kamano, mano maanisha ni gimora mora manotim BBI, kata ka public participation was right, kata ka basic structure is not applicable, gimora mora manotim BBI koro bedo marach, nikech giwacho ni president no bedo promoter mar BBI to no koripo bed promoter mar BBI. Erokamano.
Erokamano ahinya okil Kamaloka Green Odera kuom miyowa maler kuom gigo ma bende itemo lieko ne nyikwa Ramogi Jwang kendo itemo fuono ne giyo makare gima omiyo koro BBI ne nyaka go mana break gi kanyo endo kendo nyaka koro lwar mana gi kanyo. Kata kamano weche miwacho gin mago ma bende gora til piny kotende koda weche mag neno ni oganda jo Kenya ahinya to nyikwa Ramogi Jwang obedo gi ng'eyo ewi gik ma omiyo koro chuno mondo mi jo ng'ad buche e doho maduong' mogik Supreme Court ong'ado mondo mi koro BBI kik yie ni winjo bed ni tiyo godo kaka en no gi sani. E studio kar kanya kwa Ramogi wan koda okil Kamaloka. Okil Kamaloka ma wan godo ka iluongo ni Dr. Eric Komolo. Eric Komolo en okil Kamaloka ma bende okwasebedo kode ka kuom thuolo mokwongo but wasebedo kode kaendi moingo nyadichiel. Ka bende osebedo kofuononwa weche motendo koda chike ma samoro nyalo miyo ng'ato bedo gi toni to koro ma otim nikech ang'o. Gini olwar te koso nitiere mana kidienje moko molwar. Odwa ni mondo minyiswa ni koro sani kama piny Kenya ogike ka koro wadong' mana gi dweche mikwano to ji dhi e yiero. Maendi nyalo miyo paka mar siasa nyalo ringa chocha koso yamo nyalo loko e alap mar siasa kar kanya. Kwa Ramogi wadani mondo wawuok koda okil Kamaloka Eric Komolo e odhiambo ne mondo mi omiwa ne ler. Okili kuongi kaw thuolo mar moso nyikwa Ramogi Jwang.
Erokamano ahinya amor wuoyo gi jodalawa sana odiochieng' ma muhimu kama ma weche BBI koro orumo e Supreme Court. Ageno ni jowa follow, amba temo follow and kaka jok moko sewacho nitiere jok ma oyombo kuonde moko, nitiere jok moko oyombo kuonde moko, mano normal e court. Koro anoka ne gima miyo ng'ato nego celebrate ni BBI olwar kata ng'ato ne ni BBI okalo. Mana kaka nyienche wacho nitie gik ma judges owacho ma king'iyo maber to ulono nego bedni wan wajoma support BBI wapar diriyo going forward. But aparo ni nitiere gik ma nitie BBI ma pod nyaka wawachi ni pod nyaka water mbele.
Okil ng'ato nyalo wacho dhok moro kaendi ma bende owachi ni ka ing'ado burani to wach ni the process kata dwaro mar timo lokruok ne pend chike ma pacho kae kitimo gi alwone biluongo ni BBI is unconstitutional. Maendi nyiso ni gini orach koso nyiso ni ok oluwore gi chik.
Unconstitutional matiende ni nitie chik moketi to chik ne mana ok oluwo. Nitie gik abeyo BBI ma ka ok noter gi kendgi moko riw gi process mane president otiyogo to ne dhi kala. Koro unconstitutional ok oluwo ni gigo richo. Ok oluwo ni BBI bill ne rach. Oluwo mana ni samoro ne warokni. Ne okwang luwe kaka chik no wacho sana chik minuang'o fuond katiba ma chakore 255 255 nyaka 257. Yes, kuro BBI okrach procedure ma noluwo marach.
Gimoro bende wuoye kaendi ma jowa awinjo ka Green Odera olieke studio maro ma Kisumo. Basic structure doctrine. Gin fuonni kata siro moko chike marito piny kata marito gana miluongo ni katiba ne ma samoro ko winjo bed ni ndeko kiyengi. Maendi nyiso nang'o gin chike mage ma ok nyal mul kitimo lokruok ne chike mag piny kata chik moro amora kaluwore gi katiba mar piny Kenya.
Ji mang'eny ok winji gima basic structure doctrine oulo. Basic structure doctrine oulo ni piny ka piny nigi history mare. Kenya ne nigi history manomiyo waloko katiba ma 2010.
Uganda bende gi history mare ma president gin go karibu higni 30 gi wiye sani. Tanzania be thagore gi multipartyism. Koro Tanzania ncho lando ni bang election ma 2025 gidhi loko katiba. Koro basic structure en yande history mar Kenya. Ang'o miyo ne waloko katiba to already ne wan katiba. Matiende nitie gik ne richo. And gigwero ka okunego bed ni wabed gi process inyalo lok gi dio ne executive ne too powerful doctrine mass separation of powers ne onge devolution ne onge pesa ni tiyo go Nairobi ka endi te weche ratiro mar dhano ing'eyo kaka ji samoro kaka jakom ing'e no maki without trial ligni mang'eny donge ji mang'eny nitie kata jok mane nego mas kata sani wakia kuma nitiere koro gigi ema ne wawacho ni kopo ne wakelo katiba to gigi are so important and Kenya ne wadefine na sovereign republic koro gigi gin so important ma kopo ne walokogi to nyaka ihusisha ji te nyaka kel ji te kanyakla machak wuo
koro gin ang'o gini
koro egino kinya define gi egino kinya wacho ni ABCD basic structure lakini kidhie ber katiba ni wani ende kidhie chapter 16 to nitiere gik mo list kanyo manyaka nyaka tim referendum gik machalo independence of the judiciary ke jakango kuro gi chal kama inyalo wacho ni gin part mar basic structure mar Kenya magin kigolo gi nyaka tim process ma elaborate one process no nyati me ng'at ma ne telo machalo ker president ma gin gi wacho kanyo ni president ok nyal initiate popular initiative and then judges make high court gi court of appeal to no wacho ni ok en na referendum kende mokuongo nyaka puonj ji nyaka kel ji kanyakle constituent college magi wuo then nyaka ket bill then nyaka bill ni the referendum and procedure ni nyaka bed very elaborate koro basic structure mar Kenya exists nitiere jok mawacho kata judges mokaneno ka kata justice Mohamed Ibrahim moyie ni entie wacho ni entie to entiere chapter 16 to nitiere joma wacho ni machalo justice Odunga gini ni entiere to entiere chapter 16 but also on a case by case basis nikech katiba ni endie na living document koro nitiere kuonde moko ma samoro devolution on nitiere chapter 16 lakini kidwa scrap ma Bay County kuma ae to nyaka i consult wadonge koro nitiere gik ang'eny but ok wach ni kinya medo counties lakini ok nya scrap koro judges moko wacho ni entiere chapter 16 to nyaka wamede gi gik moko koro basic structure jok kipachan kaka okil Kamala kama bende osepuonjo nyithindo balariany kipacha Kenya nigi history and history nende wanya tiyo gi tam mora mora basic structure kata an amendable classes or whatever but gima important ni tiyo gik moko nyalo kaloko yuma an ng'eny gigo ne onge BBI yes in fact ana paro ni gimoro mane nitie BBI minya wacho ni donje basic structure en gima ne gikelo mar ombudsman gi nene judiciary modong ne gin ordinary amendments kipacha
okay nyakora mogi maendi Dr. Eric Komolo okil Kamaloka kendo bende japuonja mag weche chike mbalariany kendo wan kore kaendi mondo mi ofuonwa madito ma uwinj kowachi gi ute mag yalo bura maduong' mogik e pacho ka Supreme Court odiochieng' ma kawuono wang'iyane kama piny Kenya oseaye chakre nowuoge samo ket chik matiyo wasani higa 2010 gima pod piny Kenya manyo en riwo Uganda kanyakla kendo ni Uganda obedo gi kwe gachiel mar paro dwaro kachiel kod dongruok marwa ng'eto mar burani e weche mag riwo Uganda jo Kenya gi keto Uganda jo Kenya bed gimoro achiel ineno ka onyalo kelo wach mane kinde mabende koro siasa obede kingi kaka nobiro nyaka kama koro chopeni nitiere kaka pogruok nobete kindi jok masiro gi jok makwede ing'iyo kama oketo wakanyi
Supreme Court otime achiel kuom gima ber mogik gi delay decision mar BBI ni nyaka koro kodong karibu dweche 3-4 to wadhi e yiero dine giamua gini ndika dwe mar 10 mokalo to ne wanyalo bedo gi scenario mane wabedo go higa 2005 nyaka 2007 mane dalone mane ODM walose ndalo ne ane university nikech ne process mar referendum chande no polarize piny kabisa sani endi koro en too late mokuongo nikech giwacho ni president ne obedo involved in process ni koro en constitution ok nyadhi mbele koro BBI orumo koro focus agenda mar orumo at least for now focus agenda mar Jakom bedo president, focus ni Kenya Kwanza gin agenda mane iwinjo, kuro focus policies. Kuro an kaka nene en omayo joma ne dwa ketho, dwa tiyo gi nying BBI marach, omayo gi muya mondo kuro wa audit gi nikech ngene gima ng'ato ka donjo sirkal gima important en ni structure mantiere mar katiba mar president, parliament and senate gi joge mago idhi tiyo go nade to implement policies gi. Jakom for example wacho ni achiel kuom policies ge en kelo pesa mar 6,000 mondo kele mier ka mier niende. Wa focus e mano sani.
Wakili, adwa ni mondo igo mana break gi kanyo. Pod wan kodi kaendi. Kikidhi kata kikibere gi paro mar weyo nyikwa Ramogi nikech gin gima thoth ahinya magiri dwaro mondo giwinj koa kuomi. Omiyo wakwayi ni wahore mana matin. Wayudo weche manyien. Kasto bang'e no to waduogo kodi mondo mi nyiswa mana matin moko kuom manitie. Ahinya kotendo koda riwo oganda jo Kenya. Kaachiel koda bende neno ni oganda jo Kenya ong'eyo gik ma ong'adi e bura ma kawuono niende. Koting'o wach mar ni to en karang'o ma koro jatend piny Kenya kata jatend piny weyo bedo e apisi kata konyalo timo gimoro kaka ja Kenya ma ok onywanda apisi ma entiere no ire. Magi mana kwaseyudo weche go manyien ma bende biro ni nyakwa Ramogi. Gin weche ma bende dito kendo wang'yo thuok gi ka wakolo gi wasuso gi nyakwa Ramogi kendo waketo negi achana koda okil Kamaloka Dr. Eric Komolo. Kikidhi mabor wakawiyo machuoko boduo koda mathoth ahinya.
When it comes to school movies, School Flicks is a big time. Get a taste of local drama. Stick to the story, sir. Thrillers.
If you don't repent, it will rain fire.
And experience raw talent from schools around Kenya. Embrace Kenyan. Watch Kenyan.
I saw someone who looked like me.
School Flicks on View Sasa.
Kitume mawakelonu otenore en dhadho maggi. Kawa kiko gi makare. Yud thumbe miero mapacho ka.
Weka mzuka umepanda twende paka chini.
Kod pinje maoko.
Baby feel my command like zombie.
E chenro mag Tiedero. Ngoma uwake.
Kimwaga pesa nitaleveza.
Tum Dagmor. Ramogi Night. Magite mana Ramogi TV. Teacher Beach. Yud thuolo mar neno gi ng'eyo jathumiero Odongo Swag biro bedo kodwa achiel kachiel kwariure gi Stella Brenda, Lynn Ramogi to kod DJ Kolo e chenro mar Bak Ndalo mana Ramogi TV. Kik bai.
Duok piny sukari ma itiyogo kod gigo motimo sukari mang'eny kaka peremende kod math motimo sukari mang'eny.